All right, are we live? All right, well, welcome public to day one of the Joint Judiciary Committee, and welcome committee. Some of you, this is for most of you, it might be on the House side, your first joint meeting of the interim. All right, very good. We'll try not to disappoint you. We'll make sure it's very entertaining. All right, with that, go ahead and call the roll.
Entertaining.
Mr. Chairman, this is for Joint Judiciary for May 19th. Senator Crago? Here. Senator Crum?
Here.
Senator Hicks?
Here.
Senator Kolb?
Present.
Representative Brady?
Here.
Representative Bratton?
Here.
Representative Chestick? Representative Filer? Representative Kelly?
Here.
Representative Lean?
Here.
Representative Singh?
Here.
Representative Webb?
Here.
Co-Chairman Washit? Chairman Olson?
Here.
All are present, Mr. Chairman.
All right, thank you for that. Co-Chairman Washit, do you have any opening remarks before we get started here?
Thank you, Mr. Chairman. It's always good to be back and kind of cozy up here. This is a little tighter confines than we're accustomed to, but we've got important topics. Some of them are controversial, some of them are not, but they're all important and they're important to somebody. And we're going to do our best to move through the agenda and address all these important topics while we're here. And glad everybody made it.
All right, and just for the committee, this evening there will be a barbecue at Senator Sherry Steinmetz's house. I don't have the address, but this evening there will be a barbecue at Senator Sherry Steinmetz's house. We're definitely going to have to fix that.
Echo in this one.
Well, that's good. All right. I will get you an address for that, but I guess the timing will just be when we finish up here and finish up our tour at the prison, but and staff are welcome as well to that. So just plan on that. We'll go ahead and move into our first order of business, which is the adoption of our interim committee rules. Oh, no, we already did roll call. Yeah,
we did.
were you here?
No,
Do you have Chairman Washer that's marked here? Okay,
Yeah, okay.
all right.
Sure.
Okay.
Mr. Chairman,
Yes,
we're going to
please.
review rules.
We are looking at our rules now. Yes.
Okay, and we had two packets from LSO and packets 1 and 2, and I moved the interim rule packet number 1 as committee rules. That excludes except to sponsor legislation which shall require a majority vote of the quorum of members of each house then present.
Are you
Which is-
amending you're just saying what the
No,
rule says? You're not.
That's what the
amending
rule says. So I'm just saying that's considered packet 2, and I move to
Option
accept-
number 1,
Yep.
we'll call it.
yes.
Okay.
Okay.
It's been
Thank you.
moved. Is there a second? It's been seconded by Representative Lean. Representative Brady with the motion. Any discussion on this motion? Senator Kolb.
Thank you, Mr. Chairman. Yeah, I don't believe the packet number 1 is the way to go because the issue's always been when we have a difference between the House and Senate and the majority of votes wasn't support. We didn't support it both House and Senate side for an interim topic. Then when it gets into our respective bodies, it can fail. It has a high probability of failing if we don't get everybody to buy in on it and to agree that this is a good bill draft to present. So I think it's always better, in my experience over the years, is that we have buy-in, and that's important. I don't want to waste money, the state's money, on an interim topic that goes nowhere on a bill draft. So I'm not in support of packet number 1. I'm in support of packet number 2. So I'm voting against packet number 1 adoption. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Senator Hicks.
Yeah, Mr. Chairman, not packet 1 or packet 2, but specifically on the issue of, and so this is just a practical application. when we have a majority of both bodies, and I think this is what Senator Kolb was trying to articulate. So if we pass legislation out as a committee, as a majority of the committee, but it doesn't have a majority of one body, this is the exact same committee that's going to hear the bills when they get back in session. And it's dead. And so effectively what we've done as a committee, we spent a lot of time working on a piece of legislation, gets introduced, and then it never makes it out of one house. Now that's the byproduct of that is not only do we spend a lot of time working on legislation, the staff spends a lot of time working on the legislation, and people from around the state of Wyoming, agencies, individuals that are affected by that legislation travel all over the state to come when we effectively know that the committee, that there's one house that when it gets to Cheyenne, the bill's introduced is already failed. I think that's a disservice to the public. Now, contrary to that, when you go through an election cycle, I believe it should be a majority of the committee, because the committee is just like we have here, that every single face is different than it was a year ago. And so consequently, I think it alternates back and forth. But right now, we're the same people that are going to hear these exact same people that are going to hear these bills. And if you can't get it out of this committee now with the majority of both sides, it's effectively not going to make it into the session. So one body works that bill and it comes over to the other side. We waste a lot of time, folks, and not just ours, but the people of the state of Wyoming. And personally, I think that's a disservice. That's just my perspective. I haven't done this for a while. And I think it just bodes well of the committee to make sure that we serve the public. So I would concur with Senator Kolb on this, that it should be a majority of both houses.
Representative Lean.
Thank you, Mr. Chairman. I would argue that there is an education value to be heard, and then between the interim committee and session, there is an opportunity for education to happen, and that we have the opportunity for the public to then have a say, excuse me, and that over time, there is an opportunity for people to learn that there's a need for a piece of legislation. And so while it may not happen today or tomorrow, because our committee days are very limited and time is precious, we may have an opportunity between now and session in February to be able to talk to those senators or those House of Representatives, whichever side it would be that doesn't want to hear it, to know that the education value is there and that it potentially could live on and serve the people of Wyoming.
All right, any other discussion on this motion? Sensing you are, oh, no. Representative Bratton.
Thank you, Mr. Chairman. So 3 people out of 14 would, if we adopt the second rules, then 3 people out of 14 get veto power. And that's kind of a service to the public, not having that additional time to where things might change and we can discuss that bill.
Any other discussion?
Mr. Chairman, so 2 points. On the education side, everything we do is education, and we can still the methodology that I found to be most effective to do that is that's to work with the committee members to bring these bills back as individual bills. You still have every opportunity to get before the committee that way. Keep in mind, we're going into a budget session, so it's going to take 2/3 majority vote to make introduction. It's a different world when we have to do that, to get to that 2/3 bar. And if you can't even get the majority of both houses, it's just, we're not going to get much done. The way to do that is back through an individual bill, working with members of the committee and try to get as many folks on there as possible. So it's not so much that they control veto power. It's just to say, look, this hasn't risen to the level that we're going to be able to get this through both chambers. And so it's about time and efficiency, but every individual on this committee has an opportunity to bring a bill and get as many members of this committee to sign on to it as possible. That way this has a higher probability of getting through the session. And you don't run into that issue that it's just, and when we say 3, that's a reference to the Senate because there's only 5 of us. So you still have to get it through the Senate. That's my point.
Representative Singh.
Thank you, Mr. Chairman, and good morning, Mr. Chairman. I'm gonna throw my hat in the ring, 2 cents here. I would argue in favor of the first packet. And just regarding any work that we're gonna be doing during this interim session, I don't think that we should expect a unanimous decision from the House side or from the Senate side, particularly. But I do think that we're being more efficient with our time if we're able to pass something from the interim, if we're choosing to talk about this during the interim and suddenly a smaller amount of folks are able to shut down an idea, I think that is a disservice to all the labor that we put in, the time that we put in, not just in this committee while we're sitting here, but also in the days that we're preparing for this committee as well. By adopting the first set of rules, it does not negate either body's ability to amend a bill that we have during our individual committee meetings during session. And if the concern is that we won't come up with some work that is cohesive for everyone, I would argue that we're able to, if the Senate has concerns, then they can address those things in committee. And then if there are differences, we can address those things in conference committee. And so I would ask that we vote for the first option. Thank you, Mr. Chairman.
Representative Webb.
Thank you, Mr. Chairman. Just 2 points. One, I think if I'm understanding correctly, historically, it's always been a simple majority of the entire group, not of the Senate and the House. And number two, doesn't Masons refer back to a simple majority in the of the whole quorum, but not the individual houses?
Mr. Fuller, can you give some insight on what is actually historical and what the rules? I don't think Masons matters, but go ahead and touch on that.
Yep. So I'll take the second question first, Mr. Chairman. Masons, would leave it up to the individual committee to determine its rules in the course of business. In terms of the historical aspect of what this committee has done, candidly, it has been an outlier, except for the last legislature, the 67th legislature, at least in my time here, and I think maybe 2 or 4 years at least, even before then, the Joint Judiciary Committee has operated on taking a majority of each house to sponsor legislation. So the last legislature, the Joint Judiciary Committee, adopted rules to have a majority of the entire committee. So, yeah.
Is that helpful, Representative Webb?
Yes, thank you.
Great. Co-Chairman Washit.
Thank you, Mr. Chairman. So my experience has been that when you have the entire body, the majority of the entire body pass legislation, when it gets assigned to a body for introduction, it's if let's say the Senate did not support the legislation, then the bill would start in the Senate. And so if 3 of 5 committee members voted no on the bill, but then the bill starts on the Senate side, the chances of that bill surviving is really low. And so one of the reasons that we set up the only 4 days of committee meetings this summer was to really stay focused, get legislation that we know will have good support to increase the percentage of the committee bills that survive in the session. And so I'll be opposed to the motion.
Yeah, not to beat a dead horse here, Mr. Chairman, but I do want to weigh in a little bit too. I'm opposed to this motion. This isn't my first rodeo. I've done this for quite some time now, and I've served on other committees that operate under the rule that we are discussing right now, and I've seen the outcome of that. And I think Chairman Washit just accurately described that outcome. Last session, we saw a tremendous number of committee bills killed. Probably the most I've ever seen in my time in the legislature. So I think the purpose of rule number 2 is to avoid that, is to say that when both chambers support legislation that we're actually going to move it forward. And I think that's already been said, but I just want to say it one last time so everyone knows where I'm at on this vote. I don't think I think it's the best and most efficient way of the committee's time, the staff's time, the legislature's time. So I'll be voting against it as well. Any other discussion? Okay, all those in favor signify by saying aye. All those opposed?
Aye.
All right, that motion has failed. Yeah. All right, all those in favor, please raise your hand. 1, 2, 3, 4, 5, 6. Okay, put your hands down. All those opposed, please raise your hand. 1, 2, 3, 4, 5, 6, 7. All right, my hearing's not so bad. We have another motion. Senator Kolb.
Thank you, Mr. Chairman. I make a motion that we adopt rule packet number 2, as we're now calling it, I assume. The one that has to have a majority of both House and Senate members agreeing to legislation to clarify that, so if there's any confusion.
All right, Senator Kolb has moved option number 2. Is there a second?
Second.
Seconded by Senator Crum. We've had the discussion, but is there additional discussion? Anything new anybody wants to discuss? Representative Lean.
Mr. Chairman, I just have a question about the 7-6 vote. There's 14 of us. Could we revote on that?
Why would we revote?
Well, if there's 7 plus 6 is only 13, that means one person didn't vote.
Yeah, I'm not sure. I probably just didn't count myself.
Okay.
Okay. Any other discussion? All right. All those in favor signify by saying aye.
Aye.
Any opposed? That motion has been adopted. Are there any other issues in the rules that we need to address, Mr. Fuller?
Yep, Mr. Chairman, just an announcement as to how you and the co-chairman would like to handle absentee voting.
Oh, yes. Thank you for the reminder. So committee, for your edification, the co-chairman and I have discussed this, and we think that it's not addressed directly in our rules. So we decided that the best way to address absentee voting is to just say that if you were here for a substantial amount of time during the committee hearing, that you would be allowed to vote on the bill that took place during that time that you were here. So if there's a bill that comes up later, let's say, for example, and you've already left, then you weren't here at all for that discussion of that topic, then it would not be appropriate for you to have an absentee vote. But if you were here for a substantial amount of time during that discussion, once again, that's the measure, then we would allow for an absentee vote. Senator Hicks?
Mr. Chairman, is it going to be the prerogative of the co-chairs that people can participate and vote online in circumstances, or is it case by case, or how are you going to handle that?
Rule. Management council.
Yeah, I think there's a management council on that.
Yep,
Mr. Fuller?
Mr. Chairman, Senator Hicks, there is a management council policy that permits an individual member to participate via online methods.
Yes, I think the protocol just for the committee, what would be helpful is to let us know as chairman that you're not going to be attending the meeting. And then obviously you'll need to let staff know so they can get you the link, but it is nice to have the heads up. So just let co-chairman Washington and I know if you're not going to make it to a meeting.
Mr. Chairman.
Senator Hicks.
So, Brian, isn't there some provision in that management council guideline that you do have to consult with the chairman to make sure your arrangements, you can't just just show up online and then participate at part of the meeting. It still would follow that you have to sit through a substantial portion of the discussion to be able to vote on those issues.
Senator Hicks, I think they changed the rule in this last management council meeting. So I think the original rule did have something about chairman. But Mr. Fuller, do you know?
Yeah, Mr. Chairman, I'll have to pull it up to confirm. I think it's a matter of course, so there would be some communication between the member and the chairman, at least insofar as, a member would have to let staff know to get the Zoom link, at which point, if the chairman are unaware, we would inform the chairman.
All right, we'll look that up just to make sure we've got the language of the rule right. Any other questions about rules? Representative Bratton?
Thank you, Mr. Chairman. I have a question. So at the under meetings at the bottom of page 1A, where it says call, about halfway down, notwithstanding any other provision of this subsection, less than a quorum of the joint interim committee may meet and transact business, provided the absent members are subsequently polled. So I think that's what we were just talking about, but I need to understand a little bit more about less than a quorum can meet and transact business. How can How can that be? It seems like it should be a quorum of this. When was this rule, this part of this rule implemented, and what exactly does that mean?
Mr. Fuller.
Yep, Mr. Chairman, Representative Bratton, these sample interim rules have been around as long as I've been here, at least. With that provision, I have never seen a situation where a committee has transacted business. And by business, I mean taking votes on action items, a vote for LSO to draft a bill or a vote to sponsor the bill. Certainly the other provisions in section 2D would apply for that the quorum necessary to transact any business is a majority of the members of the committee. I think where this portion of the rule has come up practically would be, say, for example, coming back after a lunch or a break where members are still arriving and the committee gets started on accepting information.
Representative Bratton.
Thank you. And so, yeah, I have concerns about this. I think that there should be a quorum to transact business. And even though it's never been used, I would like to make a motion. I am making a motion to strike from notwithstanding any other provision of the subsection less than a quorum of the joint interim committee to the very end of that, ending with members of the full committee.
So you are on 2A, and
Yes.
it's the last sentence of the rule that you are striking.
Yes, Mr. Chairman.
Is there a second?
I'll second.
Seconded by Representative Brady. Still getting used to your names, so if I pause, it's because I'm making sure I get it right. So sorry
Point of
about
order,
that.
Mr. Chairman.
Yes.
Mr. Chairman, didn't we already adopt these rules? We all voted on that. I didn't think it was a good time to amend the rules.
I don't think we voted. I thought we just voted on the rule change. Did we vote on the rules themselves?
Mr. Chairman, I would have taken that motion as a motion to adopt these rules.
Oh.
Mr. Chairman, I'm not sure there's anything that would preclude the committee from reopening the rules, though, to consider further amendments to them.
Good with that, Representative Filer?
Up to you, Mr. Chairman.
All right. I think we're going to proceed. I think it's appropriate to discuss this rule. Any other, I got the second. Any other discussion on this motion? Discussion. All those in favor signify by saying aye.
Aye.
All those opposed? All right, that motion has been passed. And then Representative Bratton.
I also would like to make one additional motion, at least to have the discussion on page 3, order of business 3B, a motion to reconsider. Just under that, it says 15 business days, a motion to reconsider or to rescind actions of the committee unless made at the same meeting at which the action was taken may only be made upon 15 days prior. I would like to make a motion to make that 15 business days. Prior written notice of each member of the committee stating what action is to be reconsidered or rescinded.
Okay, it has been seconded. Is there any discussion on that? Mr. Fuller, that's adequate time between our meetings, so either way, it probably doesn't matter.
Mr. Chairman, yes, I think this is just a matter of policy. I mean, the policy behind the 15 days prior was at least 2 weeks notice to the public that a matter was going to come up again at a subsequent meeting.
And so this would be 3 weeks.
It would be 3 weeks instead. Yes, Mr. Chairman.
And I think our meetings are spaced apart just far enough that that's not going to be a problem. Any other discussion? Yes. Senator Crago.
Thank you, Mr. Chairman. I really don't have I'm not taking a stance one way or the other on the amendment. I don't think it really matters. The only thing I would point out is it will start creating inconsistencies between committees. And when you serve on more than one committee, you're going to think, oh, it's out of 15 business days to give notice in judiciary. You're not going to think about, oh, I have to do it 15 business days in, for my example, ag. I get a little bit concerned about getting rules that vary from committee to committee. because we are a citizen legislature, we're, not- you know, we don't have staff to remind us, if you're going to do this, you have to do it 15 business days or 15 calendar days. That would be my only comment, that I think we need to be a little bit cautious about making too many changes to the interim, the standard rules, so that all of us don't lose track of where we are. But that's it, Mr. Chairman. Thank you.
Senator Craig, we are the #1 committee. So it would be appropriate for those other committees who are inferior to the Judiciary Committee to follow suit, but we can't, you know, I guess we can't control what they do. Other discussion? All right, all those in favor signify by saying aye. Those opposed?
No.
Oof, out. All right, all those in favor, raise your hand. 1, 2, 3, 4, 5. All those opposed? 1, 2, 3, 4, 5, 6, 7, 8. That motion has failed. Are there any other motions on the rules? Let's take a formal motion. If someone would be so kind to move to adopt the rules as amended. It's been moved.
Chairman.
Senator Cole.
Yeah, I'd make a motion that we adopt the rules as amended.
Okay, it has been moved and it has been seconded. All those in favor or any discussion? No. All those in favor signify by saying aye.
Aye.
Any opposed? All right, those rules have been adopted.
And then, Mr. Chairman, before we move on.
Yes.
The policy for remote attendance at legislative meetings by legislators is that at a legislator's discretion, the legislator may participate via remote means, so long as the meeting is held at what is called an approved facility. What that means is the facility is capable of handling Ethernet and the Zoom meetings. And then this sentence, I think, is where the question was: the legislator intending to participate remotely shall provide as much notice to the committee chairman and the LSO as is reasonably possible under the circumstances.
All right, very good. So yeah, let us know as soon as you possibly can. Our next meeting is in Casper, and then our last meeting is in Cheyenne. So they are in approved facilities, but those are also at least Casper centrally located. So everyone should be able to make it, hopefully. All right. With that, we will jump into our agenda. Committee, we are going to be taking updates from agencies. The idea is that agencies might actually come forward with legislation, or the discussion that they're having with us might spur legislation in the minds of the members. So keep that in mind. If you're thinking there's something that warrants legislation, don't be afraid to bring that up. That's kind of the idea behind the updates. And then that's going to take the bulk of our day. And then we will have a specific topic that we'll address during our lunch meeting. Actually, I do need to address our lunch time. I don't know, staff, you're probably not taking care of anything lunch-wise. No. Even though we officially put it on the agenda, you still punt it back to us. Okay. All right.
Domino's are right down the street.
All right. We will figure that out as we go. What would someone from staff be able to pick it up for us if we ordered something? Could we at least do that? Okay. All right. Very good. And then we'll have a tour this afternoon of the Medium Correctional Institution. So with that, let's jump into agency updates. The first agency that we have listed is our Attorney General's office.
Good morning. Oh, that's probably close enough. Good morning,
Morning, Ms. Chambers.
Chairman Olson, Co-Chairman Washut. My name is Kara Chambers. I am with the Wyoming Attorney General's office, and I am joined by Director Jones from DCI. I just wanted to start off by letting you know that AG Hill sends her regrets that she is unable to attend in person. You might be aware that she's got a new job coming up on May 28th. She will take seat as our newest Supreme Court Justice here in our state, which is Wednesday after next. So there's a lot going on for her. And she has sent me in her stead as a poor substitute, but I will do my best. She has given me a script, thankfully. So I apologize in advance, but I'm going to be reading from it. Attorney General Hill wanted to start off with kind of a preamble because she knows that so many on this committee are newer to this committee and newer to the legislature. So she wanted to do a brief rundown of our agency as a whole. So our office is comprised of 6 units. There is the law office, which I think most of you traditionally think of as the Attorney General's office. There's the Division of Criminal Investigations, the Wyoming Law Enforcement Academy, POST, or the Peace Officer Standards and Training, the Division of Victim Services, which is mine, and then the Governor's Council on Developmental Disabilities. And that is the entire umbrella that is the AG's office. The work of each is generally going well and proceeding along. We have a professional dedicated staff working in the agencies that do outstanding work on a consistent basis. Of course, like all agencies, there are challenges that we encounter as we go along, but she would describe the state of the agency as good and stable. And she has a few brief highlights. I'll begin with the law office. There are 5 divisions within the law office. There's civil, criminal, human services, tort, water, natural resources. And then there's also a small school finance unit, which we'll talk about in a moment. In general terms, these divisions are handling the legal work for the state of the Wyoming. Their work includes things like offering day-to-day legal advice to state agencies, representing executive branch elected officials, representing the judicial branches and judges when they are sued, defending all criminal appeals before the Wyoming Supreme Court, and any request for post-conviction relief in both state and federal courts. The law office investigates and prosecutes instances of Medicaid fraud. We actually have a small MFUCU unit that does that, Medicaid fraud investigative unit. We also have a consumer protection unit that enforces Wyoming's consumer code. We are responsible for the termination of parental rights cases, responsible for defending suits against the state and asking for monetary damages, which also includes against law enforcement officers sued in their individual capacity. The AG's office pursues suits on behalf of the state of Wyoming and state and federal courts regarding actions of the federal government on water and natural resource matters. The agency is responsible for protecting Wyoming's interest in water matters, including such as the Colorado River Compact. The AG's office defends the constitutionality of all Wyoming statutes and participates in cases that will impact Wyoming interests such as immigration, Title IX, Second Amendment, endangered species, and she has grizzly bears in particular. By the numbers to date in 2025, there have been 28 criminal briefs that have resulted in opinions, and we expect 50 more before the end of the year. There have been approximately 15 other civil, tort, and termination of parental rights actions. 17 termination of parental rights were filed in 2015, and we estimate 15 more before the end of the year. 19 civil matters from defending elected officials to defending the constitutionality of statutes. 43 tort matters are currently pending, various stages from notice of claim to discovery and preparing for trial. Approximately 45 water and natural resource suits are pending. Approximately 10 other cases in large nation topics pending, for example, immigration, Second Amendment, and ESG. There are 2,671 contracts that have been done so far, and that unit is on track to review 7,500 before the end of the year. And the school finance section that I mentioned, that section is primarily charged with assisting in maintaining the constitutionality of Wyoming's educational finance system. It advises the relevant entities such as the governor, Department of Education, legislature, and the superintendent of public instruction on school finance matters. And they handle school finance litigation matters when they arise. Obviously, that is big in the news, as we did indeed have litigation over school finance. The trial took place in June of last year. The state lost. And we have an appeal in front of the Wyoming Supreme Court. And then we regularly update the JAC and the GEC about these matters. I'm going to skip over DCI as Director Jones will have his own. The Wyoming Law Enforcement Academy, they're keeping up with training. The facility is a big concern right now. There was a 2020 needs assessment that recommended a new facility be built. There are issues with the driving area, the building foundation, shooting ranges are too small, and the mechanical systems to move targets are antiquated. The dorm rooms have water leaks to small laundry areas. There's security issues. So some of these are getting addressed piecemeal, but dorm construction is currently ongoing. And then in 2022, there was another study to try to readdress some of these issues. Looking for land in the Douglas area is happening as we speak. And the agency continues to work with the State Building Commission regarding the potential purchase of new property for an emergency vehicle course operation and firearm training facility, and possibly a whole new facility in the future. Also for the post, so Peace Officer Standards and Training. In January, we saw the retirement of Director Chris Walsh. And a new executive director has recently been hired that I'm now aware of. Thank you, Representative Washit. And his name is Robert Terry. He started May 5th. And he has already hit the ground running. He's unable to attend today as he is, as I let the co-chairman know, eating the elephant as we speak. But he plans to attend the next meeting in Casper so you can meet him in person. And then for DVS, she says I get to say whatever I want. So I would just let you know that the work of the division is ongoing. For those of you who may know, we generally are responsible for the pass-through of state and federal funds. We have 57 subrecipient programs across the state. We also chair the Human Trafficking Task Force, which just met earlier this month. We just came off the heels of a fabulous conference in Montana in conjunction with the Montana AG. And we continue to look for work on legislative matters. The bill last year that all of us will remember is the Prostitution Amendments Bill that was sponsored by the Human Trafficking Task Force. We also have the Missing and Murdered Indigenous Persons Task Force, and that is also ongoing. We had a meeting last week, and the bill that sort of arose out of that was the Missing Persons Protocol Bill that you guys saw last year. And so that work is ongoing. I intend to attend the Select Tribal Committee meeting later this week. And with that, the final small unit is the Governor's Council on Developmental Disabilities. That is administratively housed within the agency. Their longtime executive director has just retired, and Kayla Green is serving as the interim director while we are searching for a new director. And with that, I will turn it over to Director Jones for DCI update.
Co-Chairman Washit.
Thank you, Mr. Chairman. Before we move on, Ms. Chambers, I was contacted and someone mentioned to me that the Victims' Bill of Rights in Wyoming only addresses felony cases, and that there is no provision for victim impact statements, for example, in misdemeanor cases. I just wanted to verify that that's accurate and whether or not you have an opinion of whether we should include, it seems like domestic violence, injury, DUI cases. There would be a whole host of misdemeanor cases where the perspective of the victim might be beneficial. Your comments, please.
Ms. Chambers.
Chairman Olson, Co-Chairman Washit, thank you for the question. I would recharacterize it. The Victims' Bill of Rights applies to all crimes. Specific to victim impact statements is it is clearly outlined that is required in felony, and I would argue it is permissive in misdemeanor cases. You have an opportunity to hear from a judge who's in circuit court where the misdemeanors are handled, and he could lend his perspective on how he handles it in his courtroom. That could be a change where to make it mandatory, that it's clear that it's mandatory for most. Anecdotally, our experience is pretty good across the state with judges allowing victims to make impacts, but you are right. It is clearly outlined for felonies and more permissive for misdemeanors.
Co-Chairman Washit, you're not aware of a case where you think there should have been a victim impact statement, but there wasn't one, or is that how that topic came about to your?
Yeah, I was contacted by an individual who brought this forward, so I don't have a specific case.
Yes, Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, Ms. Chambers. My question is to receive funding for the victims, do they have to wait until that goes through court, or do they immediately receive funding for services to start mending them as a whole?
Ms. Chambers.
Chairman Olson, Representative Lean. So I assume you're referring to crime victims compensation, which is administered through my office. None of the above. The only thing that is required for crime victims compensation is that it be reported to law enforcement and that law enforcement certify that a crime has occurred. We don't need an arrest, we don't need a prosecution, and we certainly don't need a conviction. So that can happen right away. There are statutory requirements on timeline to apply and what crimes we cover, but those would be the only limitations.
All right. Anything else on the Attorney General's office? Yes, Representative Brady.
I'd like to, excuse me, referring to AG Hill's last day and when the people will know her replacement. And I just think it's a fair question, considering all the high profile cases that are in the state is involved in right now. Thank you, Chairman. Sorry.
Chairman Olson, Representative Brady. Agreed. The governor will make an appointment to that, and I am not aware of any. He hasn't told me yet, but we will, I'm sure as soon as that becomes public, there will be a press release. And I agree, because I work there. I've worked there for many years. I'm on my 5th, going on 6th AG. These are always interesting times, but we have faith that the agency will remain in good stead.
All right. Any other questions? All right. If not, then we will move over to Division of Criminal Investigation.
Thank you, Mr. Chairman, members of the committee. DCI is made up of 3 sections, Criminal Justice Information Services, the Crime Lab, and our Operations section. So I will break this down into an update of each section, and I'll start with what we call CJIS, Criminal Justice Information Systems. That section has 15 employees and 3 supervisors, and they are responsible for seven different units: applicant tracking, automated biometric identification systems, or ABIS, the control terminal, uniform crime reporting, concealed firearms permits, sex offender registry, and computerized criminal history. In our ATS unit, in the last budget session, we were given 2 more full-time employees to address backlog in background checks. And I'm happy to say that as a result of that, we've gone from 2 to 4 weeks on a background check, the wait time for a background check, to 3 to 7 days. So that's been a huge success. That unit processes about 30,000 fingerprint cards per year. So the extra help has really helped with us being able to get background checks out more quickly. The uniform crime reporting section, that is 1 person. That's sometimes referred to as NIBRs. We have put on 4 trainings for local agencies on how to submit that information over the last year. And as of last week, there were 66 agencies in the state reporting NIBRs, 18 that were not. Our control terminal is responsible for our message switch. This is a piece of equipment that all criminal justice information transactions go through throughout the country, and in some cases even outside the country. So, for example, if an officer pulls someone over and they run their driver's license, that information comes through our switch, and that's how the information gets out. So it's a crucial function of CJIS, and that switch, we process a little over 30 million transactions through that switch per year, which is about a 42% increase over the last 5 years. They also manage the missing persons database, which that is not a 24/7 system, because we're not 24/7. Our control terminal used to be 24 hours, 7 days a week, but we are no longer 24/7. So those entries are put in or taken out Monday through Friday, 8 to 5, as we receive those NCIC entries. Concealed firearms permit, we have 2 people in that unit. They average about 6,000 concealed firearms permits per year. And as of today, there's about 30,000 valid concealed firearms permits in the state of Wyoming that they manage. Sex offender registry, we have 1 person within that section, and she manages about 2,500 registered sex offenders. She updates information, checks addresses, vehicle registrations for all the sex offenders that are registered throughout the state. Computerized criminal history, we have 2 people in that section, and they maintain the state's criminal history repository, which includes about 521,000 arrest records on 251,000 offenders.
Next, I'll move to the crime lab. We are an accredited crime lab through ANAB, and we're the only lab in the state that provides that service free of charge to all of our criminal justice partners. We have 21 scientists, 5 supervisors, and 1 director. In the lab, we perform analysis on toxicology, chemistry, biology, fingerprints. We have an evidence section, quality assurance section, and we are currently contracting out our firearms work. Our lab for the last 2 years received Foresight Maximus Award. And what this award is it's awarded to labs who are operating at least 90% of peak efficiency. There's over 200 labs that submit data to this body who analyzes that data and determines, what efficiency you're working at. And we are very proud to have received that the last 2 years. And that is as demand for our services has increased. Over the last 10 years, the evidence submitted to our lab for analysis has increased by 77%. Biology submissions or DNA, 82%. Chemistry is 70%. Toxicology is up 8%. And our fingerprint section is actually down by 60%. As a result of some of these increases and decreases, we're restructuring some of the responsibilities in the lab to try and meet some of those increases in demand. Our turnaround times, practically day to day for local law enforcement agencies who rely on our services, turnaround times is really the benchmark for how we're doing in providing our service. And I'm a little biased, but I think we're doing very well. In biology and DNA, our turnaround time is 82 days. Chemistry is 34 days. Latent prints is 45 days, and toxicology is 25 days. So that would be the day that we receive the evidence from the day that the analysis is complete and a report is sent. That's what that turnaround time means. And then we do have some new technology in the lab. We've got a rapid DNA instrument that I believe is still going through validation. In chemistry, we now have a validated method online to analyze THC in hash, wax, oils, and concentrates. We have some new software in our latent print unit, which enhances the it helps to determine whether a fingerprint is of value for comparison. So it helps the analysts with that comparison. And then in toxicology, we have an isomer method online to distinguish delta 8 THC from delta 9 THC. If you have technical questions about any of that new technology, I do have Director McWilliams here, and he can answer those questions much better than I would be able to. And then the last section I'll touch on is our operations section. That would be our sworn agents. We have 38 sworn agents across the state in 11 field offices. We currently have 19 task force officers assigned to 6 of our enforcement teams around the state. 15 of those are grant funded, and 4 of them are funded through the general fund. In addition, we have 13 of our agents are currently assigned to federal task forces. We have 7 on the FBI Safe Trails Task Force. We have 2 assigned to DEA, 2 assigned to the Postal Service, and 2 assigned to HSI, which they primarily work on ICAC cases. Over the last 4 years in operations, our requests for what we call general investigations, which would be investigations that we have to be asked into, those have gone up by 28%. We are being asked much more frequently to assist local agencies with investigations, and we don't say no to many of those. Our drug investigations over that same period of time, 4 years, is actually showing a decrease in 28%. Although I will say that 2020
the COVID time was very busy for us. Our drug investigations were actually up during that time. Over the last 2 years, they've remained relatively steady, which I think is more indicative of the drug work that we're doing around the state. Fentanyl and methamphetamine are the two drugs that we pay the most attention to. They cause the most problems. Fentanyl, in 2020, we had 34 submissions of fentanyl evidence to our lab for analysis. And in 2024, that went up to 836. The data we're seeing for this year seems to indicate that that has leveled off or may even be decreasing a little bit, which is also a trend we're seeing nationally. But those two drugs are certainly the most concerning to us and have been for years. Our overdose fatalities have decreased between 2023 and 2024. There was 120 reported in 2023 and 97 in 2024. Now, I will say that not all of those are fentanyl related. That includes all overdose deaths for all types of drugs. 21 of those in 2024, a contributing factor to that death was fentanyl. So just to give some perspective on those numbers. There were also methamphetamine related overdose deaths, as well as prescription or other opioid deaths included in those numbers. We were able to successfully get our cold case database up and running on July 1st of 2024. There was an appropriation to pay for that. We were able to create that database in-house at no cost. So recently I approached the chiefs and sheriffs and offered assistance with that appropriation for them to work on their cold cases. As of yet, I have not had any takers, but that money is going to be available to them as well as to us to work on their cold cases until June 30th of 2026, when that will revert. We were successful as well in implementing the forensic genetic genealogy program. We have the rules have been promulgated, and we currently have one case that we are reviewing for the use of that service. And we also were able to go under contract with a company that will be able to provide that service to us, or for us, I guess. And then back in 2020, we created an officer involved shooting team. The reason we did that was to provide a higher level of objectivity in those cases. What we found from time to time is, let's say there was an officer involved shooting in Cheyenne. Historically, that team, our enforcement team in that town would have conducted that investigation. And there were some concerns that our agents who know the officers that were involved, the appearance is that it may not have been as objective as it could be. So we have agents all over the state that are members of this team. And so now if there's an officer involved shooting in Cheyenne, we will have an agent, let's say from Rock Springs, be the lead agent on that case to help with that appearance of objectivity, or at least to avoid the appearance of impropriety, I guess would be more accurate. We average about 7 of those per year that we investigate. In 2022, we had 15, which was a very busy year. And so far we've had two this year. So that is my update. If I'd be happy to answer any questions.
Senator Hicks.
Yeah, Mr. Chairman, just if you would characterize, have you seen any uptake in operational with any of your federal partners associated with some of the recent increase in activity of trying to get some of the criminal element, the drug trading element and stuff? How is DCI interfacing with our federal partners? And are you guys seeing an uptick in your workload associated with that?
Mr. Jones.
Mr. Chairman, Senator Hicks, historically, we have always had a really good relationship with our federal partners. And the part of the reason for that is because there's not a lot of federal
agencies or federal agency in the state of Wyoming. So they rely on us heavily. I would say that our level of work and cooperation with the federal government, the federal agencies has remained pretty constant. Their focus has changed. Their focus is immigration right now, as well as violent offenders and drug traffickers. But that's what we have not focused on immigration, nor are we as state agents. If they need help, we will help. But really the change that I've seen is that their focus, whether it be DEA, FBI, HSI, their focus really has shifted more towards immigration as opposed to their more traditional roles.
Follow-up, Senator Hicks.
Yeah, just follow up, but immigration based on criminal element, which falls right in. So we're not just because somebody was crossed the border here illegally, they're really primarily focused on that criminal component. And I've noticed that there hasn't been a lot of arrests in Wyoming, but I think it's probably coming to a town near us as I see them continue to move. But right now, you have not seen, just to characterize, any increase in your workload associated with increase in federal agency action to get more of the criminal element out of Wyoming. Is that just a numbers game?
Mr. Jones.
Mr. Chairman, Senator Hicks, I would agree with what you just said. We have not seen an increase in our workload based on that directive, but Wyoming tends to be on the back edge of what's happening nationally, whether it be drug trends or enforcement actions. And so I do anticipate it will get here at some point in time, but I have not seen it as of today.
Co-Chairman Washit.
Hey, Mr. Chairman, a few questions. I'll start with this one. The 18 non-compliant NIBRS agencies, longstanding bugaboo with me. What's the impact of that? When 18 agencies from across the state of Wyoming don't submit data using the NIBRS system, does that prevent Wyoming's data from being fully incorporated into the national data? Do we then use statistical estimates, those sorts of things, as opposed to under the old summary reporting system where we would get counts of all the murders, rapes, and robberies and so forth? What's the impact of having 18 agencies that are now non-compliant for what, 5 years? We were supposed to have been NIBRS compliant 5 years ago. Thank you.
I was going to say this is kind of deja vu because I remember when this committee had this discussion 5 years ago. Mr. Jones.
Mr. Chairman, Mr. Co-Chairman, the impact is that the data is not accurate. I mean, that's really the impact. We still report it to the FBI, but it's just not a complete picture. It's 18 short of what the actual picture is.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Yeah, I have the same deja vu back when I was on here in 2020 that we had non-compliance with the counties and local law enforcement, cities and counties. Who's compliant? That's my question. Or if there's most are, then who's not? I guess I don't know what the update is, and maybe I missed it because I hadn't been here for the 2 prior years. So could you please help me with that? Thank you.
Mr. Jones.
Yeah, Mr. Chairman, Senator Kolb, I don't have the list in front of me, but I can certainly provide that to the committee. That list changes, as we train more agencies and they come online. It changes, then, they have a change in staff. Whoever's entering that information for them leaves, and then now all of a sudden they're not reporting. There's also a number of agencies around the state who are using a particular report management system, who are trying to become compliant, but they are having a really hard time with their report management system, the company building that bridge in order to make those two systems talk. And so I wouldn't say that there's 18 agencies who are just intentionally not reporting because it's cumbersome. I do think there's a number of those agencies who are trying to report, but they are running into problems with getting the systems to talk to each other.
Great. Mr. Jones, you could email that list to us because I think as individuals, we can look at that list, and if it's our local sheriff's department, then we can at least meet with them and maybe understand why they haven't before we publish the list. But I know we've published that list before. Senator Kolb?
Thank you, Mr. Just to follow up. There was this, in the past, there was a large conversation about cutting funding. In other words, having to pay a price for not complying because we had other issues that we were dealing with and trying to understand certain crime statistics, and the data was not there. And people were, I guess, coming to their own conclusions. So that's why it was important. And it doesn't sound like really much of anything's changed. So I look forward to seeing that list. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Representative Lean?
Thank you for coming today. My question is about the cold cases. You mentioned that there was no outreach to be able to put anybody on that list to start helping them with their cold cases. Did you reach out to local detectives, local sheriffs, local police officers, or do you just reach out to local DCI agents in the region?
Mr. Jones?
Mr. Chairman, Representative Lean, I just want to make sure I understand your question. Are you talking specifically about the $150,000 appropriation that I offered to local agencies?
Representative Lean?
Mr. Chairman, yes.
Okay.
Mr. Jones?
I was at a WASCOP, Wyoming Association of Chiefs of Police and Sheriffs. Maybe I got that backwards, but I was at their meeting 2 weeks ago, and the chiefs and sheriffs were represented in that room, as well as a number of their command staff, and I offered it up to every agency that was in that room.
Representative Lee?
Can I ask a separate question, Mr.
You sure
Chairman?
can.
Okay.
Just this one time.
Okay. Earlier you were talking about DNA cases, and you said that you have somebody that may be able to answer this in the room better. You mentioned that is currently going through validation. Are we actively using that in DNA cases, or is that piece that's being validated for future cases?
Mr. Jones?
We might need to
Phone a friend?
Mr. Chairman, if I may have Deputy Director McWilliams come up. I do not believe we're using it yet because of the validation, but I will let him speak on that.
All right, welcome to the hot seat.
Good morning, Chairman Olson and Representative Lean. I'm Scott McWilliams, Deputy Director of DCI's Crime Lab. And we procured a rapid DNA instrument. This is a new instrument that has been under development for the last 15 years or so. The FBI really called for the development of this instrument in order to be able to develop a DNA profile in 90 minutes. And this instrument isn't a silver bullet. It's about 20 times less sensitive than the technology we use in our state crime lab. And it's currently we're validating it for use on reference samples or known samples from an individual. So we can get that profile in 90 minutes. This will help with convicted offender confirmations when we have matches in our combined DNA index system or CODIS. It will expedite the reporting of DNA hits. Later on, this may be important tool for crime scene samples, but at this point, we're not developing it for crime scene samples. The FBI has put in rules and quality assurance standards to allow crime scene samples to be used with rapid DNA in the future. These protocols or standards will be out in July 1st of this year. But at this time, that's not a approved use for combining that with the CODIS system. So yeah, this is still under development at our lab.
Follow up, Representative Lee?
Thank you, Mr. Chairman. My follow-up would be the cost. Do you anticipate this to be a reoccurring cost within your budget to update this piece of equipment?
Deputy McWilliams?
Yes, there are. This was a federally funded piece of equipment. Currently, it's does require maintenance every year. And so to do preventive maintenance and keep this under high functioning, we are going to pay for maintenance. And currently that's on a federal fund as well. And we hope that the federal funding continues. But at this point, we're not asking for anything to continue supporting that unless the federal funding goes away.
Co-Chairman Washer.
Thank you, Mr. Chairman. As long as we have Deputy Director in the hot seat, firearms unit. What's the standing right now and what's the timeline for us to once again be doing those firearms assessments in-house?
Deputy McWilliams. Or Mr. Jones. Or both of you at the same time.
If I may, Chairman, Mr. Chairman, Mr. Co-Chairman, we are still in the process of the look back. Look back of the cases that had previously been worked. Those have been completed, although we still have to take a look at that information, understand what it means, and then notify our prosecutors, defense counsel, and our customers as to that notification on that information. To answer your question on how long it will be till that is back up online, it depends. We currently have a senior level analyst position posted in the hopes of being able to find somebody who's already trained. We haven't had any luck yet. If we have to start from ground zero, it's going to be probably best case scenario 2 years before that program is back up and functioning.
Any other questions for DCI?
One more.
One more. All right. Co-Chairman Washit.
All right. Thank you, Mr. Chairman. So it was in the news not too long ago about, I believe it was one of the parcel services had an employee who was pilfering from packages being sent to the crime lab. The ramifications of that in terms of impact on prosecution seems huge. Is there a fix? Do major cases like rapes and murders get sent through the same transit system through a parcel carrier, or do agencies deliver them directly? I'm just worried that if this type of thing were to persist, we could lose a major prosecution.
Mr. Jones.
Yeah, Mr. Chairman, Mr. Co-Chairman, that issue is not unique. We have had that occur a number of times over the years. Generally, when it happens, we mail less evidence for a period of time. But what that means is if we buy some drugs in Afton, let's say 3 grams of methamphetamine, we buy that in Afton. That's a day and a half trip, paying an employee's salary to drive from Afton all the way to Cheyenne to drop off one piece of evidence. So we mail evidence only when we have to, but we still mail it. Major cases generally are delivered in person. I mean, I guess an argument could be made that they're all major cases, which they are. But I think to your point, if we have an officer involved shooting or something that it's critical that all of that information make it, we drive it. Now what local agencies do, we don't have any control over that, but I will tell you, we get a lot of mail from local agencies, which is evidence. So I mean, it was a very unfortunate deal, but it's not the first time that it has happened. And practically, I don't know how we get away from being able to mail evidence when it's necessary. I mean, it's just not practical.
Senator Hicks.
Yeah, Mr. Chairman, one follow-up question for the deputy director regarding the DNA calibration with the machinery. And you said you use known samples for that process. I just want to make for the record here, none of those known samples are from any member of this committee. Is that correct?
You don't have to answer that.
Just leave your cups in the garbage today, please.
Right.
All right. Any other questions for DCI? All right. Well, thank you all. Next, we will move to our clerks of district court. And I believe Miss Sutton is online.
Yes, Mr. Chairman.
All right, let's bring her in.
Good morning, Mr. Chairman. Can you hear me?
Welcome, Clerk Sutton. Can you hear us?
Welcome. I can hear you. Can you hear me?
We can hear you.
Okay. Thank you. Good morning, Mr. Chairman and committee
Yes,
members.
we can.
Okay. I'm having a slight delay. I'll do the best I can. I'm having a slight delay. I'll do the best I can. My name is Ann Sutton. I'm the president of the Clerk of District Court
Yep,
Association.
we hear you. Go ahead and proceed.
My name is Ann Sutton. I'm the president of the District Court. I'm the elected clerk in Teton County. We appreciate the opportunity to provide a brief update.
We're ready to rock and roll. You just let us know what you want us to hear.
We appreciate the I also appreciate the opportunity to provide these remarks by video. Our clerks' spring meetings start tomorrow morning on the other side of the state. My update today will focus on e-filing from a clerk of district court perspective. It's the topic that seems to garner the most interest and attention from partners and the public. I'll provide a high-level review of the complexity of district court record keeping and a brief overview of the status of implementation, some successes, some challenges, some takeaways, and some perspectives as we look ahead to next phases. As background, district court record keeping is far more complex than most realize. We have a very broad range of case types, as some of you are familiar with. They include, but aren't limited to, criminal cases, adoptions, involuntary hospitalizations, family law, estate administration, wrongful death, contract, tort, juvenile, paternity, guardianship, conservatorship, trust administration and litigation, and confidential intermediaries, which help biological families involved in adoptions connect. Some of our case types are entirely confidential, and other cases are public but have certain components that are confidential. Confidential information can include public cases such as cases with information such as social security numbers, trade secrets, trust documents, pre-sentence investigations, psychological evaluations, tax returns, confidential informant information, and addresses for victims of domestic violence. For a little additional background, I also want to mention that the 23 current elected clerks have over 350 years of combined experience managing these complex district court case records. Our top priorities include preserving a complete and accurate record in providing appropriate access and restrictions. We're also focused on timely processing. To summarize e-filing implementation from a clerk of district court perspective, I would say that implementation is far easier said than done. It's largely due to the complexities with case types, some of which I just described. Additional complexities includes who are official parties to the case and the different fee collections that are required with certain filings. I would say that the project has experienced common challenges when project success depends on strong alignment of theory and practice. Again, something easier said than done. Where I would describe e-filing at now, again, from a clerk of district court perspective, it's not only available to attorneys in all counties, but it's also mandatory in most instances. Pro se filers who aren't represented by an attorneys filing something for a non-party, all still file in a more traditional way, such as mail, in-person delivery, or email filing, which is a separate thing than electronic filing. Most of the required fees can be collected at the time of submitting the e-filing, although there have been some kinks and we continue to work out those fee collections. Attorneys using the e-filing system have some access to case filings. I'd call this bonus access at this time. Perfecting access to the case records is proving challenging, and it's a slightly different scope and focus than the initial focus on providing for e-filing submissions. Clerks have spent a lot of time partnering with bar associations to put on workshops before and during e-filing implementation, and we've started to attend the Wyoming State Bar Conference to be available in person to answer questions, hear suggestions and concerns. Some project successes to date from a clerk of district court perspective. We perceive that e-filing has increased convenience for attorneys in that they're able to more timely file documents and avoid having to print and mail or go to the courthouse in person to file. The e-filing system provides secure submission of confidential case filings. As I mentioned, attorneys have increased access to case record information through the e-filing system. Even though it's imperfect in these early phases, it is still greater access to case information than they had prior to e-filing. And many offices have completed the transition to paperless court records. There have also been challenges. Challenges from clerks' perceptions include, one, some misperceptions. I hear often from partners the perception that my office must have experienced significant increases in operational efficiency, and I must have had lots of time freed up. And I would say that we're not there yet. We're hopeful we're heading in that direction, but these early phases are clunky. We spend a lot of time on the phone with filers trying to answer questions and troubleshoot. It's time consuming and challenging to be training staff on so many new processes that are regularly continuing to evolve. And we have lots of cleanup tasks still before us so that the many different systems that we use better communicate. Another challenge has been expectation management. When we're trying to do too many things at once with technology, it can kind of dilute our attention from each of the individual important tasks and goals. The attorney access can be positive, but it can also be problematic. There are external pressures for speedy rollout and increased wish list conveniences. And sometimes in trying to move fast, we worry that we might risk the case record and increase confusion and potentially risk incomplete protection of restricted information. Another challenge is the e-filing system was not initially designed to provide clerks the opportunity to use it and to file and serve, despite being the constitutional and statutory custodian of the record and despite being required to issue notices of assignments in all cases and to serve orders on parties. But I'm happy to report that this week we'll be training with the Wyoming Judicial Branch on updates that will allow us to use the system more completely. Two last thing, I'd like to share some takeaways and some lessons learned. We believe that our court partners are starting to better appreciate our record keeping and managing public access and restrictions experience, and that it's far more complex than many realized if you weren't the custodian. As the subject matter experts in these areas, clerks really have the unique and critical experience that no other party can provide to this project. Engaging with us as subject matter experts often and proactively versus reactively increases project success. We can be most helpful if consulted early in planning and decision-making. We've also been learning that training and transition takes time and it's not fully accomplished with written materials and initial presentations alone. And it's especially challenging when the technology, the process, and the court rules continue to evolve in significant ways. If I were to summarize, I would say that projects of this scale and complexity benefit from going slow to move fast. It's critical to have clear goals, begin with the end in mind, and keep non-negotiable priorities at the forefront of all decision-making processes, even when faced with significant pressures for speedy rollout and increased conveniences. And again, from a clerk of district court perspective, our priorities are trust in the record, a complete and accurate and timely record that includes those proper restrictions. And in closing, looking ahead, it's our experience that clerks and all of the different partners are working diligently to address challenges and make improvements. Clerks are committed to make e-filing and records access as convenient and efficient as possible. Again, as long as we aren't compromising the accuracy, completeness, and protection of the record. We will continue to use our hundreds of years of collective experience to proactively identify where theory and practice are not aligning and to reduce risks to the case record. We will continue to advocate to be included early and often, essentially at every project phase that touches the record, including rules reviews, trainings and outreach, planning for next phases, and troubleshooting. We also hope that there's adequate funding support for additional enhancements and customizations that will be critical to maintaining the record, providing proper access and restrictions, and optimizing system features for all partners wherever possible. And with that, Mr. Chairman, I stand for any questions and thank you for your advanced patience with the delays I'm experiencing in hearing you.
Thank you, Ms. Sutton. Representative Lean has a question, and then Representative Webb. Representative Webb, you're up, I guess.
Thank you, Mr. Chairman. Thank you, Ms. Sutton. I guess with the complexities of things and the problems that we're facing with this system or systems, my question would be, could you provide us with what the Clerks Association would feel would be an adequate solution to help to make this process easier for everybody?
Ms. Sutton.
Mr. Chairman, Representative Webb, I wish I had a golden ticket, one simple answer. I think it takes commitment from all the partners to keep coming to the table and to be willing to get a bit in the weeds. It's often, it's human nature to try to work through the many tasks we all have on our desk as quickly as possible. But sometimes I believe for project success, we need to take some time to really evaluate the nitty-gritty details. And so to answer your question about what would be the most helpful, I think we're trending in the right direction. I think we're continuing to improve and enhance our partnership with the various committees in the Wyoming Judicial Branch Applications team. So I think we're doing all that we can. We're really trying to articulate issues that are meaningful to all of the different parties and to efficiently represent possible implications of different proposals. I'm not sure I'm providing you the answer that you're looking for, except to say that we're still going to continue working at it. We still can continue to hope to be invited and at the table as much as possible, and I think we'll get there.
Any follow-up, Representative Webb?
Yes, thank you. I would like to see at some point you guys make suggestions as to what could be done. And then as a follow-up, does this have anything to do with public access? And this may be a question that is more appropriate for the judicial branch. But I know that neighboring states, of at least two of them, have been online with public access for 10 plus years, and we are not. And I'm wondering, is this a part of the problem, or how are we going to address this?
Ms. Sutton?
Mr. Chairman, Representative Webb, What I will share is that there's 4 systems that touch the district court case record. As you are aware, online public access is not yet available. I would defer to the judicial branch in terms of project planning, knowing that our current focus is really on perfecting this e-filing system that attorneys use. What I will say is clerks are always eager to make those improvements that you've described. We're always going to be advocating to move slow, to move fast, to make sure that information that is needs restriction from public access is properly protected as we make that transition. And Mr. Chairman, if I may, Representative Webb, regarding your requests for a list of things that may be helpful, we will certainly be discussing those opportunities at our meetings this week. For a list of things that may be helpful, and we will certainly be discussing those opportunities at our meetings this week.
Thank you, and thank you for the work that you do.
Representative Lean.
Thank you, Mr. Chairman. Public access was it, and Mr. Webb touched on it.
Perfect. Co-Chairman Washit.
Thank you, Mr. Chairman. Ms. Sutton, you mentioned one thing that kind of caught my ear when you mentioned a seat at the table. And my question is, does your association believe that you've been adequately invited to the table for these discussions, or have you been left out up until now?
Clerk Sutton.
Mr. Chairman, Co-Chairman Washit. You know, the e-filing project implementation has happened a little differently than some of our other systems implementation. My perception, the Clerk of District Court Association perception is at first at glance, it seemed like it was maybe going to be an easier process than it was. I think there were some opportunities where we could have been more helpful if we were included earlier in the process in certain decision making. I would like to think that there are some collective lessons learned. I know there's lessons learned for us as the Clerk of District Court Association about how we would advocate differently in the future. As I mentioned previously, I think we're trending in the right direction. I think that those relationships are strengthening, and I think we're increasing mutual respect for the different roles we all play and the different expertise we bring to the equation. So I think there were some missed opportunities, but I do think that we are making appropriate corrections and are going to take those lessons as we move forward with this and other projects.
Other questions for the clerks? Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Just how many years has e-filing been, I don't know, floating around out there? I was a county commissioner back in 18 and I heard about this, and I just could you give an update on just how many years we've been trying to get this thing off the ground? Thank you, Mr. Chairman.
Clerk Sutton.
Mr. Chairman, Senator Kolb, I don't probably have the most complete history for you. I know that it's been a discussion for decades. I've been a clerk for, this is my 11th year, and I know it was already hopeful to be on this horizon when I started 11 years ago. I also can say we hear all the time at the counter, we've heard for quite some time about how long the federal system's been using it. But in terms of it being implemented in Wyoming, I believe the first pilot courts were about 4 years ago, if I have that right. I know Teton County started 2 years ago this July. So we're closing in on 5 years into it in Wyoming. I know it's been a long-term project, but it required some statewide system implementation and stabilization, and then we changed the statewide system midstream.
Other questions, Representative Lean?
Thank you, Mr. Chairman. Thank you for being on Zoom today. My question is about the application of the process that you're using. And you said you just changed midstream. Could you tell me what is the current program that you're using?
Uh,
Clerk Sutton?
Mr. Chairman, Representative Lean, thank you for the question and the opportunity to clarify. When I say midstream, I mean years ago, prior to starting e-filing, we first went through a system change. So it wasn't midstream in e-filing. The first statewide system was a system we called Y-User. And then we made a change to a new statewide system called Full Court Enterprise. That adjustment was in place before we started the e-filing transition, but was a necessary step before you overlay new systems. Excuse me, sorry, Mr. Chairman, if I may add to your question,
No?
to your question,
other questions?
Representative Lean. Excuse me.
Yeah, go ahead.
Mr. Chairman, if I may add to your question, Representative Lean. The e-filing system is known as File and Serve Express, and I'm not a technical IT person, but basically that system communicates with the primary case management system, Full Court Enterprise. Technical IT person, but basically that system communicates with the primary case management system, Full Court Enterprise.
And our judicial branch will have a lot more information. They're the ones that will know the specifics about the softwares. And so if you want to dive deeper into that, certainly welcome to try with the clerk, but the judicial branch will be equipped to answer those questions. Representative Lean.
Thank you, Mr. Chairman. My follow-up would be, at what time frame do you anticipate to be fully online?
Clerk Sutton.
Mr. Chairman, Representative Lean, I think the spirit of the question is to be fully online in terms of that public access piece. I'm not in a position to answer that question. Perhaps it could be posed to the judicial branch in terms of, future technology rollout plans. As I mentioned, we're at the ready to help wherever we can, as long as we continue to prioritize stabilization and trust in the court record.
Anything else, committee? All right. Thank you, Clerk Sutton.
Thank you.
Do we have anyone else from the Clerks Association here? I'm just not sure what Goshen County's clerk looks like, so I couldn't pick her out of the crowd if I had to, or him. Okay. All right. Very good. We'll move on. Let's go to the Wyoming Office of Homeland Security.
Okay, good morning, Mr. Chair, Mr. Co-Chairman.
And I believe we have a presentation.
Oh, yes, we do.
Can we get that up on the screen for the public and for us? All right, welcome.
Thank you. I am Ashley Paulsrud. I am the Grants and Finance Section Chief for the Wyoming Office of Homeland Security. Director Budd sends her regards and wishes she could have been here today, but you're stuck with me, and we're going to provide you some updates since the last session, things we've been working on, as well as the status of kind of FEMA in general and some funding considerations that may be coming forth this next biennium. So with that, I believe Brian Erickson, who is a critical infrastructure protection analyst in our office, will be, I think he's online, and I think he'll be providing some information on the critical infrastructure protection project that our agency is working on.
Hello, thank you, Ashley. I am experiencing the same delay in audio
supposed to be online.
as Clerk Sutton was. So
Oh,
please be patient with
welcome.
me and
All
I
right.
will move along and I'll try to avoid pauses and once I get done, I'll stand for questioning. Thank you. Okay, so Wyoming statute 19-13-502 designated the Wyoming Office of Homeland Security to define critical infrastructure points throughout the state and then to create zones around those where we would be monitoring property transactions. Originally, the statute had the Office of Homeland Security creating those zones and then sharing that information with the county clerks. Luckily, last year, House Bill 97 modified that. And so now we have all of the data coming from the county clerks to the Office of Homeland Security. This does a couple of things. This keeps the number of eyes on that list of critical infrastructure zones and points low. And then it also makes one centralized area for all of that data and the analysis of it. It also modified the language to allowing investigation into transactions to within up to 5 miles of a critical infrastructure zone. You're welcome to move through those slides a little bit for me because I'll thank you very much. You see here, this is where we sent out this survey to each of the counties. We sent them out to the emergency managers in the counties and then also to several other partners. They give us all of the information about what they are determining to be a critical infrastructure point. And then you see on the right side of that screen, there is a feature score. So what we do is we score each of these points, and that helps us create and define the zone and how big of a zone needs to be around each of these points, depending on how critical it actually is. Now, we do get a lot of information from the counties, and at this point, we have over 1,500 critical infrastructure points throughout the state. We have to go through each of those points and determine if this is actually critical as far as state, region, national security is concerned. Next slide, please. So we do go through and we create a dashboard. That tells us where we are in this process, how many points that we have, where they are located, and that's how we're actually working through them and creating those zones. Next slide, please. And here you see that dashboard, and this is a really good example of one of those points. We have the Hog Park Saddle Dam number 2. And if you look at the picture, the little purple circle down in the bottom right of that map, that's actually the point. And then the immediate square, the red hashed square, that's the parcel that point is within. Now, for this one, we've determined that the immediate parcel and then all touching parcels would be considered a critical infrastructure zone. So we would be monitoring property transactions within that zone. You see here, it shows that we have almost 1,500 surveys submitted. That's a lot of data. We have actually ended up with going through all of this. We're about 88% through all of the surveys that have come in. We have over 10 million acres in the state that are now considered a critical infrastructure zone. That ends up being about 15% of the state that is a critical infrastructure zone. And that's a lot of land. We are leaning on professionals in each of these areas and professionals in the fields where these zones are, with this being dams, water and wastewater facilities. We are leaning on the people that are in those and know those facilities to help us score these zones and determine how large of that zone that needs to be. But within Wyoming, there are hundreds of thousands of property transactions that occur each year. And there's only two of us here in the office that are able to go through all of these transactions. So the way that this works is we get the transaction data from the counties. We have to compare that list of parcels to the list of parcels that are within a critical infrastructure zone. And then if we have a transaction that's in that zone, we have to move it forward and go through a further investigation. And that's going to use other partners as well. That'll be the Attorney General's office, the Secretary of State's office, DCI. We are going to need to have a software solution that can help expedite this, because with just two of us, we're not going to be able to get through every transaction throughout a year. So we have created an RFI. It's gone out, it's come back. We had 6 responses. 3 of those responses were good responses, but there is going to be a lot of money that's needed to create this software solution. Wyoming is going to be the first state that actually does this from start to end, the way that we are looking at doing this and the way that that statute is asking us to do this. But realistically, we are going to be the giants whose shoulders other states stand on. And we're hearing from lots of other states that they need to be doing this as well, but they just don't know how. And so this software that we're going to have to come up with is going to kind of set the standard for that. July 1 is when we will start getting all of that data from the county clerks, and that's when we have to start going through it. And for now, it's going to be a very manual process, but we really hope to get some funding and get an RFP moved forward so that we can expedite this process. And Ashley, that's really all that I have.
All right, thank you, Ms. Paulsrud.
Thank you. Before we move on, does anybody have questions for Mr. Erickson?
Are there any questions on the presentation? Yes, Representative Chestick.
Yes, thank you, Mr. Chairman and Mr. Erickson. So the point of the bill is to monitor transactions in these critical infrastructure zones. What are you looking for when you're monitoring? What is the fear that we're trying to address here?
Mr. Chairman, really what we're after is, as the statute asks, is those I'm sorry, it's escaping me right now. Foreign adversaries. There we go. Foreign adversaries purchasing property near our critical infrastructure. If you remember, there was the issue with the Mine 1 facility here in Cheyenne, where it ended up being the PRC actually came under full ownership and control of that facility, and it was within, I believe, within a mile of F.E. Warren Air Force Base, and that's a problem. And so what we're doing is we're trying to avoid those situations in the future. Thank you.
Representative Chestick, follow up.
Thank you, Mr. Chairman. And how does one determine whether a property owner or somebody involved in a transaction is a foreign adversary? Seems like it'd be easy for a foreign adversary to hide behind a straw party.
Mr. Chairman, you're absolutely right. That is a huge investigative process that has to go on there. And that's where we're going to be leaning on our partners. And it's really just going to have to be a big investigation. And some of the software solutions that we've seen, they use a lot of data that's already out there, tax data, beneficial ownership of companies. And it's really going to be a work in progress as we go through this process. Thank you.
No, he's good. Co-chairman Washit.
Thank you, Mr. Co-Chairman. Just comment. You know, when we draft legislation, it's like two lines of text, you know, saying do this or protect us from that. And I appreciate this information this morning, giving us a real sense of what the administrative burden equates to when we pass legislation. I think the legislation was very well intended. But I'm not sure most of us were thinking of every communications tower and irrigation dam and so forth as critical infrastructure when we voted for the legislation. So just thank you for your presentation.
Thank you.
Representative Singh.
Thank you, Mr. Chairman. And sort of just to follow up on that, that statement from Chairman Washit, and forgive my ignorance on this topic, can you just elaborate more on the types of infrastructure that we're talking about? So, I mean, everyone is thinking about like the electric grid as critical infrastructure, but does that include things as that may be more abstract, like a fishing hatchery or an animal crossing? Does that also considered critical infrastructure? Thank you.
Thank you, Representative Singh. Really, what we're looking at here is, and you can actually go to the next slide on this, is what we refer to as the CWET, which stands for communications, water, energy, transportation, and then we also add military. Wyoming has a lot of military assets that are critical to the state, the region, and the nation. At this point, we are focusing on energy and military first. We do have to get through all the other critical infrastructure sectors, but with what we have here in the state and what we provide to the rest of the nation, that's really where we're focusing. Now, some of these counties, as they do provide these submissions, they are including those things like the fish hatchery and the mom and pop grocery stores in their small towns. And to them, that is what they would consider critical infrastructure. But for us here at this point, at this level where we're going into this project, we are focusing on those things that are critical at the state, region, and national level. Thank you.
Representative Filer.
Thanks, Mr. Chairman. Just when we look at, you said that you were focusing on energy and military. I was wondering, are they taking, whenever you get submitted here, are they taking into consideration every single missile silo that's out there also? Not just including F.E. Warren Air Force Base, but I believe when I drove here yesterday, I passed at least a dozen missile silos. So are we looking at every single one of those places and their surrounding areas also?
Mr. Chairman, yes, we absolutely are looking at every single missile silo and as well as other military assets. But yes, we do look at every single one and the surrounding areas for them. Thank you.
All right. I think that's it for online. So Ms. Paulsrud, do you have something else you'd like to share with us?
Yep, I just have a few additional points that I'd like to talk about. Starting off with the current status of FEMA. I'm sure you guys have all seen in the news, the state of FEMA and the status of FEMA is in flux right now. We've been paying close attention to the testimony of DHS Secretary Noem, as well as staying connected to the ever-changing environment through the National Emergency Management Association, NEMA. If you guys didn't know, Director Budd is the president of NEMA currently, so we're staying heavily connected through them, and it changes every 5 minutes. It seems like there's something new coming out with FEMA. What it boils down to, though, and what we're hearing is that the states need to be prepared to take on more responsibility when it comes to disaster response and recovery. We're seeing that through the cancellation of some grant programs. We're seeing that through some increased thresholds for the disaster programs from FEMA. So to start, FEMA kind of divides their programs into two areas. You have the disaster programs, and then you have the non-disaster programs. So on the disaster side, these are the programs: public assistance, individual assistance, those sorts of programs, disaster response. Currently in public assistance, the state of Wyoming has a threshold of $1.1 million. That is the amount of damage we would have to have if we want to qualify for FEMA public assistance. We have heard that they are proposing quadrupling that threshold. That means for the state of Wyoming, that number will increase to about 4.3 million if we want to qualify for a FEMA public assistance disaster declaration. So that is significant. I don't know in the history, I've been here about 8 years, in the history of Wyoming disasters, should we have to meet that 4.3, none of our disasters would have met that, which means we wouldn't have qualified for any FEMA public assistance dollars. So pretty scary. On the non-disaster side, we have the Emergency Management Performance Grant, we have the State Homeland Security Program Grant, and we have the Nonprofit Security Program Grant. Those are the three main grants that our office is the state administrative agency for. A lot of those grants get passed down to the local level. In fact, 80% of the State Homeland Security Grant Program must be passed through to local agencies, to local jurisdictions. 35% of that grant has to go to local law enforcement. The status of the Emergency Management Performance Grant, 17 of our 23 employees in our office are funded through the Emergency Management Performance Grant. That's 83% of our staff. As a whole, our agency is 92% federally funded. And then on the Nonprofit Security Grant, that goes to support security, physical security, cybersecurity projects for local nonprofit agencies, churches, schools, youth, community centers, that sort of thing. These are annual grants that historically come out in the spring of each year. So we would have normally seen funding announcements in February of this year. We have not seen anything on any of those grants. We don't know when or if they will be coming. We don't know what they will look like if they come. So what this means is that those local communities that rely on the SHSP, the State Homeland Security Grant Program, the nonprofit grant, as well as Emergency Management Performance Grant, that grant, the EMPG, it also funds about 30 emergency management personnel in your communities at the local level. So what that means is that there's a lot of uncertainty for those local communities about where their funding is going to come from, the projects that we've previously supported. We don't know if we'll be able to continue to support those. We also don't know what it looks like to support our communities in times of disaster. We know that the state will have to take on more responsibility, but how do we do that without relying on the federal government and the federal funding that we've received previously? One thing I did want to mention kind of on the mitigation side, something you've also heard about, FEMA has recently canceled the Building Resilient Infrastructure and Communities Grant. That was a mitigation grant that provided funding upfront ahead of a disaster to make our infrastructure more resilient. They canceled not only the current year, but all previous years of that program. So from fiscal year 2020 through fiscal year 2023. We were fortunate enough, we've done a lot of talking with FEMA Region 8 down in Denver. Our state was fortunate enough that we only had one project that was canceled this current year. And that was because it wasn't obligated at the time of the cancellation. So all of our other BRIC projects, our other mitigation projects will be allowed to continue, and those communities will be allowed to complete their projects. So that is a little bit of good news in kind of what seems like dark times right now. I think really what we just want is we're asking for your support. We will probably, most likely, our budget ask will be a lot different this year. It'll look a little bit different. We'll have to potentially ask for some more general fund money, but really just figuring out how we can still support our local communities as a state when we don't have the federal FEMA disaster money coming in. And then if you'll head to the next slide, please. To give you a little bit of update on some of the funding that was allocated for our regional emergency response teams and our bomb squads, bomb teams, during the last session, a total of $4 million was allocated to our regional emergency response teams. Of that, we did put out a request for proposals. We've received a bid from SVI Icon Fire in amount of $883,283 per apparatus. So with the $4 million, we'll be purchasing 3 of the heavy rescue apparatuses for our regional emergency response teams. The additional money will be used to procure 2 kind of non-fire apparatuses for 2 additional teams. So a total of 5 pieces of equipment will be purchased with that $4 million. On the other side, for the bomb teams, we were allocated $1.5 million. Of that, 1.3 has been allocated and encumbered for those local bomb teams to purchase necessary equipment needed for their response. The additional money will be used to purchase training explosives and various smaller items that were identified after that initial purchase was complete. The last thing that I kind of wanted to talk about was the Emergency Management Assistance Compact. So what is the Emergency Management Assistance Compact? It is an interstate mutual aid agreement, basically a governor-to-governor agreement to share resources among the states. It really is the backbone of our nation's disaster response. It provides for timely, cost-effective mutual aid across all 50 states and territories, as well as the district. By coordinating local and state resources, EMAC delivers critical support while reducing resilience on federal resources, which I think will become even more important as we see those federal disaster response dollars decrease. The importance of EMAC in sharing our resources and supporting our state, but other states around us, that will become more important. We may see, typically EMAC has come in the form of resources during disaster. However, we're seeing more requests being pushed for planned events and large scale events such as the Republican National Convention. We are also expecting to see the FIFA 2026 World Cup will be in the United States next summer for about 40 days. It will include 16 host cities across 3 nations. That's the first time that's ever happened. And the team numbers have been expanded from 32 to 48. Also a first for the World Cup. We are expecting a large influx of people coming into the country. Of the 16 host cities, 11 will be here in the United States. They've already formed a subcommittee through EMAC, and a task force has been formed to plan and see what kind of resources will really be requested next summer. Mostly, we'll probably see it in terms of law enforcement. They will need law enforcement for also the host cities where the competitions are happening, but also numerous cities around the country plan to host big fan events. And people that aren't necessarily attending the competitions could attend those fan events. And so looking for some additional law enforcement support to support the states that have host cities in them. Any questions? I think I'll stop there and I'll answer any questions should there be any.
Committee, Representative Bratton.
Thank you, Mr. Chairman. So I have a question about the large equipment that you're purchasing.
Yeah.
Where will those be located and what is the plan for deployment of those? Can you describe those a little bit more?
Ms.
Sure.
Paulsrud.
Yeah. Thank you, Mr. Chairman, Representative Bratton. The current apparatuses are designated for Regional Emergency Response Number 1 out of Sheridan, Regional Emergency Response Number 3 out of Laramie, Regional Emergency Response Team Number 4 out of Rock Springs. So each one, we have 8 regional emergency response teams in the state. Each one of them cover multiple counties. And then these 3 will be receiving the new equipment. All of them need to be replaced at some point. I think they are about 20 years old, and we're just working through priorities, trying to figure out who needs what first. As far as deployment of the teams, they are deployed through our office. So anytime a regional emergency response team, primarily hazmat, is needed on an event or a call, they get deployment activation through our office, and then we reimburse them for their time and supplies and expenses as needed through one of our funds.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. You've mentioned that there are 30 local management personnel in our communities that stand to lose their jobs. My question is, what is their cost and what are their duties?
Sure.
Ms. Paulsrud.
Thank you, Mr. Chairman, Representative Lean. I don't know that I would say that they are potentially losing their jobs. However, their funding is in jeopardy. The way it works with our emergency management personnel is they are actually county employees. So they are county employees that are appointed by the governor. They are in statute. Their title is the Homeland Security Coordinator. We provide currently 50% of their salary through the Emergency Management Performance Grant. The other 50% is matched by county funds. Currently, we receive about $3 million in that grant each year. Of that, $1 million is passed through to all of the local emergency management agencies. It varies by county, just depending on the salary that they pay their emergency management. That's set by the county. But we are looking at potentially a significant decrease in the funding that we're able to pass through to them. The emergency management coordinators, their duties at the local level are really the same kind of as our state agency. Their job is to prepare their communities for times of disaster. That includes creating plans at the local level, emergency operations plans, continuity plans. It's also to really respond in times of emergency. If there's a local flood or a local event, your emergency manager in your local county will be involved.
Representative Singh.
Thank you, Mr. Chairman and Chief Paulsrud for being here today. So I have a first question and then I'll have a follow-up, but
Okay.
so this, what was it, EMAC? Participation in EMAC, is that a result of legislative action? Did the legislature have to take a vote in order to participate in that compact, or is that at the discretion of the executive branch?
Ms. Paulsrud.
Thank you, Mr. Chairman, Representative Singh. That is it in statute. It is a legislative action.
Follow-up, Representative Singh.
Thank you, Mr. Chairman. And this is unrelated, but where is the closest city that is partnering with FIFA to Wyoming?
Yeah. I have a map. Thank you, Mr. Chairman, Representative Singh. I have a map. And nothing in the Mountain West region. It looks like there's one in Seattle, San Francisco, LA, Dallas, Houston, Kansas City, and then a bunch on the East Coast. So probably Dallas or Kansas City. Yeah.
It's almost like you guys coordinated that question. That was teed up perfectly. Representative Singh.
Thank you, Mr. Chairman. It just sounds like these international athletes need some high altitude training. That's all. Thank you.
Agreed.
Anything else? Do you have anything else for us?
I don't.
All right, we really
Thank you.
appreciate the update
Yes.
and your time and commitment to be here.
Yes. Thank you.
All right, committee, let's go ahead and take a 10-minute break. We'll be back at 10:45. Paging the House of Representatives. Paging the House of Representatives. I guess the Senate too.
Senate got a pass, huh?
Yeah.
All right, are we live? All right, we are back. Welcome back for the second half of the morning session of our thought my voice would calm the crowd, but I needed the gavel. Next up is the Wyoming Department of Family Services. They're making their way up here. Welcome. Whoever wants to start, you're welcome to start.
Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. With me today is Christy Gordy. She is the Social Services Senior Administrator for the Department of Family Services. Today, what we thought we would do is just give you a very high overview of the Department of Family Services. Some of you are a little bit newer to us than others. For those of you who know us, I'm sorry, this is going to be highly redundant. But then we'll also give you an update on the Juvenile Justice Information System, and Ms. Gordy will do that.
No, this is my favorite part about the House of Representatives because every 2 years it turns over so significantly that we have to redo and rehash all of this. So it stays at the forefront of my mind.
Thank you, Mr. Chairman. Number one in your hearts, isn't that? So the Department of Family Services is one of the larger agencies. We get thrown into the top 5 classification. We have about 660 employees located in 2 youth facilities, the boys' school in Worland, the girls' school in Sheridan, and 28 field offices throughout the state. So every one of our counties has a local DFS office. Some counties have 2. The majority of our staff, about 87% of our staff, are doing direct services. So what that means is that they're working in the local offices or they're providing direct services at the boys' school or the girls' school. Our biennial budget, is about $328 million a biennium, of which 49% of that is general fund. The remainder is federal fund, which is about 46%, and then other fund, which is 5%. And other funds are things like tobacco settlement funds that are still in our budget, and also revenue that we're generating, like through central registry, for example. It's pretty hard to discuss the totality of what we do as an agency. And so I think I'm going to start with a lot of the things we don't do. What we know is that there are a lot of myths around what DFS can do and can't do, and what we don't do and what we do. But I think kind of getting some of the myths out of the way will open up some room for questions. And I'm also always available for any conversations if you'd like to have those offline or even a visit. So what is it that the Department of Family Service does? Well, we are much bigger than abuse and neglect. While that's a lot of what people hear of and think of when they say DFS are abused children, neglected children, and removals. We are actually an agency that's a human services agency. So we have 4 divisions. of which one is social services, as Ms. Gordy is here to speak to. We have economic security, which are a lot of the public benefits that you hear about. TANF, temporary assistance to needy families. SNAP, which is the Supplemental Nutrition Assistance Program or food stamps. LEAP, which is the Utility Assistance Program. Weatherization, which is where we provide services to homes so that they can be weatherized, so that there's a decrease in spending on utility bills. Child support, which is we are the #1 program in the US, 12 years running. Again, Ms. Gordy. We also have child care licensing. We have child care assistance. We also do central registry. We have a fiscal services division. And we also have the youth facilities. So when you think about human services, chances are we manage one or more of those grants. We also focus heavily on prevention. A lot of times we're thought of as a reactionary organization, but what we do try to think about is providing those services closest to the people at a time that they need them. So the way that we've oriented our work around that is through the model of why home matters. And that's just our catchphrase, why home matters. What it tries to do is get people to reorient what they think about families and what it is that they need at home. Our values really come around children safe at home, vulnerable adults safe at home. We really want people, and we know people do better if they're with families or if they're with somebody that they know at home. Opportunities for success, which means that we provide a lot of services, but we also know that we need to provide a lot of support and opportunities to the families in order for them to be successful. And then last, supporting the people who support the families. A lot of this work is done by entities in your communities, not necessarily done by the state through this agency. So providing that support to those folks is very important. So getting a little bit into some of the details, when we think about child protection and adult protection and juvenile justice, we are not the whole system. DFS does not have the authority to remove children from their families. That authority comes through the courts, it comes through law enforcement, and it comes through medical professionals. Now, certainly, we're there many times alongside law enforcement and alongside medical professionals. But when the decision is made that a child cannot live safely at home, that decision is made by law enforcement medical professionals. Once that decision is made and that removal has occurred, then that child is placed with us, and then we find a location for that child. Our responsibility under the law for those children is reunification, which means that immediately we start to look at what it is that family may need for that child to return home or for that child to stay home. There was a long conversation a couple years ago in this committee around what it is that our system does, and I would love to share that again with you if you would like. We have a great presentation that we can resend. About 70% of the children who are removed or who have some sort of court order are reunified with their parents. So they've returned home. If a child has to be removed, more times than not, they're placed either at home with their parents or with someone they know. So when we talk about foster care, a lot of times we talk about foster care in terms of people who are not known to the children or families who are not known to the family. Less than half of the placements go to families who don't know those children. And this is important because we know that children do much better if they're with someone they know. It's a little bit terrifying to wake up the next day after a lot of trauma of removal and wake up in somebody's home while what our foster care providers provide is tremendous. It is pretty tough on a child to be in a new place, to be in a strange place, new rules that they don't know, new foods is a big deal, not sure who else is in the house. All of that is pretty traumatic in addition to whatever was going on at home. So we try very hard to find somebody that they know. And what we do know is in that situation, children will do better, and the research tells us that. We are not an adoption agency. As I mentioned, most of the children go home. Most of the children are reunified with their families. Of the children who do not go home, who are not reunified, a good portion of them go into guardianship. What that means is that the parents' rights are intact, but the children, through a legal guardian, have an arrangement with the court, and that guardian will take care of those children. In some cases, the most severe, children are permanently removed from the families, and the parents' rights are terminated. It's only after the rights are terminated, and that's through the court. It's only after that then our children adopted. So it's a long path to adoption. About 16% of the children over time become adopted out of our system. We work very closely with adoption agencies. We will work very closely, for example, with the Wyoming Children's Society. And once a child becomes available for adoption, which means that the parental rights have been terminated, then we'll either work with them, and a lot of times the foster families turn around and do adopt those children. Another point that I think is important to make is around juvenile justice. And that's going to be a conversation, I think, that will certainly come up through Ms. Gordy in the Juvenile Justice Information System update, but also just in whole as we think about what is happening. We heard a little bit of discussion with DCI, but we are not the sole juvenile justice agency. So when you think of a juvenile delinquent, oftentimes you'll think about what DFS is doing around that juvenile delinquent. The majority of the juvenile delinquents actually are cited in municipal court and circuit court. They do not come to us right off the bat. In order to be adjudicated as a juvenile delinquent in our system, it requires going through juvenile court. A petition is filed by the county attorney. They ask the judge if the case can be filed in juvenile court. The judge will say yes or no. And then that case becomes one of ours. So we are really not the entirety of juvenile delinquents. And that's a misnomer because when you say juvenile delinquent, we have delinquents, but the definition, the local definition is much larger than what comes in juvenile court. There's a lot of discussion about what is the role of DFS in terms of benefits. And you heard a little bit from the Office of Homeland Security, some of the federal implications. One of the programs that is coming under question at the federal level is the Supplemental Nutrition Assistance Program. And so far, out of all of the programs that we manage, that is the one that has really had a lot of conversation. There were suggestions that other funding sources would be reduced, but we have not yet seen it. We have heard, and there is a very real conversation about SNAP happening in house agriculture. I believe that is going to go through, and I believe that that bill will be heard by the larger body. And what they are suggesting is a way to reduce investment into the SNAP program is asking states to have some cost share. So currently our SNAP program is paid for administratively 50-50. We have 50% general fund, 50% federal fund. What Congress is suggesting, or what the committee is suggesting, is that our share of the administrative costs becomes 75% compared to 25% for the feds. That would be an additional $3.2 million a biennium for us. Another consideration is looking at the states paying a portion of the food benefits that are offered to SNAP recipients. Currently, the federal government invests about $66 million in SNAP benefits for Wyoming citizens. So those dollars go directly from the federal government to the SNAP cards, the EBT cards, which are then used to purchase food. So about $66 million right now is the current federal amount that they invest. If we were to go to a cost share, we would start to pick up about $6.5 million of that a biennium. So it's an additional $3 million or so a year. There's a lot of conversation. I won't get into the details because they're going to change at any given time, but they're determining the amount that states will provide based on the error rate for the state. And the error rate is around how well do we do issuing benefits correctly. Our error rate is either second or third lowest in the nation. So at this time, we would have to invest the least amount percentage-wise. Some other states that have higher error rates are going to have to increase their share, I think up to 30% or so. Our investment would be at about 5% based on our current error rate.
To ask questions on specific topics as the director goes through them, or wait till the end?
I would prefer to have the questions as we go. That way you don't have to sit around and think about your question for too long.
So
Go ahead.
Ran with the potential changes to SNAP with funding ratio.
Oh, microphone, Senator Hicks.
Yeah.
You're pulling a Senator Scott there for a moment.
I'm not that old, but I'm getting there. Not an archaeology and so forth. Anyway, so the question, Director, is with these discussions that are going on with the Ag Committee and stuff, and so are they also looking at reform and eligibility for SNAP? I know that's been a discussion in the past as part of that. And is there any discussion associated if the states pick up a bigger portion of that? Do we have some latitude to manage eligibility criteria above and beyond the federal guidelines? So what are you hearing on that end?
Director Schmidt.
Mr. Chairman, Senator Hicks, there is a lot of conversation about the eligibility determinations. For example, households right now qualify for SNAP based on, everything's based on income. So income first, and then there's other things that come into play. One of the qualifications is income, and then children in the household. One of the considerations that they're making is reducing the age of the child from, I think, 15, 16 down to 7. So in order to qualify, because you have a household with children in it, those children would have to be 7 or younger. So that's one of the eligibility criteria. They're also considering increasing the age for work for a group called Abled Bodies Without Dependents. And that's a term that comes up quite a bit in the SNAP conversation. You'll hear it referred to as ABODs, and that's just the acronym. So an able-bodied adult can qualify based on financial criteria for SNAP benefits with a lot of different kind of requirements. But this group of recipients are required to work. So currently, I think the work requirement ends at age 59. What the proposed legislation would do is increase that, I think, to 64. So there would be, the work requirement would last longer for that population.
That specific issue, it seems to me like the states do have some flexibility for the work requirements for the able-bodied adults to work on some of those criteria. Is that correct or incorrect? That we have some latitude to set those parameters also.
Director Schmidt.
Mr. Chairman, Senator Hicks, we do, but we do not participate in any of those waivers. So other states can ask the federal government to waive some of the criteria in order to change the eligibility. We follow strictly the federal rules, so we do not have increased utilization based on a waiver. The other comment I'd like to make, though, is that there is a lot of conversation about the flexibility potentially given to states if the states are going to have to invest their own funds. There has not been a lot of conversation about that yet, that level of detail. What I would expect to happen is that they will allow states to ask for waivers. So depending on maybe what it is that we would like to do, I would imagine, and this is just reading tea leaves, that then we would put together a proposal, submit it to the U.S. Department of Agriculture, and then they would make a decision as to whether they would allow it.
You got a question over there?
Yep, Representative Kelly.
Thank you, Mr. Chairman. There have been repeated references to the amount of money that's invested into the Supplemental Nutrition Assistance Program. considering it's a substantial amount of funds that we're talking about investing here, does the agency have any estimates or any expectations for our return on those investments?
Director Schmidt.
Mr. Chairman, Representative Kelly, that's a good question. And nationally, I know that there's been a lot of research done on the return on investment. We've not done anything on Wyoming, but I'm happy to get you that national data.
Representative Kelly.
So would it be fair to say then, thank you, Mr. Chairman, to say then that we're not investing, we're spending money on these programs, not investing?
Director Schmidt.
Mr. Chairman, Representative Kelly, that's fair.
Okay, Senator Kolb.
Yeah, thank you, Mr. Chairman. Well, nice to see you again, Director Schmidt.
Thank you.
The question I have is the definition of a Wyoming citizen. Does that involve legal status, non-legal status for, that the conversation we got currently going on in our country? Or is that blind to the status of said person applying for assistance? And I guess then the next follow-up question would be, what is your thoughts on that? Are we then hemmed in by the federal government, to continue doing something that maybe we don't like or we disagree with? So I guess I'd like to have a cleaner definition of what a Wyoming recipient of this benefit is. Thank you.
Director Schmidt.
Mr. Chairman, Senator Kolb, each of the definitions come by program. So depending on the grant that we're administering, the definition of citizen would then be reflective of that. Most of our programs do not provide benefits to people who are here illegally. However, in the case of a child who is allegedly abused or neglected, or a juvenile justice issue, or a child in need of supervision, or even an adult protective services, citizenship is not a factor. If there's a harm that we suspect, regardless of the citizenship of that family, that child, we will take protective custody if necessary.
Senator Kolb, follow up.
Yeah. Thank you, Mr. Chairman. Yeah, I wasn't referring to a child who has had issues of that nature, mostly to just the facts of how we're giving out these type of food stamp benefits and, what the criteria was only under those circumstances. Thank you, Mr. Chairman.
Director Schmidt.
SNAP is what? U.S. residents only, right? Okay. Mr. Chairman and Senator Kolb will get an outline of the requirements for each of those programs because they do differ.
Okay, thank you. Representative Filer.
Thanks, Mr. Chairman. Director Schmidt, pivoting away from SNAP program a little bit. I was wondering on the foster care, it's kind of a two-part question, I guess. What are, if any, challenges with placing children with developmental disabilities into foster care? And also, is there a different criteria for foster parents to be able to accept a child with developmental disabilities? And I know this comes up for years ago when I served on the DFS advisory. This was a big issue then. And I'm just kind of seeing maybe how we're progressing along with that, because I know there children with developmental disabilities, we have per capita pretty good large population of that in Wyoming.
Director Schmidt.
Mr. Chairman, Representative Filer, those are all very good questions, and I'm going to get a little weedy, so forgive me for a second. So when a child comes into protective custody, and let me back up even further, when there's a case filed in juvenile court, whether it's abuse and neglect, a child need of supervision, or juvenile delinquency, the court then assigns what's called a multidisciplinary team. And the multidisciplinary team, of which DFS sits, the county attorney sits, the child's attorney, which is a guardian ad litem, possibly a public defender, education, and then also mental health therapists if there's one assigned. Education is a part of that group. That multidisciplinary team is responsible for working with the family throughout the case. So they do the case planning. They make the recommendations to the judge, and then the judge either upholds those recommendations or overrides it for some reason and then goes on the record stating why. So the decision-making that happens through that court system is done through the MDT. If a child has special needs, if a child is on an IEP, then technically that multidisciplinary team should include somebody who's familiar with their IEP. And while that's educational, it's from that conversation that we can learn and know more about what a child may need in foster care. So when a child is possibly placed with a family, we don't necessarily screen for that, but we will provide opportunities and assistance to be able for that family to be able to take care of that child. We have flexibility within our funding to be able to increase the amount of subsidy or foster care payment that we make in order to help that family with the additional costs that would come with serving a child with developmental or medical disabilities.
Follow up, Representative Filer.
Yes, thanks, Mr. Chairman. And then just, because I'm talking 10 years ago, I knew there was it seemed like there was always kind of a roadblock when you had a child with severe disabilities or anything like that for any foster parent to even want to accept a child. So that, you know, the DFS was always trying to find ways of, you know, how do we place this child into the right care, or does the child end up going to a state facility? Are we seeing those types of issues decline in the last 10 years, or do we see that still being a problematic?
Director Schmidt.
Mr. Chairman, Representative Filer, you are tapping into some of the most difficult cases we have. And at any given time, we have about 15 to 20 youth, usually youth, mostly adolescents, but they do get younger, where we have a very difficult time finding an appropriate placement for them. One, because they may be developmentally disabled, but two, because sometimes they come with a lot of behaviors. And so we have what's called the Interagency Children's Collaborative, which is a very high-level case management group, of which the Department of Ed sits on, the Department of Health, the Department of Workforce Services, and the Department of Family Services. And what we do through that group is we scour all over the country for any type of opportunity where a child can get what they need educationally, behaviorally, and then, of course, whatever mental health or substance use disorder issue that may also occur. But yes, placement is difficult for a lot of those youth. And I think you would hear Director Johansson with Department of Health echo the same thing.
Co-Chairman Washit.
Thank you, Mr. Chairman. Two questions. One I hope is pretty quick, and the other one will be a little more in depth. The tobacco settlement money you mentioned, was that a one-time cash settlement, or is there ongoing funding from the tobacco industry that will go into perpetuity or for some extended period of time into the tobacco fund? And I know Wyoming's done a lot with utilizing that money as it was intended for prevention efforts and so forth. But my second question has to deal with Representative Kelly's question, and that is, you know, whether or not we can look at a cash payout as an investment requires some, I would think, longitudinal data of what do we get in return. You know, if a child is hungry and a government program provides for that child to have adequate nutrition, I would think there'd be some benefit at some point, right? But if we don't have good data on these programs, their participants, certainly in the juvenile justice arena, you know, my concern is that we've got a lot of young people who are gobbling up resources in DFS, education, juvenile justice, and then in the future, they gobble up resources in adult corrections and law enforcement and mental health, yada, 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 right? And so how do we know whether those programs that we're providing are doing any good? Which ones are better than others? And my sense is we don't have really good data on all of that. So 2 questions.
Was that 2 questions?
It was.
Director Schmidt.
Mr. Chairman, Mr. Co-Chairman, two questions, one of which could take a day. So to answer your first question first, the Tobacco Settlement Fund was originally an investment by the tobacco companies into a large fund, of which the corpus was the major investment, and then the interest is what was spent on a lot of the programs. I kind of looked to the Attorney General's office for that information because they are the ones that actually manage that fund. We're just the recipients of it. But I do know that the interest off the corpus is a lot of what has funded the mental health substance use efforts throughout the years. And that's been, 10, 15 years now, I think, of Tobacco Settlement Fund. To answer your second question, longitudinal data, and I think, this committee heard our request for a conversation around the confidentiality statutes that we have. And the Department of Family Services confidentiality statutes, especially around our juvenile court cases, so that's our children in need of supervision, our abuse and neglect, and our juvenile justice and adult protective services, those statutes are pretty old. I think they were written originally in the 70s. And so our ability to participate in a lot of the longitudinal studies that you're suggesting can be very difficult. For a very long time, what had gotten in the way was just technology, the inability of the systems to be able to talk to each other. But as technology has improved, what we're finding is that now some of the roadblocks we faced come with confidentiality statutes. So when you ask us about the return on investment, and I'll give you the community juvenile service boards as an example. The state invests or provides money to communities through the Department of Family Services for diversion programs. Those services are provided to juveniles in any community, not necessarily youth that are involved with the Department of Family Services. So these are youth that maybe were cited in municipal court or circuit court, but for some reason have not been to juvenile court. The Juvenile Justice Information System, which Ms. Gordy's going to speak to in a minute, is a data collection system that was just recently created that can gather some data, but it doesn't gather all of it. It's a starting point. However, if that diversion program, for whatever reason, didn't take hold and that kid ends up in juvenile court, we wouldn't be able to tell you that. Because the way that our statutes are written right now, we would not be able to talk about the fact that what happened to that youth if they moved on from a citation into a higher level of care. Juvenile court, you can only access the Wyoming Boys School or the Wyoming Girls School through a juvenile delinquency petition in juvenile court. So that's the highest level of sanction for juvenile delinquents in Wyoming. They may go to jail, but that's usually because they've been tried as an adult, not necessarily as a delinquent. There's a lot of caveats there. We do have kids that go to detention centers. So when you talk about longitudinal data, we really do not have a good handle on being able to connect all those dots. Some of that, as I said, is confidentiality statutes. Some of it is still IT and old systems just not able to talk to each other.
No more questions like that. It throws the agenda off, Co-Chairman Washington. Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, Ms. Schmidt. My request is for the presentation of reunification. Would you be willing to send that to me by the end of the week?
Chairman Olson, Representative Lean, yes, it's a few years old, but we'd be happy to send it to you.
And Mr. Chairman,
Representative Lean.
Mr. Chairman, Ms. Schmidt, my next question is, you talk about adoption versus reunification. At the 16% that are adopted out of DFS care, can you tell me about the benefits that follow that child?
Director Schmidt.
Mr. Chairman, Representative Lean, it depends. Sometimes 4E adoption. So 4E is a federal funding source that we receive. It's a shared source of funding. So the state pays a portion and the federal government pays a portion. That is a funding source that can be available depending on the conditions of the case. So meaning what does the family need? What does the child need? And then we will pay an adoption subsidy. We also do that with guardianships as well. And then those benefits will last until the child turns to an adult. Some youth are also able to continue with Medicaid benefit after they turn 18 as well. I also believe adoption can include Medicaid benefits as well.
All right. Is that it for you, Director?
And now I'd like to
Ms.
pass
Gordy?
it over to Ms. Gordy, who's going to give you an update on the Juvenile Justice Information System.
Okay, let's do that.
All right, Mr. Chairman, Mr. Co-Chairman, members of the committee, my name is Christy Gordy, Senior Administrator of the Social Services Division with the Department of Family Services. So very specifically, as Director Schmidt said, here to provide you an update on the Juvenile Justice Information System. You are the home committee for that report. This legislation was amended and put into effect in the 2022 budget session. It went into play, however, just last year in 2024. What it did was transfer responsibility from DCI to the Department of Family Services as it related to the data for juvenile justice. Really, the effort was to provide more systemic collaboration and data management around this. As Director Schmidt mentioned, there are a lot of different data sources and a lot of different agencies that are involved with juveniles when we get to this conversation. So really done in an effort to try to have all of the data collected and maintained in one area to be able to do some more interagency collaboration around that data. And also a huge part of it was also the protection of that data as we are dealing with juveniles. So the Department of Family Services we also at that same time had funding to update our child welfare system, which includes for us juvenile justice as well as adult protection, so quite a large system. We received funding to update that large case management system. When we received this, the JJIS is what we call it, the Juvenile Justice Information System, responsibility, we leveraged the same vendor we were using to build our new case management system. So we engaged with that vendor. The JJIS system went live, which I will caveat a little bit, went live last July. So July 2024, that system was up and running. However, we were not using it because there was a lot of things that still had to be done with it, such as getting data. So right now, and we have been working very closely with Ms. Butler and the Supreme Court and her staff because the data source for JJIS is the courts. So we have a mechanism that now is weekly that we will get data from the court. It is data that is laid out in statute and also in our rules. Our rules just around JJIS went into effect just a week or a week and a half ago. So we were also waiting. We couldn't quite use the system until we had rules to manage the data that's in that system and to have the mechanisms around it. So we are currently, I think we started doing testing around data in February. We have moved data from the court into JJIS. The initial push of data was over 30,000 records. And then that is being updated weekly. So we get the data. They're kind of our source data record is the court. So there is, like I said, the data elements are laid out in statutes such as name, social, some of that demographic data. There is some data that we want to know or that is within the system that doesn't necessarily come from the court. So the statute authorizes entities, DFS being one of them, that manage probation. So in some counties, there's county probation to also update and enter data. So that data they cannot change the data that comes from the court. They can only add to it, which would include placement data, potentially around community service and maybe potentially around payment of restitution. So we are currently that access has not yet rolled out. We anticipate that we will roll out that access to Department of Family Services probation workers later this summer, and then we will work with the counties. So very specifically, Campbell County, Fremont County, Carbon, Converse, and Sweetwater all have county probation. So there may be children or juveniles on probation that they are not within the Department of Family Services cases. So we will be working with them on how they can access that and update records. So then the other purpose of this data is then to have access to those who can then use the data. So there is an external portal, again, hasn't yet rolled out because we haven't quite had the data or the rules in place for it, for access. So from an external portal, law enforcement and county attorney offices will be able to access data that is in JJIS, really by search. If they're working with a juvenile or juvenile has come into, they've encountered a juvenile, in whichever aspect they've encountered the juvenile, they can look into the system to find any data that may live within that system. There is also a form that lives on the department's website, which is requests for data. Those requests are requests that could be made by a juvenile who wants to see his or her own records. But there is also the opportunity through statute and through rules for somebody doing bona fide research to make a request of the data in the JJIS system. That comes through a form and goes through a process for review before that data would be released. And all that, again, is all done by our rules. And Mr. Chairman, Mr. Co-Chairman, I will admit, we are late on our annual report that is due to this committee. It is due March 1st. However, because we were finalizing rules, we did wait. That report is ready and will be sent to you tomorrow, along with copies of the rules that were just established.
We were just about to issue a very stern letter.
Thought I would just hit it on its head, so.
Okay.
Another component that has been a conversation of topic when we talk about juvenile data that is allowed in the statute that I just want to hit on is there is the opportunity for a juvenile through court to ask for their records to be expunged upon reaching the age of 18. If there is a court order that has to go through court, that is nothing the Department of Family Services is a part of. That is a separate action. If a court issues an expungement record, then we within this system have built through the technology the ability to then expunge that data out. Therefore, it is not accessible or available upon any type of request or look into the system. There's probably more data to provide you around that, but I'll just stand for any questions.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. My question is about the storage of files. How long do they remain within your system after they turn 18?
Ms. Gordy.
Mr. Chairman, Representative Lean, I believe and I'll lean a little bit to the director, mainly because I know there's been conversations for quite a few years around this. That data will remain when they turn 18, but very specifically in the JJIS system, that data will go, the system is built in a way that when they turn 18, the data will no longer be within JJIS. There is a storage component in which that data would live, specifically for the Department of Family Services. I believe it was around 10 years that we discussed for other reasons that we would potentially need that data for audits, but I'll look at Director Schmidt. So I don't want to misspeak.
Director Schmidt.
Mr. Chairman, Representative Lean, we were close.
Yeah.
The JJIS records are very different than our case records that we gather through juvenile court. So I think to make that distinction, expungement says any case, anything involving that person who requested their records be expunged, with the exception of in our case system, what we call WyoSafe, for up to 10 years, because there's a lot of financial audits that could happen around because we pay for a lot of those services. So after 10 years, we can expunge, but that's upon request. That's expungement. That's a little different than retention. And I believe our retention rates for our WyoSafe cases is about 99 years, if I remember correctly. And there's some caveat. There's 50 years and for some, 99 years for others. And some of that has to do with actually just over time, in terms of when we're doing an investigation potentially, does that family have a record with us? Has there been other issues? Do we have other people? But then we destroy all the records, and I can get you the retention schedule specifically.
All right. Co-Chairman Washington.
Thank you, Mr. Chairman. So am I correct that if there's an expungement, then all that data would be lost to any longitudinal research to try and figure out the flow of people out of your system who then go into the mental health system or adult corrections.
Director Schmidt?
Mr. Chairman and Mr. Co-Chairman, so JJIS is a different source of data that comes from the court. In our WIOS safe system, which is anyone who we opened a case because of substance or because of abuse, neglect, adult protective services, child in need of supervision, or juvenile delinquency. Those are the court actions that can occur. Those cases would stay in there until the retention record says to dispose.
Senator Hicks?
So question for you, is there anything that you can foresee through this summer that you're going to need from this committee?
Director Schmidt?
Mr. Chairman, Senator Hicks, it would be nice to have a little bit more conversation around the confidentiality statutes. And the reason why I bring that up, I know that the committee last year, the Mental Health and Vulnerable Adult Task Force, took it up. Joint Judiciary then accepted it as a committee bill. And then it went to the House, and the House then defeated further progress on that bill. It did get brought back up on the Senate side, and it passed the Senate, and it went to House Labor, and it almost passed there. So I would just maybe like an opportunity to provide a little bit more information about the whys and hows of what we were asking, and giving more information about what we were trying to do around keeping that data safe. I know there was a lot of questions about potential breaches and electronic issues. Those issues are going to exist no matter what, and just giving some opportunity to explain a little bit more detail about why we think that data would stay safe and would not be involved in a lot of public consumption.
Senator Hicks?
Mr. Chairman, in the spirit of educating the committee, again, it's a little different situation with a new election cycle. I would strongly recommend that the chairman might want to bring that bill back for edification for the committee and maybe take a look at it. I just think it's something that wouldn't take a lot of time, but I think it's worth looking at.
And Mr. Fuller, let's put that bill draft on that would be, I don't remember the bill number, but that was my bill from last year, and then the committee bill before that. So let's just put that on the agenda. All right. Anything else for the Department of Family Services? If not, despite Co-Chairman Washett's compound question, we're only 6 minutes behind. Thank you. All right, and with that, we will move to the judicial branch. Start with Ms. Butler, and we have some dignitaries from the Supreme Court, the District Court, and the Circuit Court today for a couple more days. All right, welcome. Thank you for joining us in person.
I'm Chief Justice Fox for one more week. I thought I would take this opportunity to come and speak to the Joint Judiciary Committee since it's my last chance. And for one thing, thank you all for your attention to matters of the judiciary, and also to say to you one more time, what a great branch we are. And I mean that so seriously. We have just 57 judges and justices and around 300 support people. And together we keep on deciding the legal disputes of the people of Wyoming, keep business moving, keep communities safe, and apply the laws and the Constitution of Wyoming in a consistent and really professional manner. But I should do some introductions first. We have Elisa Butler, our court administrator, Judge Buchanan, District Court Judge here in Torrington, and Judge Chambers, Circuit Court Judge in Laramie County. Also, there she is. Justice Boomgarden is here. She will be taking over as Chief Justice, so say hello. You'll get to be more familiar with her in the next 4 years. I'm happy to answer any questions that you might have, but I did first want to give my strong support to the judicial branch, to the work that we do here, and to the way that we select our judges. Our judges are chosen for their performance, for their objective job qualifications, and because, as I said, we get the job done. We did have a handout, which I think Judge Buchanan will talk about a little more in Judge Chambers, so I'll leave that to them. But I wanted to talk about just initially, and I think you know this, the members of the committee, but it's important to make sure that people understand in Wyoming, we have a different system than the federal judges. You hear a lot about federal judges in the press, and we could see that first one. I have huge respect for the federal judiciary, but that's not Wyoming. Wyoming has a different system. It's much less political. We have judges who come, for the most part, from their communities. They're lawyers who've lived and worked in those communities and represent their community's values. So I just wanted to show you this page in the PowerPoint that I think has already been distributed to you, to illustrate that the Wyoming judiciary is very different from the federal judiciary. And like many things in Wyoming, we do things much more efficiently and in a pretty direct and plain spoken way. We just really provide a framework in which people can operate and conduct their business with the greatest degree of certainty. So not everything we do is popular, of course, because guess what? There's always a winner and a loser. But I think that what the courts do in Wyoming is generally respected. And the polls show that, actually, that the people of Wyoming do have confidence in their courts. And that's because we apply the law and the Constitution to the facts of each case and set aside our personal preferences. Sometimes we decide cases. A lot of people are surprised by this, but I think every judge will tell you sometimes the way we rule on a case isn't what we personally would have preferred, but it's not our job to do our personal preference. It's our job to know the law and the Constitution, to become familiar with the facts, to listen to the arguments of the parties, and to reach the conclusion that's driven by our training and the law. So with that, I would be happy to take questions or just turn it over to Judge Buchanan.
Okay, let's see if we have any questions for the chief. If not, we'll move forward with the presentation. All right. Judge Buchanan. I'm not sure if I call you Mr. Speaker, Mr. Secretary. I guess it is Judge.
Well, thank you, Chairman Olson, Chairman Washat, members of the committee. I know many of you, and for those that I don't know, welcome to work on the judiciary. In my humble opinion, the best standing committee there is in the legislature, because you get to do a lot of different things. Today, I was asked to come to present and just kind of give a very simple overview about the court system. And you'll see the slide in front of you shows you that we are divided into 9 separate districts. As you can see, for example, some of those are a single county. So district number 1, Laramie County, has 4 judges commensurate with the volume of work that they do. And then, for example, where you sit today in Torrington is district number 8, and we cover Goshen, Platte, Converse and Niobrara. I have a counterpart in Douglas, Judge Peasley. So between the two of us, we travel back and forth, taking pretty much every other case that occurs in Niobrara County and over in Platte County. And that's how we get things done there across the state. Just as a reminder, and most of you don't need this reminder because you are on the Judiciary Committee, but if you look at the Wyoming Constitution, Article 2, the Wyoming Constitution sets out very distinctly and succinctly the powers that are given to the judicial branch, as well as the separation between the judicial, the executive, and the legislative. And just to kind of follow up a little bit on what Chief Justice Fox had stated, the Constitution specifically mentions that the courts will be open to everybody who has some type of grievance, whether it's an injury done to themselves, their property, their reputation, and justice must be administered without undue delay, without sale, denial, etc. So that's something that we take very seriously in our jobs, both at the district court level and at the circuit court level every day. And in just a few slides, you'll see some of the numbers we deal with on a fiscal year basis. And there's going to be a breakdown of the different types and kinds of cases that we hear each and every year. First, I'm going to follow up a little bit on some of the comments about judicial selection. As was mentioned, we went away from the old model in 1971, I believe, by a constitutional amendment. And as you can see with this slide, the process works with 3 attorneys that are selected by the bar, 3 non-attorneys selected by the governor, and then the Chief Justice presides over those matters, but as a non-voting member. And you can see the rest of how the process works. I thought we would touch just momentarily on the length of the terms of the different judges, depending on where they sit. So Supreme Court is 8 years. For me as a district court judge, it's 6 years. Chancery Court is 6 years, and then Circuit Court is a 4-year term. And at the end of that term, there is a retention election in the general election year, basically stating should Judge so-and-so be retained. And that's a yes or no vote that is put to the people to see if the judge can continue to serve another term for the requisite period. All right, some of stats for my own court, district courts, and this is statewide fiscal year 2024. As you can see, there's a little over 13,000 cases that are handled on an annual basis. You can also see there that domestic relations takes up most of, not a majority of what we do, certainly, but out of everything we do, that's what we handle more than anything, or domestic relations, family law, custody matters, child support, and things along those lines. That's followed up by our criminal docket, as you can see. And then the balance is taken up by general civil cases. Those are cases that are above $50,000 in alleged damages. That's our jurisdiction. And then you can see probate. And then we're also the juvenile court. So we handle abuse, neglect, children in need of supervision, as well as juvenile delinquency cases that seems to take up, in my opinion, more and more time every year. One thing I'd like to mention that we do in addition to this, and I'm only speaking for myself, I know a number of the courts do this. I have a Liberty Day, a Constitution Day, and one we kind of invented called YOLO Day, which is you only live once. And the idea is to bring kids in grades 5th through 8th grade. I'd like to expand that a little bit into high school because I think it may hit home a little bit more for the high schoolers. But the idea is to teach kids about the Constitution early, tell them about the process and why our constitutional republic works as well as it does, and kind of impart that knowledge to supplement perhaps what the local school district is teaching, so that they really have a good idea of what the judiciary does. And then on the You Only Live Once Day, We try to bring in and use a case example and bring in somebody, if they volunteer, and we've been successful at this, having someone who's been on probation or someone who was a juvenile and is now an adult to come in and talk to kids about kind of when they started going the wrong direction and their involvement in the court system, and basically teach kids that you only live once. And so you have to make the correct choices in life, or there are consequences to those choices, and kind of how the system can play out. Hopefully to get across that message that prevents them from being the next statistic and us seeing them in adult court. I'll now, and maybe we'll, Mr. Chairman, if we want to wait till the end for questions, I was going to turn over this presentation to Judge Chambers, because he's got some circuit court statistics to share with the committee.
Sounds good to me. Judge Chambers?
Chairman Olson, Chairman Washut, thank you for having us here. In the circuit courts, you'll often hear referred to as the People's Court. It's your sort of entry-level court. Your basic run-of-the-mill cases happen there, disputes between neighbors, the sort of things that happen quick, that happen, not according to a long, drawn-out docket schedule. Things happen really fast in the circuit court. I'm in court in Laramie County morning and afternoon, 5 days a week. It's very busy, very fast paced. And I think generally speaking, when you hear about somebody talking about that they've had to go to court or something, it's probably about a traffic citation or something like that. And it's most likely that they went to a circuit court. And if you look at the pie chart up there, I think of the circuit courts as having, in the statistic there, 97,852 cases. That's representative of how fast things happen in the circuit court, the volume of cases that happen in the circuit court, and sort of that people's court mentality that is a lot of things happen in the circuit court. And then the pie chart, I think of the circuit court as involving 6 types of cases. That's how I always describe it. And I think that's pretty much what that chart shows. The biggest part of the chart is, we label it traffic court, but I think it really should be called citation court. That's any time that law enforcement issues a citation on the street, that an arrest does not happen. You're given a citation, says, you can either must appear at court on this time, or you can appear and contest the citation, or you can pay the citation, whatever the fine is, if it's a fine only offense, and just deal with it that way. I think the majority of that slice of the pie is traffic offenses, speeding, equipment violations, CDL violations is a very growing thing. Those happen in traffic court. No insurance, no registration, no driver's license. I call that the trifecta. A lot of people get those. It's a very common combination of offenses. And what you would traditionally consider as traffic type offenses. Somebody is given a citation on the street by law enforcement and said, either you must appear in court if it's that type of citation, or you may appear. And if it's a may appear, you could simply pay the fine and be done with it. The other type of traffic court case that is, I've been on the bench almost 5 years, and more in that time, very common now, certain misdemeanor possessions, misdemeanor possession of marijuana. A week ago, last Thursday morning, my traffic court session, I wrote these down. I think I had 25 must appear citations for my traffic court setting that morning, and 14 of those were misdemeanor possession of marijuana. So it's very, very common, particularly in those communities along the interstates. They're close to, say, Colorado. When law enforcement stops somebody that's in possession of marijuana, they're generally issued a citation that says you must appear in court. And it's striking. In that 5 years I've been on the bench, it has become very, very common that misdemeanor possession is cited into traffic court. The other types that we see more and more in traffic court that weren't the case even 5 years ago, your retail theft, low-level theft that occurs, somebody stealing things at Walmart, or, under-scanning is a common thing. Somebody that walks out with $500 worth of merchandise and is only paid for $400 of it. They're generally issued a citation. And again, law enforcement makes those determinations case by case, whether it's appropriate that for that person that's in possession of marijuana or that has committed retail theft or those other things, whether it's appropriate in that situation that they be given a ticket on the street and says, you got to go see the judge. So traffic court is really expanded in the 5 years I've been on the bench. That is more than just traffic citation. That is pretty much the breadth of low-level misdemeanors that happens to include traffic offenses. The other slice of the pie up there is criminal, and that is the cases that folks are actually arrested on the street, are actually taken into custody, and are actually making their first appearance in a criminal case before a circuit court judge. That includes both misdemeanors and felonies. If you just set aside municipal cases, that's sort of a different thing. Every single misdemeanor offense, every single felony offense in Wyoming starts in a circuit court. They get their initial appearance from the detention center. They're read their rights, advised of the charges, appointed an attorney if as the case may be. And in the case of felonies, they are entitled to what's called a preliminary hearing, which is held within 10 to 20 days of their first appearance, and it's a probable cause hearing. Is there probable cause that this felony offense was committed and that this individual committed it? And then at that point, if probable cause is found, they're bound over to the district court and the felony cases proceed from there. Otherwise, all other misdemeanors, any type of misdemeanor that appears in the Wyoming Criminal Code starts in the circuit courts. Similar thing, read their rights, make sure they're advised of the charges and are appointed an attorney as the case may be, and the case proceeds from there. And those are the two types of criminal cases. We have traffic and then the criminal that I just described. Civil cases fall into the following categories. General civil is anything under $50,000. Everything over $50,000 is in a district court. Under 50,000 is in the circuit court. And I would say that the bulk of the general civil cases in that category in the circuit courts are collections, whether it's, credit card debt, medical debt, other types of things where a collection agency is involved and there's a lawsuit filed for collections. That's the majority of those, but we do see your, the types of things that you would imagine appear in civil courts, traffic accidents, personal injury, those types of things that can and does appear in the general criminal filings in a circuit court. Small claims are cases where there's money damages of $6,000 or less. That's Judge Wapner in the People's Court. That's neighbors suing neighbors. Could be collections. I've had people suing each other for dogs and, minor traffic accidents. And I think you talk to most circuit court judges, they'll say that they really enjoy the small claims. It's a one-page complaint that they file. It's served by the sheriff. And they appear in court. And when you walk into court, you're like, it's the Wild West, right? You don't know what you're going to walk into. It could be anything from tort injury damages to contract claims, warranty claims. It is really, you walk into court in a small claims dispute and you've sort of stepped into a first year law school exam. Like, what is this? And you got to wade through that and do it very fast. It doesn't, it's no taken under advisement, no take it back to your chambers and deliberate about it and talk with your colleagues about it. Happens right then. They get a decision right then. Take the evidence, issue the decision. Tell them who wins, who loses, and why. Next category is forcible entry and detainer. That's your eviction. When a landlord is evicting tenants for non-payment of rent or violations of leases. That's very common. I'm kind of surprised that it's that small on the chart there, but I think probably every circuit court judge in the state has at least one, probably more, eviction cases on their docket every single week. I know in Laramie County, all three of the circuit court judges, we probably do 3 to 5, sometimes more per week, each of us. It's very common. The next category would be protection orders. Those are 3 kinds of protection orders: domestic violence protection orders, sexual assault protection orders, and stalking protection orders. This is where a petitioner has come to the court and alleged that they are a victim of either domestic violence, sexual assault, or stalking, and are seeking a no contact order from the court. It's a very quick proceeding. You take evidence, rule on it, but it's incredibly consequential. With domestic violence protection orders, it comes with if there's a domestic violence protection order issued against somebody under federal law, that person cannot use or possess firearms or weapons. I always tell respondents in Laramie County that if you have a protection order issued against you, it's one of the easiest ways to get arrested in Laramie County, because you send a text message, you communicate through to the protected person through a friend or some indirect communication. That is a violation of the protection order. It's a violation of the court's order, and it's very consequential for a proceeding that happens very quickly and with a relatively low burden of proof. There's heavy consequences that come with having a protection order issued against a person or violating that protection order. So those categories cover that chart there. A couple other things. Treatment courts. I know there were treatment court bills and discussions on treatment courts the last session. I think all of the treatment courts, I think, are in circuit court. Is there any district judges?
Judge Kervin in Buffalo.
Okay. So it's not required that treatment courts be in circuit courts, but generally speaking, except for Judge Kervin in Buffalo, all the treatment courts in the state are run through a circuit court judge. Again, that's not a requirement. It's just sort of how it has worked, and I think works very well actually that way. The last thing I wanted to mention in terms of things that we see, weddings. I don't really think about that, but the courthouse wedding happens in circuit court. Somebody comes to get married, they get their license at the clerk's office, then come up to the circuit court and get wedding. I think that's one of my favorite things to do. I think for the most part, that's one of the rare cases where people leave the courtroom happy, I think. You know, it could be a small thing. Sometimes people have to recruit others in the courthouse to be their witnesses. Other times, you know, everybody comes all dressed up and happy and flowers and the whole thing. Professional photographer. It's a lot of fun.
You don't get to see them when they come back because they go to Judge
They
Buchanan.
go to Judge Buchanan, right? Right.
So it is all happy for you.
Yeah, I get the good side of that bargain. Last thing, I wanted to give everybody an open invitation to come to my court. And if you can't make it down to Laramie County, to Cheyenne, find the local circuit court judge in your jurisdiction. It is where it's happening. In my view, it's busy, it's fast paced. I tell people that there's nothing I do that's secret. There's very few cases on my docket that are confidential. A few juvenile type things and a few sexual assault related things are confidential by statute. Otherwise, everything I do is out in the open. It's for the public to see. You could come hang out in my courtroom and see what happens, see these crazy small claims cases I have, or shadow me for a day. You can come hang out with me all day long. in and out of chambers, in and out of the courtroom, up and down all day long. It's exciting, it's interesting, and anybody here, or any of your colleagues in the legislature are invited to come see my court. I've been extending this invitation for all 5 years that I've been here. Representative Singh is the only person that has actually come to the court. So thank you, Representative Singh, and any. Thank you.
Was that circuit court criminal or traffic?
Yes, Mr. Chairman, that was a voluntary time there. And I would like to say that it was incredibly educational, and you really get to see the type of business that your own community is dealing with, and the work that our judges are doing are for the betterment of our community. So thank you all for being here today.
Mr. Chairman, I know it's past your lunch break, so maybe we'll just run through these last slides. This slide, well, let's go back to it. Yeah, that one is the circuit court workload broken out by time spent as opposed to numbers. So you'll see criminal then takes up a lot more space than traffic, but it gives you an idea of how much time the judges spend on each category of case. And then next we have Chancery Court. As you'll recall, many of you will recall, in 2019, the legislature instructed the Supreme Court to set up a Chancery Court. It's a business court, which is designed to resolve all types of business cases, no jury trials. It's expedited. And we have those numbers, as you can see, have grown over the years since we got it started. We now have a full-time judge, Judge Birmingham, to do the Chancery Court work, and it's going really well, and I think will be a boost for Wyoming businesses. And then we have, I think, Supreme Court stats are next. As you can see, roughly half of our appeals that we see in the Supreme Court are criminal cases. And then, you know, the distribution of generally what we call civil cases, and that's everything that's not criminal. Again, as I keep saying, we just do the business of the people. We try to get it done as expeditiously as possible. Is that it? Do we have more? Oh, well, we can't forget the Administrative Office of the Courts. That's Elisa Butler's shop, and she runs it extremely well. That, you know, as you already know, because of all the other work that you're familiar with, it takes a lot of support to do this work: technology, HR, education. And we have, again, a very lean and effective team that does all of that. So, yeah.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, Chief Justice, and to the rest of you as well. My question has to do with the Supreme Court vacancy. I was curious to know how many people applied for that vacancy.
Chief.
Mr. Chairman, Representative Lean, I'm trying to remember how many applied for that vacancy. Do you remember, Justice Boomgarden? I think it was a dozen. I think it was 12. And I was a little surprised by that number because the last vacancy that we had about 2 years ago was more like 20. Mr. Chairman.
Representative Lean.
Thank you, Mr. Chairman. As a follow-up, can you tell us who those applicants were? And if it wasn't given to the public, why was that information not presented to the public?
Chief.
Mr. Chairman, Representative Lean. No, we do not divulge the names of the applicants to the public until the 3 names are selected that go to the governor. That is according to the Judicial Nominating Commission rules. And I think the philosophy behind that is that it would, 2 things. One, almost all the applicants are practicing lawyers who have a practice. And so many of them do not want to discourage their clients from continuing to do work with them, you know, and on the chance that they might be leaving to take a judicial job. I think the other reason is to have a certain amount of insulation from political pressure. because judges are meant to, their primary function is to adhere to the laws and the Constitution and not to any sort of political position one way or another. And so during the, so the Constitution has written into it a 90-day period from the notice of the vacancy to when the governor selects. And this is one of the great aspects of our system, is that we don't have vacancies for a long time. We fill them so people can keep doing the work. But so during the initial 60-day period, when the commission is working, that piece of it is confidential. Then the 3 names go to the governor. And at that point, the governor, who, as you know, is an elected official, does take a lot of comment from the public. And there is where the public can weigh in on whatever they want to weigh in on in terms of the governor's selection. But the idea is to have that balance so that there is some period of confidentiality before the crowd is narrowed down.
Representative Lean? You done?
Well, I have more, but if they want to go, I'll let them go and then I'll tail it.
Okay. Who wants to go? Representative Bratton? Go ahead.
Thank you, Mr. Chairman. Thank you, Chief Justice. So my question is more about the general other judges being appointed as well, like that whole process. So my understanding, the Chief Justice and 3 attorneys is selected by the Wyoming State Bar, 3 non-attorneys chosen by the governor, but the Chief Justice can, would vote during a tie.
Chief.
Mr. Chairman, Representative Bratton. Yeah, that's right. So the governor chooses 3 members of the JNC who are non-lawyers. 3 lawyers are elected by the Wyoming Bar, Wyoming lawyers. The chief serves. I only vote in the case of a tie. And in my 4 years, I think that happened twice.
That was going to be my next question is,
Representative Bratton?
Chairman, is if that had indeed happened, or how often that happens. So it seems to me that really the governor, since the governor appoints the Chief Justice and the 3 non-attorneys are also chosen by the governor, well, one could argue that that is 4 votes, Mr. Chairman. So that's just something that I have heard. And then I have another, may I follow up?
Sure.
Then also, are those judges' names are also not made public? Are the nominees for the other judgeships? Is that correct?
Chief?
Mr. Chairman, Representative Bratton, the process is the same for all our judges. So whether it's Circuit District or Supreme Court, the Judicial Nominating Commission works in the same way. Municipal court judges are not ours. They work for their municipalities, so that's different. But for all our 57 judges and justices are selected in the same manner under the Constitution.
Representative Bratton?
Thank you. So those judges, those names are also not published. And is there I know some states do publish all the potential nominees for those judgeships. What reasons do you see to not publish those names?
Probably the same reasons given before, but I'll let the chief answer.
I was going to ask that. Yeah, I was curious if she had same reasons, different reasons, or thought that those same reasons applied.
Mr. Chairman, Representative Bratton, the same reasons do apply. It really is to allow practicing attorneys who are interested in being judges to have that confidentiality, in part because it could impact their practices if people knew that they were looking to change jobs, and also in part to avoid too much political pressure, because, and the thing I keep coming back to, and I can't say too many times, is that judges' allegiance is to the law and the Constitution, and to avoid political pressure as much as possible. In fact, in our Code of Judicial Conduct, one of the rules is judges must avoid that kind of pressure and just do their jobs.
Representative Webb?
Thank you for being here. Thank you, Mr. Chairman. Speaking of the Judicial Nomination or Nominating Commission, is there a way? Flashing, blinking. Is it on? No. Okay. Curious to know if there is an option for public input to be able to, I don't hear anything about public input and would like to know if there's an opportunity for the public to say who they would like to have as judges.
Mr. Chairman, Representative Webb, there are public input opportunities, not in the first 60 days. Although, so there's a lot of input taken by the Judicial Nominating Commission. When a person submits their expression of interest, they also submit the names of 8 references. So that will be 3 attorneys, 3 judges, and 2 personal references. So the judges especially can be very frank, right? I mean, here's the way I look at it is you ought to be able to find 2 friends to write you a nice letter of reference, right? But you have to pick judges that you've practiced in front of. You don't get to pick just the ones who like you. You have to pick judges who know you as an attorney, and they're going to give you some pretty good feedback on these applicants. And then the 3 lawyers as well. So there's input, not from the public, but there's a lot of diverse input that the commission receives about these applicants. Then during the 30-day period, when those 3 names go to the governor, it's wide open for public input. The other thing that I would say about public input, Representative, because I know that you're concerned about the lack of confidentiality, but there's actually a huge amount of transparency in our judicial system. First of all, as I said, in the governor's selection period, the feedback that he receives. Then we have, as Judge Chambers said to you, come to the court. There is no more transparent branch than ours. You can come and hear what happens in court. You can see the written opinions. Come to the Supreme Court, read our opinions. I have tried to make my opinions shorter and shorter over the years so they're not too painful to read. There's a lot you can see about what we do. And then, of course, we have the retention elections when the public has full power over whether to keep a judge or not keep a judge. So there are many steps along the way in the process for the public to know what's going on in the judicial branch and then to give feedback. If you want to throw a judge out, then that's a great opportunity to do it.
Follow up, Representative Webb?
Follow up, please. Yeah. So do you think there should be an opportunity for the public to have more input? I know we can see things after, but it's about nominating these judges and that process. Do you feel there should be more public input and more public transparency during that process?
Chief?
Mr. Chairman, Representative Webb, I would say this again, as I keep saying, our job as judges is to adhere to the Constitution and the laws, not necessarily to be subject to the will of popular will, right? Because what we do is often not popular. And I'm going to, actually, I brought this Code of Judicial Conduct rule to read to you. 2.4, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. And it goes on, but that's something that we are supposed to live by, is to put aside public clamor or criticism. Now, but to answer your question more specifically, I'm not entirely opposed to having more public input during that, say, first 60-day period. I think, and Justice Boomgarden and I have talked about this, we've had conversations with the Judicial Nominating Commission about this. I think the merit selection system is an excellent system. It's not without flaws. but it is far preferable than elections or even Senate confirmation, gubernatorial appointment. All those are so much subject to political and financial influence that I think it would undermine the job of the judiciary. However, we could open it up. We could, for instance, it's not in the Constitution, it's in our rules that says that the first 60 days, the applicants' names, for example, are confidential. And as Representative Bratton said, in other states, they do open those up. So it's not out of the question that we would do that if what the people want or what this committee wants is improved transparency in the process. It's certainly something we could work with. So I don't think we should be throwing out the baby with the bathwater. If that were an improvement, then we're open to it. Or by we, I should say they, because I'll be gone.
And Chief, just, I think there's still some confusion on what the process really looks like. So the Judicial Nominating Commission members are published online. So the membership is open to the public, and anyone could, there's nothing that would prevent a person from contacting the commission members at any point in the process. It's part of why they're published online, is so public does have access to them if they desire to engage in it. The vacancy is publicly published. So even though the names of the individuals, that's, step number 2, but in step number 1, the vacancy itself is published. So the public knows that there's a vacancy, knows who's on the commission, and then has access to them. And then I do know in the second phase of the appointment process, when the 3 names move to the governor's office, you could ask the chief executive how many emails and phone calls he receives, because he certainly does. I know that for certain, that people engage in the process at that level too. So some of it might not necessarily mean that there's a necessary change in our process to get you more public access, but it might just be more awareness. I mean, does the public really know that these names are published on the website and they can go and access the members of the commission and email their thoughts or phone call and give them their thoughts? They probably just don't know that exists. I know as a member of the bar, I'll tell you that we receive communication through the process. So we know there's a vacancy. We know who the members are of that. And so there'd be another outlet through bar members, through attorneys, to access the commission as well. So I just want to make sure that it's clear that there is quite a bit of access to the commission and to the governor throughout the process. Senator Crago?
Mr. Chairman,
Chief,
while he's sorting himself out.
That could be.
This might be a sign.
I did want to clarify one point to Representative Bratton's point about the governor selecting the chief justice. Actually, the other justices elect the chief. And for instance, I was not selected by this governor. It was Governor Meade. So over time, those things change. I don't think it's quite as much control by the governor as that might seem.
Oh, no matter what we give you, this is just not going to work.
It's that magnetic personality down there.
There you go. Senator Crago.
I thought it was divine intervention for a moment there.
It's probably all the above.
Speak loudly.
Mr. Chairman, I was just going to say what the Chief Justice just said, which was that the governor does not get to appoint the Chief Justice of the Supreme Court. And oftentimes the current governor has not appointed the Chief Justice because of how the terms roll over and the length of terms of your governor. So those don't always, it could work out, but typically does not work out that way. I'll also just mention, I've been part of this process a couple times of the judicial nominating process. And if anybody has any questions, any of the committee wants to talk to me about it, I'm happy to fill them in. It's an interesting process. It works very well, results in us getting very good judges and justices appointed to the bench, and super proud of how it works in Wyoming.
Thank you, Senator Crago. Senator Kolb? And then Representative Lean, I'll come back to you.
Yeah, thank you, Mr. Chairman. Oh, it's on.
Yeah.
All right.
Good.
Now I'm gun shy.
Green means go.
Question about retention votes instead of an outright situation where you actually cast a majority of people that voted for said judge retention. I'm going to ask a dangerous question because I don't know the answer. Is it in fact constitutional that it's a vote of retention, and how that it's laid out in the Constitution that it is in fact of the number that of the people, not the, you know, when you have a retention vote, you don't have to have a majority of the people that voted. You have to have a majority of people that didn't vote against you. And to change that and make it into a different situation, I think there's lots of things that could be done, Senate confirmation, but maybe at the lowest thing we could do is to change the retention. Because as an elected official that I am, it floors me how people tell me how a retention vote's the same as a general election vote. And it is not, absolutely not the same thing. So what's the thoughts on making, changing the retention situation on the criteria for what that means? Chief Justice Fox. Thank you, Mr. Chairman.
Chief?
Mr. Chairman, Senator Kolb, I guess, because I've been a lawyer and a judge for a long time, I need to start my answer to that question by saying this assumes facts, not in evidence. And by that, I mean, does it need to be fixed? I think we have a darn good system. And so first, I just, for the record, need to make that objection. But to answer your question, and I think what you're saying is right. So right now, our retention election, we survive a retention election if we don't get more than 50% of the votes against us. And you might want to switch that to say you only survive if you get 51% of the votes to keep you. You know, to tell you the truth, I'd have to look at the Constitution and see how that's written. And if you could switch it without a constitutional amendment, I kind of think you couldn't. But you have this very talented staff over here, and I bet they would tell you.
Please, Senator Kolb.
Yeah, just I want to state for the record, I'm not a member of the bar. I'm not an attorney and I have nothing to lose by saying what I said. Thank you, Mr. Chairman.
Well,
Mr. Chairman, Senator Kolb, I respect that.
Chairman.
yeah, we're going to go to Representative Lean and I'll come back to this side.
Thank you, Mr. Chairman. Rule 13 of the Nominating Commission rule allows the commission to nominate a person for a judgeship even if they have not filled out an application. Has this ever happened? And if so, how often does it happen? Mr. Chairman, Representative Lean, it has not happened in my time on the court, to my knowledge. I don't know if it ever did before that.
Senator Hicks.
Mr. Chairman, thank you, Chief Justice. Thank you for your time and your service to the state of Wyoming. And you're in a unique position to answer this question. So we talk about this public process, and I want to focus specifically on Supreme Court justices. There's been this, in recent times, new kind of evolutionary thought, and I want to deal specifically with interpretations of the Constitution, Wyoming Constitution. That's the purview of the Supreme Court. How would anybody in the public understand the philosophical decision-making process that a nominee or somebody that has been nominated for the Supreme Court through the judicial nominee, how would they find out if that person's thought process in interpreting the Constitution was an originalist, a textualist, or a precedentist, or any number of methodologies that people use now to come to a determination on constitutional issues? Because to me, it's the most fundamental underwriting thing. I want to understand this decision-making process that a judge will go through in interpreting the Constitution. So in your time on the bench, in your experience, how would I find out what you're predisposed? Are you a textualist by nature? Do you believe that court precedent is that the way that the Supreme Court should always interpret the Constitution? To me, that's the fundamental nature that I need to understand about a Supreme Court justice before they go on the bench. But in your experiences, how do you answer that question? How would I ever find that out?
Chief?
Mr. Chairman, Senator Hicks, well, there's a lot to that question. So, first of all, I have never in my time on the court and in all the discussions that I've had with my colleagues, we have never approached our analysis of a case in terms of, okay, I'm an originalist, so here's how I'm going. We don't really do that. We're much more practical people. So I understand the question you're asking is how you can really dig into who these applicants are. But before I answer that, I want to say we don't approach our cases in this kind of box of some philosophy, other than this basic philosophy, which is this is the law that the legislature has written. This is the Constitution that we abide by. These are the facts. How are we going to sort this out and make the best decision adhering to the law and the Constitution and making sense for whatever the dispute is? So that's just not a way that we talk about how we approach cases. And I think I speak for all the justices with whom I've served, which is probably 10 by now, in that we're not political people. We're practical people. How you would know that before those three names went to the governor is you wouldn't know that, but the Judicial Nominating Commission is asking these questions. How do you approach your legal analysis? What do you look at? The questions change over time as the commission members change, and also because word gets out what the interview questions are, so you kind of change them. But basically what the commission wants to know is what is your philosophy when you approach a case where the law is difficult and when perhaps the law doesn't conform with what your personal opinion is? And the commission is always looking for people who are going to say, I have a lot of experience as a lawyer. I care about the Constitution and the laws that have been promulgated by the legislature. I'm going to look at the facts. I'm going to do the work. If I'm a trial court judge, I'm going to assess their credibility. And then I'm going to make a practical and a legal decision. So what you're going to know about that before day 60 is probably very little, honestly, but the commission is doing an incredible deep dive, reading all of the application materials, reading all of the evaluations that people have submitted, and asking very probing questions in the interviews to make sure that these applicants, the three that they're going to send to the governor, have the right skills and knowledge to do the job.
Mr. Chairman, just a real quick follow-up. So there's a number of definitions out there, but this has actually come up before a number of Supreme Court justices to the United States and their confirmation before the U.S. Senate. And a number of them come out and have absolutely definitively stated, I'm a textualist, or I follow an originalist intent construct in determining a specific to the Constitution is what we're talking about. What I heard you say is pretty much in line with what the definition of what be a pragmatism. And that's the way that under your time as Chief Justice is kind of a pragmatic approach to interpreting all those things. I won't go into the exact definition that's defined for that. But again, my concern is we don't know, and it's very important in this time and place. And it gets back to the Judicial Nominating Commission and how that's structured. I understand independency of the judiciary. I think independence of the judiciary and political influence are two different things. And there is, as you well know, there is a number of criticisms out there of the Judicial Nominating Commission about the political influence of the bar, in particular, and the fact that it is a political process because ultimately the governor appoints. those people to the three of those people to the Judicial Nominating Commission, and then the governor picks. That's a political process. So I'm concerned that we're talking apples and oranges, but could you characterize the difference between one of the criticisms is that even the bar has a political disposition. There's an overall bending direction within the Bar Association. That is a well-founded academic criticism of the Missouri Plan. But in your experience, have you seen that come into play? Because I'm aware, was it 2018 or 2019, the Supreme Court revised the rules for the Judicial Nominating Commission to try to further insulate that away from the political process, not politics. It's not perfect. Let me simplify the question. It's not perfect. Otherwise, we wouldn't have gone through these changes in 2018, 2019 that the Supreme Court did. And you've alluded to this, is there anything that we could change right now, again, to increase public participation? But is there anything within the Judicial Nominating Commission process with the Missouri Plan that we need to tweak? Or should we just leave it alone?
Was that a filibuster or a question?
Both.
Okay. All right, Chief.
Mr. Chairman, Senator Hicks, there are things that we can change in the process. And as I said, I think that the court is open, especially to the parts that are within our control, which is the rule change. I'm not really sure about the 2018 rule change. That was before I was chief. I think those were just I don't think those were any really substantive changes, but I would say that yes, we would be open to some tweaking, to some more openness. We could certainly ask applicants, for example, what their judicial philosophy, if they're originalist, textualist, pragmatist. I'm pretty sure they'd kind of go, huh? But, and not because they're not well informed, but just because that's not how we do things. But again, I really need to push back on a lot of the bases for this conversation, which is, look at these guys, Judge Buchanan, Judge Chambers, Justice Boomgarden, and I, pretty darn good judges. So what really is the problem? We have some very good judges in Wyoming. So before we start saying, how can we fix it? I really want to know what is actually wrong with it, because I think we work extremely well. And I think our judges are fantastic.
All right, folks, here's where we're at. We're 35 minutes past our topic. I think to be respectful of the committee's time and respectful of our judges here as well and the public, I am going to have us move on. I'll take one or two more questions, and then I think we're going to move on from this topic. So Representative Kelly, go ahead.
Thank you, Mr. Chairman. I don't believe anyone here is questioning the quality of the judges coming out of the system right now. So maybe that's why we're talking past one another right here. What we're looking at here is we have constituents who are very concerned about the opaque nature of how judges are picked in the first place, not necessarily complaints about the justices. Yes, I understand there are some political complaints about recent decisions. And that's not what we're talking about. I agree completely about political pressure being removed from judges, and I hate the idea of electing judges. We're looking here primarily at not knowing who the applicants even were, not even knowing who was passed over during this process. And so far, the only explanation I've really heard is pretty much professional convenience for those applicants. And as people who have been through the ringer to go into public service and had our lives laid out there was absolutely no convenience for us whatsoever, and we decide to serve. How do I go back and tell voters who want to know what's going on that transparency is less important than the professional convenience of some applicants who may or may not apply?
Chief?
Mr. Chairman, Representative Kelly, for one thing, there is a great deal of transparency. Right. I understand your concern is that there isn't transparency at the stage of who the applicants were during that period that the JNC is doing its work. I think that that's a legitimate claim. And as I said, I think the court would be open to revising that process. You know, and I've said this before, it isn't really just professional convenience, that's part of it, but it's also the political influence piece of it. But my main answer to your question is, yeah, we could consider that. It could be something that could be opened up. And I've actually started asking applicants in the last few interview sessions that we've done, would you still have applied if this were public? And getting some different answers. So we're not locked in.
All right. One more question.
Do you have one?
Rock, paper, scissors. It's okay. This is it, Representative Lean.
Thank you, Mr. Chairman. Since attorneys are electing their members, other lawyers on the commission, my question is, how does the court ensure that these members represent the broader Wyoming community rather than any legal interests?
Mr. Chairman, Representative Lean, well, they do represent a legal interest. I mean, the attorneys are the ones who use the courts. And so they do have some insight and knowledge about what's needed in a competent, capable judge. They have experience often with the applicants, so they have that insight. So in some ways, it really makes sense to have some attorneys' input in the selection process. But that's also balanced out by the 3 non-attorneys. And it's really interesting to see the interaction, the way that the Judicial Nominating Commission works together, the views of the non-attorneys and the views of the attorneys really complement each other. They are seeing and looking for different things. And so actually, I think it works pretty well because of the mix.
All right. Thank you, committee, for a robust discussion. Sorry, I have to cut you off. I know you want to keep going, but we could probably be here all day and into the next day on this topic. So we're going to move forward unless there's anything else from our panel that you want us to know or hear.
Really appreciate your time and you co-chairs. It's been a great pleasure. Thank you.
Thank you, Chief, for your service.
Just make it-
Yes.
And just in closing, at subsequent meetings or anything, at your disposal for any other questions or dialogue similar to this, going forward, so.
Yeah, we appreciate that. I think having an open channel of communication with the bench is very helpful for this committee. So thank you for that. All right.
Mr. Chairman,
Yes, Representative Bratton,
if I were to make,
you were lit up.
oh, I was lit up. Oh, no. If I were to make a motion, I want to make a motion and I just want to know if now would be appropriate time, for judiciary, for us, for the co-chairman to request 2 additional days for the Judiciary Committee to cover judicial reform, Free Speech Protection Act, elected AG, those topics. I mean, I feel like we don't have enough. That is something that many of us wanted to discuss. This was a great discussion and I think
So
we
here-
need more days because I believe we have 4, but we were allowed to request an additional 2 days for a total of our 6.
So here's what I would do with that. I would say there's probably a different way to go about it than a motion. What we will do is as we move through updates and as we move through substantive stuff tomorrow, what you're free to do as a committee member is make a motion for a bill draft. And we are judging this committee's time based on the number of bill drafts. That really helps us judge it. So let's say if you made a voluminous amount of bill requests and this committee decided to move all those forward, then Chairman Washington and I would definitely want to go back and add more time. But I don't think it's appropriate to go back and just add more topic time. But if within the topic time, within the topics that we have, because we've already gone through the process of selecting the topics, they are what they are at this stage. We don't add to the interim topics once we've gotten this far down the road. But no problem adding more time if we have the work necessary to do that. We would certainly request more time to get through those bill drafts. And that might be additional meetings. It might be There's lots of different ways to do that. Sometimes by Zoom as well. There's just lots of different ways to skin that cat. So keep that in mind as we move along. If you want to make it just takes a simple majority vote of the committee to sponsor a bill, to have a bill drafted. Unless there's extreme objection, we usually just take it from an individual member and draft the bill. And then we'll go from there.
I will withdraw my motion. Do you want to no? You want me to go?
I'll second it.
All right. All right, there's the motion. The motion right now is to request the 2 additional days for the Judiciary Committee to cover judicial reform, Free Speech Protection Act, and elected AG.
And Representative Bratton, I'm going to go ahead and rule your motion out of order. It's the chairman. It's up to the chairman of this committee to set the interim topics. That's the directive from Management Council. And so, like I said, we will certainly take that into consideration if there are bill drafts and work necessary, but your motion itself is out of order. Any additional comments on judicial branch updates? Representative Lean?
Thank you, Mr. Chairman. I move for a bill draft to delete the nominating commission and add Senate confirmations.
Okay. Is there a second on that?
Second that.
Seconded by Representative Webb. Mr. Fuller, does that motion make sense? Is there more information that you need?
I think, Mr. Chairman, if I understand, please correct me, Representative Lean, the motion would be to strike the Judicial Nominating Commission from the Constitution and replace it with, and this is the piece I would appreciate help with, the governor would appoint the judge subject to Senate confirmation.
Representative Lean?
Thank you, Mr. Chairman. The clarification would be that the Senate confirmation is the final piece.
Final after what?
Yeah, well,
So the
current process runs, governor makes a recommendation and then it requires Senate confirmation for that. Is that what we're?
Yes.
Are you
the
suggesting-
Nominating process stays in place.
the process as now stays the same. You're just adding Senate confirmation to the end of it, to the end of the process?
Yes.
Okay, that makes sense. Any discussion on this motion? Co-Chairman Washit.
I'm concerned, these senatorial confirmation hearings that we see on the national stage are often time consuming, slow, and they don't look like they'd be a lot of fun for the nominee. And I can see people being willing to subject themselves to that senatorial confirmation process for a lifetime appointment. But to put yourself through that ringer for a 4-year stint as a circuit court judge or a 6-year stint as a district court judge, I do worry that such a system would discourage applicants. So certainly, committee make a decision if we want to debate this further and take a look at such a bill draft. But I just urge caution.
Mr. Chairman, discussion.
Senator Hicks, yes.
For the bringer of the amendment, was it the intent to include all judges or just the Supreme Court judges? Because even at the congressional federal level, we don't have Senate confirmation for federal district judges and all.
Yeah, we do.
Oh, they do go
For
through
district,
Senate confirmation. But for your motion, did it include circuit court judges, district court judges, Supreme Court judges? Just clarification so I understand how I'm going to vote on this.
Representative Lean?
Because I think you have a valid.
Thank you, Mr. Chairman. I guess I'm open to suggestions. Senator Kolb has his hand, he's waving at me down there, so he might have a thought on it.
What's your motion? Let's get it down on what it says right now so we can at least discuss the motion. Do you want it to include all 3 levels of judges?
Mr. Chairman, ultimately, I'd like the entire nominating commission to go away. But because we're not going to have enough time to be able to discuss that and make it happen, if we can at least get a Senate confirmation hearing for the judges, I'd say all judges at this point.
Okay. Senator Kolb?
Yeah, thank you, Mr. Chairman. I mean, I like the direction of this. I think that I would prefer at this point in time that we would limit it to Supreme Court justices only for Senate confirmation and see how it goes. I think that would be a huge change in what we're currently doing. And I don't know if that's a friendly amendment, but I want to throw that out there. I'd certainly be much more amenable if we would limit it to Supreme Court justices only at this point. And then, like I said, see how it goes. If it works out, then we expand it.
Representative Lean, are you amicable to the amendment or would you like to keep your motion the same?
Mr. Chairman, all judges, please.
Okay. So unless that's a formal motion to amend, it's okay. All right. Any other discussion? Representative Bratton, your mic's lit up. Is that just by accident? Okay, just making sure. Yes, Senator Cole.
I'd like that, make that amendment that it would amend this proposed bill draft that we would include only Supreme Court justice confirmation with the Senate.
Okay, that has been moved to amend the motion. It's been seconded by Senator Hicks. Discussion on the amendment. All those in favor of the amendment signify by saying aye. Any opposed? Okay, I believe that. Oh, okay. All those in favor, go ahead and raise your hand. 1, 2, 3, 4. Okay, all those opposed? Thank you. That motion has failed. We're back on the main motion. Any further discussion? All right, all those in favor signify by saying aye.
Aye.
All those opposed?
No.
All right, all those in favor, please raise your hand. 1, 2, 3, 4, 5, 6, 7. Put your hands down. All those opposed? 1, 2, 3, 4, 5, 6. And I'll vote no, that's 7. That motion does fail. All right. Is there anything else on judicial branch updates? No? Was there any public comment? I forgot to ask. Now there's a lot to comment on. No, silent. Okay. Very good. Just so the committee is aware, I did order pizza. They said that the pizza was going to be here at 12:30. It's 12:50, so I'm not sure where it's at, but it's supposedly on its way. So just know I'm not trying to starve you out, but it should be here any moment.
That's the reason why that failed. No pizza.
All right, we'll move on to our next topic, though. We'll just keep pressing forward. And the next topic is mineral interest and ownership. We have Senator Crago, we have Mr. Detai and the Wyoming Mining Association. We're going to make up some time here. I'm confident in that. Senator Crago?
Mr. Chairman, you are correct. We're gonna fly through this. Barry Crago, Senate District 22. I'm gonna do very little talking. I'm going to let Mr. Sylvester, Mr. Detai do most of the informational speaking here today. Really, this is a topic that in speaking with Mr. Detai and the Mining Association, we thought this would be a good topic for this committee to look at, to learn about, and hopefully at the end, bring some legislation that has some broad-based support throughout this committee and throughout both the House and the Senate.
Hey, Senator Crago, just real quick, can I interrupt you?
Yes.
The pizza has arrived. So at your pleasure, please feel free to get up, move over, get some pizza, and we'll just continue working. Everyone can eat except for Senator Crago. Go ahead, Senator Crago.
Yes, thank you, Mr. Chairman. So just a quick background, which really what this topic is looking at addressing is the issue where we have generational mineral interests going back, actually a lot of these to patents, years and years back, where families patent, they homestead a piece of property, they get a patent, and though at some point those mineral interests are severed from the surface, and throughout time and throughout generations, those mineral interests become so small and so minute that we have a hard time, both as industry and as us as lawyers have a hard time tracking down who owns what. Many folks probably own something, don't even know they own it, and it's of such small interest that it has very little economic value to those families, but it makes the job of the Mining Association and the Petroleum Association and both of those groups makes their jobs very hard when they go to try to lease minerals and produce those minerals. And they end up with a lot of administrative costs that hopefully we could sort out. Other states have addressed this. And I think Mr. Sylvester and Mr. Detai will talk about that. And so at this point, Mr. Chairman, if it's all right with you, I will pass this on to them.
Okay.
Barring any questions.
Any questions for Senator Craigo? All right, Mr. Detai, welcome.
Thank you, Mr.
This is a
Chairman.
different committee for you to be in front of.
It is, Mr. Chairman. I'm Travis Detai. I'm the Executive Director of the Wyoming Mining Association, and very honored to be before committee number one. I don't get before this committee very often, and I know you're crunched for time, Mr. Chairman, but if you would indulge me just a little bit for some of your newer members and tell who we are. The Wyoming Mining Association is the state's trade association. We represent the state's coal companies, companies developing uranium resources, bentonite, trona, and natural soda ash. We represent 2 companies in the state doing rare earths exploration and development right now. We've got a lithium company working in the state of Wyoming right now. We also represent a company developing gold resources, and we represent 2 companies doing advanced nuclear work in the state of Wyoming and the Wyoming Mining Association through our associate member group. The Mining Associates of Wyoming represents about 100 companies that provide services and supplies to our mining industry. We really appreciate coming before your committee, Mr. Chairman. When I was visiting with Senator Craigo on this was a topic that we floated a couple of sessions ago as an interim topic. We floated it both before the Ag Committee and the Minerals Committee. There wasn't a lot of interest, but it's an ongoing issue that we felt really we need to start addressing it. And we felt the Judiciary Committee, with a few lawyers on the committee, a landowner or 2 on the committee, this might be an appropriate place to bring this topic. And I'm going to turn it over to Mr. Joe Sylvester. Joe is the Natural Resource Manager and Government Affairs official for Wyoben. Wyoben, one of our larger bentonite producers in the state of Wyoming. And he's been working on this for a couple of years, and I'm going to let him dive into the memorandum that we sent to the committee as the read ahead and inform you a little bit about the issue. And our goal for this committee, Mr. Chairman, we're not under a time crunch here. This isn't something that has to be done today. But what we would hope for with this committee is to advance the issue, start the discussion. We have reached out to my colleagues in the petroleum industry. They are interested in the bill. We've reached out to some of our friends in the ag industry. They have also shown some interest in this as well. And I think eventually, whether it be this session or even maybe the next session, to really dive into this, do something, do it right, and come out with a product where we could solve this problem and make everybody happy. So with that, I'd like to turn it over to Mr. Sylvester, Mr. Chairman.
Mr. Sylvester, welcome.
Thank you, Mr. Chairman, and thank you for the opportunity, and thank you for hearing this out. As Mr. Detai told you, I've been working on this. I do some of our title work for us, looking at the courthouse and that. I am not an attorney. I am not a title examiner. I am a past banker, recovering from that and for 22 years. And so working forward with that, but the dormant minerals and seeing the severing as these are being severed from generation to generation. I can give you example after example of some of the generations that it's so small, it's not worth their time. They're going to leave it as abandoned, non-use, and will never happen unless we put something out there. There's 2 forms in order to get that exchanged back to the surface, and that's quiet title. And I am in continual learning, and I just learned this Friday, the determination of heirship as I was visiting with Senator Craigo about this topic as well. So there's 2 mechanisms there. They're long, they're drawn out, costly, and other states have processes in place that they can make it a little bit easier to be able to transfer that mineral ownership and bring it back up to the surface. When we're looking at that, and I belong on 2 national boards, mining exploration boards as well. And so one of them, we are very heavy in attorneys. And so I have an opportunity to bounce these ideas off. One of them is Crowley and Fleck, and a good friend of mine as well.
And so I've gone back and forth, had about an hour conversation on the phone as I was driving down here this morning as well, trying to figure out, make sure that I don't misrepresent what's being said here. But based upon Rocky Mountain Mineral Foundation had a presentation on this about 3 years ago on their natural resources and primarily looking at dormant mineral interest and the transfer of that. And so looking at all the different states and what's been challenged in the past. And from that visit, they said North Dakota is probably our best place to look at. It's not perfect. We want to probably tweak it, but it would be a good start to be able to look at there and then bring in all the other interested parties. As Mr. Detai told you, we need to probably bring in the Stock Growers Association, the Farm Bureau, Petroleum Association, who am I missing there? Banking Association, title companies, and that to bring in and have that conversation. So I guess our ask today is if we would like to be able to continue on the conversation and bring it to the next level, and what that next level is, we're more than willing to participate and help with however we can to make sure that this goes forward. As Travis said, this is not something that's urgent. We don't have to do it today. We've had this opportunity before us since statehood. July 10th, 1890 was the first day that this issue started. So we've waited a long time so far. I don't want to wait that long to address it, but would like to be able to at least continue the conversation. Thank you. And Mr. Chairman, obviously, I probably forgot to mention where our interests lie. The state of Wyoming, as everyone at this dais knows, runs on extraction. And we believe that if we could get this problem solved, it would not only be a benefit to our membership and our folks that are out developing the minerals, to provide tax revenue, to provide jobs, but it would be a benefit as well to the landowner and let them be able to generate a little revenue for themselves as well. We see it as a win-win if we can do it right. And I think that's kind of what we're asking, is the committee to take a hard look at this. If we want to start with a draft piece of legislation, something along the lines of what North Dakota is doing, and then, take some time in the next couple of meetings with this committee and bring the parties to the table and work a bill. I think that would be what I would suggest would be our most favorable path forward. But recognizing you're short on time and your days are short, obviously leave it up to the discretion of the committee.
And Mr. Detai, that was going to be my question as to where to start. And you think the best place to start is just by looking at the North Dakota legislation? And I don't think that's in our materials yet. For some reason, we didn't. Or is it?
Mr. Chairman, it's, I'm not sure about the paper copy. The online copy is 5-04. Is that North Dakota legislation?
Yep, sure is. I see it now. Okay.
Chairman, I did provide paper copies. They took me to the cleaners at Kinko's for your paper copies.
Senator Craigo.
Mr. Chairman, it is in your paper copies as well, but it's online as well. The North Dakota version is set out by itself, but then there's also Mr. Sylvester had done some comparison work with a lot of the other states that have similar legislation. Looking through it, North Dakota's version is the cleanest. It also, to me, is the one that makes the most sense. It probably lines up with our current law the best. So if we were going to start with a particular version, I too would echo what Mr. Detai said, was let's look at North Dakota. We could use that as sort of a template and then make adjustments for Wyoming as necessary. I would also note the North Dakota version requires you to file an action at the end, a court action at the end. Some of the other states do not. So that's one thing I think we may want to look at, just to understand the differences. Some states you just file in the courthouse, your clerk's office, the final action is there rather than in the court. And so that's just an extra level of protection for the mineral owners if we want to go that far, but we can talk about that as we go, Mr. Chairman.
We'll have to make the mineral definition a little more Wyoming. It needs bentonite and trona in the definition.
Mr. Chairman, that is absolutely something that we would like to, get started work on those, work on the details and go from there. And of course, loop in our friends from the ag industry and in the oil and gas industry and other parties as well. But I think the ultimate starting point would be to get something to start working on.
Great. Yes, Representative Webb.
Thank you, Mr. Chairman, and thank you, gentlemen. I would support something like this. Full disclosure, I fall into that category. My grandfather bought some land years and years ago. Our family has the mineral rights. You know, my grandfather now has great grandchildren. So I'd like to see this cleaned up and would suggest that we move on this. Don't limit it strictly to North Dakota. Let's look at other options also.
Thank you, Representative Webb. Representative Chestick.
Thank you, Mr. Chairman. There's a reason you don't see us. We don't see you very often either. So we're not up to speed that much on oil and gas and mineral extraction stuff. So if I ask a dumb question, please forgive me. But I need to get some more information about the scope of the problem. What little I know about oil and gas and other extractive industries, that most of those are done on a basis of leasing, where the companies lease the property. And in those situations, the mineral rights and the surface rights are still united. They're still in the same situation. I think, maybe not. I don't know. But how often are these rights severed? How big is the problem that we have to deal with here?
Mr. Chairman, Representative Chestick, there's no such thing as a dumb question, but I probably could give you a dumb answer. But so the way we do it with the mining side of things, and my colleague from the Petroleum Association is here, and he may be able to do the oil and gas side. But with the mining side, you have two categories of minerals. You have your leasable minerals, which are owned by the federal government. That is our coal and our trona resource. And then the other fall into the category of what are called locatable minerals. And that's bentonite, uranium, pretty much every other hard rock mineral. And those are ones where you actually go out and you actually stake a claim and do your exploration. I'll let Mr. Sylvester talk a little bit more about that, but that's kind of the division. And those can be on private land, those can be on federal land, those can be everywhere. So it's kind of a different category as far as what you're leasing from the federal government, which is our coal and our trona resource, and everything else, which is locatable, which falls under the General Mining Law of 1874. I always get that one wrong. So I hope that gives a little bit of clarification, and I'll let Mr. Sylvester go a little bit farther.
Mr. Sylvester.
Mr. Chairman, Representative Chestick, these are leases with the private landowners when they own the minerals, and the surface owners. In that situation, we have two different contracts. We have a surface owner contract that we will compensate them to have our activity on there, so that they aren't able to plant crops or raise cattle or whatever. In the second situation, you have a mineral owner. When the mineral has been severed from the estate, the surface goes on with whoever's using it. However, those mineral owners, in an example in Hot Springs County, I'm working on a 5th generation separation. And so that means this initial individual had 5 children. Of those 5 children, the 5th child had 13 children. And so I am down to the 5th generation, where I'm working on 53 different mineral owners that we have to go get different contracts with each one of those. The challenge with that is, in the initial beginning, mom and dad, they transferred it, and the only person that did the estate actually transferred that in their probate, in their will, and included it. The other 4 children did not. So we're asking for 5th generation great-grandchildren to come back, go through probate court, and bring it forward. And so it's a nightmare. And usually these fractional interests, I'll give you one other thing is bentonite itself is a low margin product. And so oil and gas, you can become rich very quickly. With oil or with bentonite, its state rate is $2.50 per ton. And that's what we use typically with our mineral owners. And so it's not a quick get rich quick type of scheme. So if you own less than 1%, some of these mineral owners will get less than $300. And to do the probate and all that, it's going to be well over $10,000. And so it's just going to leave and stay there in the ground, or their interest will be abandoned for the rest of time.
Yeah, I was just gonna say that last part. I know true from experience. My office gets these calls all the time for fractional mineral interests, and I don't even, my office doesn't even quote them anymore because it's just we just tell them you're gonna spend more money on us than it's gonna be worth because it's not a producing, and a lot of them are non-producing. So it is an economic issue for people to be able to afford the process. And the process, because it's back so many generations, is actually extremely complicated. And so it's not like they can just get the probate pro se forms and proceed. It's not simple enough for them. Representative Chestik.
As follow, and thank you, Mr. Chairman, and you don't have to convince me about the complications of trying to track down heirs. The very first case I was handed when I became a lawyer, my first assignment in my first firm was, here's a deed that nobody's looked at for over 100 years, and we don't know who owns this property. And I did the title search and come up with about 1,000 different possible owners. So I know how that works. It's a nightmare. I understand that. But what I don't understand from your answer is that so I own a ranch and there's coal underneath the ranch. Is that something that I own, or does the federal government own that? Who owns that mineral right?
Mr. Detail.
Mr. Chairman, could be both. So on the federal land, the coal is owned by the federal government. On private land, you could have federal coal under your land as well, or you could have private coal that you own. So the answer is both. Yeah, and
That's a very lawyerly answer. Both.
It's a factual lawyer. Mr. Chairman?
Representative Chestik, follow up?
Yeah, I'm not sure how is that, what distinguishes federal coal from private coal? Again, I'm asking dumb questions, but I have to vote on stuff. Go ahead.
Depends on how lands were patented.
so
Mr. Sylvester, go ahead.
Oh, Mr. Chairman, Representative Chestik, when the property was transferred there was a patent that was with that. And up to 1916, that patent was land and mineral. However, after 1916, the government says, oh, wait, we're giving something away here. So we're going to give you the land. However, we're going to keep the minerals. And that's the definition of a split estate. And so at that point in time, now you're dealing in Powder River Basin specifically, you have a lot of federal coal leases that they're doing out there. However, there is private coal as well.
Senator Hicks.
Yeah, Mr. Chairman, if any of these states that have enacted, when I'm looking at the summary sheet here, has there been any challenges to any of these laws from a standpoint, particularly Fifth Amendment takings clause that we're taking, if there's 729 mineral interest owners, you're still taking that property away from those 729 and can't conveying it to the new owner of that property. But what are the legal challenges and the legal history associated with these?
Senator Crago.
Yeah, Mr. Chairman, Senator Hicks. So I believe the North Dakota law has been challenged a couple of times. It's withstood that challenge. I think that's one thing we'd want our staff to really brief us on as we go about this. Get some sort of memo from our staff on where it's been challenged. I just know about the North Dakota one in conversations with Mr. Sylvester, but I think we could look at that more in depth and exactly see where it's been successful, where it hasn't, and why, and help that, use that to shape our decisions on what the legislation looks like.
Chairman, if I may, just to follow up for staff.
Please go ahead.
It would be to include the nature of those. In other words, it gets back to the previous questions. Were these patented by the federal government under the Homestead Act? Or how did they acquire these? It come into possession. So, and that gets back, was it challenged in federal court or state court? That's important.
Mr. Sylvester.
Just for a follow-up to that, Mr. Chairman. So it has reached the Supreme Court, Texaco versus Short, and that was on abandonment. However, in North Dakota, their Supreme Court has said it's self-executing. So you attorneys will know what that means. And so as long as it's self-executing, as well as there's opportunities, there's chances within that, that a mineral owner is provided notification, there's publication out there. So they have an opportunity. There's two opportunities that they have to be the ability to challenge and say, hey, we own this, we still have it. And usually within these different plans, they either have a 20-year exclusion where if I say I have a claim in this mineral, I have a 20-year grace period. And at the end of 20 years, I have to re-up that. Otherwise, it's going to potentially, landowner could then file for it.
Mr. Chairman, quickly, and
Yes.
just this is in response to a little bit further follow-up to Senator Hicks' question, which is one of my concerns as well, but it's a lot like adverse possession. I mean, you can think of it along those lines, prescriptive easement type language. I mean, that's really what we're talking about. And as we learn more about it in the coming meetings, I think that'll help us all get a better, wrap our heads around it a little bit better, Mr. Chairman. Thank you.
Representative Chestick?
Been rolling this around in my head. It's still very complicated to me. So if you have some coal owned by the federal government and they don't lease it or they don't exploit it, how do we get the money, get it back from the federal? We just talk about the privately owned coal, or and the federal is still going to be a problem.
Some people call it insurrection.
Mr. Chairman, I can take that one.
Yes.
All of the states have a carve out, Representative Chestick, for government owned property. So government owned minerals would not be subject to the law.
You always find that owner.
Other questions? Yes, Representative Webb.
Thank you, Mr. Chairman. I just want to clarify with mine that I want to make sure that the property owner, the mineral right owners have the first right to, that they are notified and that they are the ones that finally give up the right to that mineral and not the state having coming in and taking adverse possession or companies or whatever else. So.
Mr. Chairman.
Mr. Detail.
That's our intent. Yeah, our intent is to make sure that the actual owner gets what they get, what they deserve and what they own. And I think the first part of that is figuring out who owns it.
Sounds like there's
Because one follow-up.
Yeah, go ahead.
Because at the end of the day, we need to know who owns the mineral so that we can develop it.
Great. Sounds like there's definitely a lot for this committee to discuss. And I think once we have a bill draft in front of us, it'll be a little more concrete and we can start to narrow our conversation. But this has been a good conversation. Thank you, committee. Thank you all for your presentation. I'm going to go to public comment. First, we do have some public comment on this topic, and then we'll come back to the committee. Yes. Mr. Obermueller. Is there any other public comment in the room? No? Okay. You're up.
Thank you, Mr. Chairman. Pete Obermueller, I'm the president of the Petroleum Association of Wyoming. Nice to see you all. Mr. Chairman, to the Judiciary Committee, I'd like to lodge an Eighth Amendment complaint that it's cruel and unusual to have a working lunch where the room fills with the smell of food that you all get to eat and we don't. It's nice to be here, Mr. Chairman. I appreciate this topic. Appreciate my friend, Mr. Detail, bringing it. Happy to be involved as it develops. I don't need to add too much. I simply wanted to maybe follow up a little bit on Representative Chestick's questions and a couple of the others. With respect to split estate, and I know Senator Hicks could go on about this for quite a while, but essentially that explanation is right, that the Homestead Act, when the federal government was trying to settle the West, they conveyed the surface but not the minerals. That's why, among a lot of other things that we get to deal with from the federal government, split estate is one of the most complicated and quite frankly one of the hardest and most tricky issues that my members deal with in the Powder River Basin. I think the number at this point is up to it's about 78% of all of Wyoming's mineral resources has a federal nexus, which means the federal government has a say on whether or not we can develop it. 78%. So that's why Mr. Detail and my members have to spend so much time with the federal government. That being said, then, so that's a different animal. We know where the federal minerals are, and we know where the state minerals are, but the fractional private minerals really does become a challenge. Quite frankly, in some cases, just to find them. Now, in the oil and gas case, we have a long 100-year precedent, judicial concept known as correlative rights. And correlative rights is the right of every surface or mineral owner to be able to access and be paid for the minerals that they own. And what we don't want to do, and there's a corollary to that about waste. Waste isn't garbage. What we mean is that we strand a resource and waste it, which does not benefit either the mineral owner themselves or the state of Wyoming in terms of tax revenue and all of that. So in Wyoming and every other oil and gas state, there's a process by which mineral drilling units and basins can get pooled together so that we can still produce and yet also make sure that every single mineral owner is paid for the extraction of what they own. I don't have the number in front of me, Mr. Chairman. You may know it, but you've probably heard the state treasurer talk about the unclaimed property, and it's a pretty large number. And you might think, man, how do we get that big of a number if people are just like they were owed $10 from their refund from their library or whatever. It's mineral rights, it's royalties where we couldn't find the owner, and so it goes into unclaimed property and sits at the state treasurer's office waiting for someone to come get it. So anyway, that's all I wanted to say about it, Mr. Chairman. I'm happy to answer questions about how oil and gas works. I know this committee doesn't get a lot of that testimony, and happy to answer those questions in relation to this effort. Happy to be involved.
Yes, Senator Hicks.
Yeah, Mr. Chairman, Pete, so because you do have the ability to unitize these units, which basically allows you to produce those when there's multiple owners anyway. So having that ability already, what benefit do you see that this law would bring above and beyond your ability? Because those are unitized anyway, you're producing those minerals under these estates. What other tangible benefits can you see by moving this direction with something like, is there something out there that goes beyond unitization that could be helpful?
Mr. Obermueller.
Mr. Chairman, thanks. At risk of getting put in a headlock by my friend, Mr. Detail, I don't know. I'm happy to be involved in the discussion, but it may.
Look out.
Yeah.
Here comes the sleeper hold.
There may not be a tangible benefit to us. There is a process. That said, it is a problem it absorbs an enormous amount of hours of my members to try to locate fraction owners. Sorry, Mr. Detail, please be nice.
Yep, there's no headlock coming, Pete. Mr. Chairman, Senator Hicks, the difference between oil and gas and say bentonite is we can't pull. If we can't get the right in the middle of that deposit, we can't mine it.
Senator Hicks.
If I can editorialize, I don't see the benefit to the fluid mineral producers, but I see a significant benefit to the surface owner under that scenario, even under the fluid minerals, because it gets back to a lot of those checks are just going right now into the unclaimed property division. And now the person that owns that would be able to capture those revenues. So it may not be a direct benefit to the company, but it certainly to that surface owner could be a very lucrative scenario to claim those minerals where they're private.
Mr. Obermueller.
Yeah, Mr. Chairman, thank you for that. I just, you prompted my memory about the previous discussion. I don't know. This is just, maybe I should just keep my powder dry for now, but it strikes me that if we do move forward on this, I'm not sure that it's wise for the committee or anybody else to try to come up with with an exhaustive list of what we're talking about, unless we wanted to just keep it to, to solid minerals and keep fluid out of it. It makes sense to me to have just subsurface ownership, whatever that ownership is.
And Mr. Chairman, Senator Hicks, that's part of our intent. We want the person that owns the mineral to get paid.
Representative Senator Craigo.
Mr. Chairman, not a question, but maybe just a quick response to Senator Hicks' question, which I think initially there won't be a huge benefit to Mr. Obi-Mueller's association, but I think over time, they spend a lot of money on landmen every day. I mean, and so over time, this will help clean the records up. I really believe that. I mean, not right away, but over time, it will make their jobs easier and they will be spending less money on title searches. I believe that's one of the benefits of the idea. But initially, I think he's right. It's not a huge benefit, but upfront, but over time, long term.
Mr. Obermuller?
Mr. Chairman, I have many landmen members and I'm not here to put them out of a job.
Better be careful. All right. Thank you. Going to online public comment, Scott Meyer, you're up first.
Thank you, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association and also as
Mr.
an
Meyer,
attorney
can you
that's
hear
been
us?
almost. Can you hear me? Can you hear me now? Can you hear me now,
Mr. Meyer, we
Chairman?
can hear you. There's just a delay between me and you, so it seems like we're not paying attention, but we are.
Very good. Anyway, Scott Meyer on behalf of the Wyoming Bankers Association and all your community bankers, and then also as an attorney that's pushing on 30 years as a member of the Wyoming State Bar. I will agree with Senator Crago, I think from an attorney standpoint, and I think also Senator Olson would probably agree. This is a big problem from attorneys when you're starting to deal with mineral interests that are not like 164th, but like 100 and 200, one of 256. And you're trying to split these things up and trying to figure out who is owning what. This gets to be a bigger deal than most people would estimate, and probably more expensive than most people would guess. I think from the Wyoming Bankers Association, our only concern is making sure that any liens that we have out there, that we have plenty of opportunity to make sure that those liens are corrected as time goes on. And I think that at least the language that we looked at in North Dakota, there's enough years out there that I think that would work. So we're happy to be in support of this and work with the committee in making the appropriate legislation.
Any questions for Mr. Meyer? All right. Thank you, Mr. Meyer.
Yep.
Let's go to Ms. Carpenter.
Mr. Chairman, can you hear me okay?
Welcome, Ms. Carpenter.
Oh. Mr. Chairman, can you hear me okay?
We can hear you. Just so you know, there's a delay between us, so it takes a little while to communicate messages back and forth.
All right. Yes, sir. Thank you. Thank you, Mr. Chairman, Mr. Co-Chairman, members of the committee. Thanks for the opportunity to join you remotely today. Kelly Carpenter, Policy Advocacy Director with the Wyoming Farm Bureau Federation. The Wyoming Farm Bureau Federation is comprised of over 2,000 farm and ranch member families involved in agriculture. And we are proud of our grassroots policy development process that drives our advocacy work on behalf of our membership. Considering we're at the outset of the consideration of this topic, I'll be brief. But our organization is interested in this legislative topic moving forward. And should the committee move this idea forward, we look forward to being at the table as it develops. Thanks again for the opportunity to provide comments, and I'll take any questions you or the committee may have.
Any questions for Ms. Carpenter? All right. Thank you, Ms. Carpenter. Welcome, Ms. Agan.
Thank you, Mr. Chairman. Can you hear me all right?
We can hear you. Just know that there's a delay between when we say something and you hear it and when you say it and we hear it.
Yes, thank you. I noticed that. Carrie Agin, resident of Buffalo and retired geoscientist. I'm speaking for myself. First, I want to correct a couple of things that the gentleman spoke about. One is that federal mineral estate, federal surface, is not owned by the federal government. I've worked for the federal government. I was a geologist. I dealt with patents all the time. The federal government does not own the land. The public owns the land, and the federal government and the various agencies administer it, in other words, manage it on our behalf. Same with state land, county land, city land. So I want to clear that up. Another one was, another one is that, yes, this could very well be a Fourth Amendment violation, a taking by the state, and then especially made egregious if the state then turns around and gives that ownership to someone else. I understand this is a difficulty with a lot of companies and title companies that takes a lot of time, a lot of costs. And, you know, when you're dealing with 1/64th of an interest, I imagine that's got to be a lot of headache for not a lot of reward. So I have a couple of suggestions. And if I think of that second correction, I'll bring it up. If not, I'll make note of it for the next meeting if this is brought up again. So one suggestion is possibly to set up estate escrow accounts for these acreages. So estimate the lateral extent of the acreage and then say the thickness of the acreage that's involved. I know for petroleum, a lot of times the formation is indicated or the range of depths is indicated. So you could come up with a volume and then estimate also like a weighted amount, say if it's extremely critical to the project, you could weight it more heavily. If it's just on the outskirts or just under a road or something like that, it could be weighted much, much less. So that's one suggestion. Another suggestion is maybe looking at some type of unitization, like is done with petroleum. So for the solid minerals, maybe to look at some type of unitization for that as well, where, you know, 85 or 90% of the mineral owners need to give their specific consent, or 95%, and then the rest of them, I guess, deal with it very similar to how it's done with petroleum. So those are my thoughts. Thank you very much for allowing me this time, and I'll stand for any questions.
Thank you, Ms. Agin. All right. Folks, we have one topic remaining before we recess for our tour. We are a bit behind schedule. I don't see Director Shannon. No.
He's gonna wait for it.
He's going to wait for us? Okay. Just so the committee's aware, we've got some flexibility on the time that we go to this, that we go on this tour for the Medium Correctional Institute, but we have a hard stop time on the completion of the tour. So we are going to try to press forward and hopefully get through the next topic within its scheduled time. Possibly if we can get through a little sooner, that'd be great. And then we can, that way we respect time and the facilities and et cetera. So with that, we'll move to the Wyoming State Hospital topic. We have the Wyoming Department of Health and Mr. Thompson.
Mr. Chairman,
Senator?
just one I guess, quick clarification. Are we going to give any directive to staff on the last topic we talked about before
Oh.
we move on?
I'm sorry. Yes. Would you make a motion for a bill draft?
Mr. Chairman, I would make a motion. I would move that we have a bill draft prepared similar to North Dakota's version to start with. And then also included in that motion would be a memo from staff regarding challenges to these types of laws in other states.
Okay, it's been moved and seconded. Any discussion? All right, all those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted. Mr. Fuller, is that clear enough? Okay. All right. Anything else on that topic before I officially move us forward? No? Okay. All right. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Stefan Johansson. I'm the director for the Wyoming Department of Health. At the other end of the table is our deputy director, Franz Fuchs, and really pleased to be joined here with Alan Thompson with the Wyoming Association of Sheriffs and Chiefs of Police. Mr. Chairman, we'll be sensitive with your time, knowing you're looking forward to the tour of the correctional institution. Can probably be pretty efficient with this presentation, hit the high points, and really not to bury the lead. One thing that I'll be offering or requesting at the end of this presentation is either the whole committee, the chairs, any members of the committee that would like to join us offline in work group sessions on this particular topic that we will discuss over the coming months in the summer during this interim. We're doing something similar with the Sheriff's Association and some individual sheriffs to really workshop some of the options on this topic that you'll hear today. I would love for any of you to join us in that. It might be a good opportunity, Mr. Chairman, to dive further into the weeds than doing all of that in today's presentation. However, any questions that you have for me throughout the presentation, please interrupt and we'll try to answer them as best we can. Mr. Chair, what we were asked to present on the Wyoming State Hospital is really a specific issue within its operations revolving around our criminal justice service, our forensic services, which are a specific component of the state hospital, really governed through Title VII of Wyoming statutes for individuals who have been charged with crimes, arrested for crimes, and there might be a mental illness either causing it or related to it. So there's evaluations that the court can order from the Wyoming State Hospital and also inpatient services in Evanston at the Wyoming State Hospital that are part of that system. But I thought just very briefly, a couple of minutes, a little bit of a background on the state hospital just to orient the committee to the facility. As I mentioned, it is out in Evanston, Wyoming. It's our only state-run psychiatric hospital in Wyoming. It's a 104-bed physical plant capacity, and it really has two primary components. One is on the civil side. So when you think of Title 25, folks who have not committed crimes but are deemed by courts to be dangerous to themselves or others, they can be ordered for inpatient treatment at the Wyoming State Hospital. By bed capacity, that's the largest part of the state hospital's operations. Out of the 104 beds, effectively what's assigned, it does move around, but what's assigned for the civil component, Title 25 component, is around 75 or 80 beds. The second component of the Wyoming State Hospital is our criminal justice services, or our forensic units. And that's, as I mentioned, all governed by Title VII. So individuals who have been charged with or arrested or are being held in jail for crimes, and there is either a mental health evaluation that's been requested as part of that legal process, or further in that process, an inpatient order that has been given to us by the court to admit that person for what we call restoration or treatment services at the state hospital. We generally operate about 25 forensic beds at the state hospital in Evanston. But as I mentioned, that does fluctuate depending on the need or the type of clientele, the types of orders we have. We will shift bed space around to try to accommodate as best we can. There's about there's exactly 364 full-time employees authorized in the budget at the Wyoming State Hospital. We wish all of those were full, especially with the direct care staff, CNAs, nurses, security staff. that make up the vast majority of that 364. But when we have vacancies, we try to do our best to maintain the service we provide to courts and to law enforcement. And so when those positions are vacant or we struggle to recruit, we will use funding that we have available or try to make it available to contract for CNAs and nurses, which does come at a cost. It's something we do reluctantly, but across all 5 of the Department of Health facilities, something we unfortunately have to rely on from time to time. About 3 or 4 years ago, 4 or 5 years ago, cut the ribbon at the new state hospital on the campus in Evanston in 2020. The legislature over the past 8-9 years invested, and we're very thankful, in completely rebuilding the Wyoming State Hospital in Evanston. A variety of reasons for that, both physical plant conditions, seismic conditions, a very dated facility that we moved out of in 2020 and 2021. We're really pleased to be in the new facility. If you haven't been there, I know some of you have. It's a wonderful place, much more modern, state of the art, and very pleased to be in that new building. So why are we here talking about the state hospital today? To put it bluntly, we have a long wait list for services at the state hospital, both on the civil side, but especially with the topic we'll consider today on the forensic side, which is a partnership between us, the courts, and law enforcement, who all bear the brunt of some of these issues. On the Title 25 side, so the civil side, we're slightly over on average about 60 days from time of order to the time of admission for a Title 25 patient. On the forensic side, on the Title VII side, inpatient and outpatient. The vast majority are handled on the evaluation side, are handled outpatient. And what that means is one of our contracted forensic psychologists will either go to a jail to conduct that evaluation of that inmate or that detainee, or do that evaluation remotely on video conference. And that generally we turn around right now in a little over 40 days on the outpatient evaluation side. When those evaluations happen and one of our contracted psychologists makes a recommendation to the court that either yes or no, this person was competent or incompetent at the time of the offense, and in many cases that evaluation deems the person to be incompetent and in need of restoration or mental health psychiatric services. In that case, a judge can order that person for inpatient treatment to the state hospital. So on the inpatient wait time, our most recent month, we were around 120 days from the time of order to the time of admission to the state hospital. And this is really the crux of the issue. That has fluctuated over time, and depending on the case, that time can be less, that time can be more. But on average, we're around 140 days over the most recent year from the time that the inpatient order happens to the time we have a bed available to serve that patient. And the reasons for that, as you'll see in this presentation, which again, I'm trying to expedite here to get you to your tour, there's about 4 or 5 main reasons for that. One is just the physical capacity of the state hospital. Again, we are on the forensic side operating effectively about 25 beds physically in Evanston for this type of population and these types of orders. The second component is just the growth in orders over time. So the number of orders that we get for the state hospital, both in civil and forensic commitments, which we're talking about today on the forensic side, have grown over time. Over the last 10 years, we just see more orders from the courts, and no judgment there. We just have seen higher volume. So there's more orders competing for a static number of beds. Third, we do struggle and have struggled across all of our Department of Health facilities with staffing, with recruiting the appropriate amount of staff that we need to fully operate all of those beds. So in the 104-bed facility in Evanston right now, we're at capacity with our staffing to serve about 80. So we have, around 20, a little over 20 beds that if we were fully staffed, we could certainly open those up. Does that solve the problem entirely given the volume that we'll talk about? No, but it would certainly speed those processes up. And then finally, with our external partners, both In my own agency, as I mentioned, we have other Department of Health facilities. We have our Life Resource Center in Lander, which is connected to the state hospital with populations that we jointly serve. We have a nursing home in Basin, the Wyoming Retirement Center, which over the past 2 years, we have tried to leverage more for our higher acuity long-term care patients who may have been served at the state hospital and have advanced dementia, but also, schizophrenia or some sort of psychotic disorder, and we cannot find private placement for them. We've started serving more of them at our facility in Basin. And even at our assisted living facility, the Wyoming Pioneer Home, beautiful facility in Thermopolis, if you haven't been there, also have started incorporating more of that safety net component when appropriate and safe to serve, to discharge folks from the state hospital and serve them more appropriately in our facilities across the Department of Health. But also in our community, you've heard a little bit about our behavioral health redesign for community mental health centers, community mental health providers. Over the past year, we have begun paying differently for those services to try to, when possible, serve this higher acuity clientele with community providers, both on the mental health side, on the developmental disability provider side. There's a lot of overlap in these systems of folks who might end up in the legal or the judicial system that you all discuss and oversee. That do often end up in the state hospital or the correctional system, and we're trying to reform as best we can, pay for as best we can within our payment policies to incentivize our community providers to be incentivized, but also paid appropriately for serving what is sometimes a higher acuity clientele. And all of that is because if we can have the state hospital really achieving its full mission of being an acute stabilization facility where you don't see these incredibly long-term stays, then it really does act as that support function for the judicial system, for law enforcement, and both our internal Department of Health facilities, our community providers, and some of the reforms that we'll talk about shortly really do weigh into this overall problem that unfortunately our sheriffs, our law enforcement, bear the brunt of when they have someone in their facility who needs to be served at the state hospital, and we're just struggling to get a bed open for them. So as a long overview, I promised we would be efficient, but what we really wanted to target your slide deck on today and more as a reference document going forward is we do strongly believe in the Department of Health. I believe we have existing resources that can improve this problem, lower these wait times, and also serve these people in a more effective and efficient way, but also some potential new ideas that this committee and the legislature could consider, some of which you've heard about through the pilot programs with treatment courts, through our behavioral health redesign, through some programs we've started experimenting with over the last 1 to 2 years. And also, as a proposal that some of you have heard from our sheriffs, is reimbursement for jails for holding Title VII populations that are ordered to the state hospital, but in that waiting period, because there's just not a bed that's open at that time. So, Mr. Chairman, if it's okay, I'll hand it over to our Deputy Director, Mr. Fuchs, very quickly to go over some of the data. There's some good news in some of these wait times that we think correlate to some of these efforts over the last 1 to 2 years, where we're starting to see signals of the wait times and the wait lists reducing on the Title VII forensic side of the hospital, and then queue it up for a little bit of discussion on what some of those options would be that we could leverage more and potentially have some of you participate with us over the summer and maybe some targeted work groups on flushing out those options. Mr. Chairman, I'll hand it over to Deputy Fuchs.
Deputy Fuchs, welcome.
Thank you, Mr. Chairman. Again, Franz Fuchs, Deputy Director of Wyoming Department of Health. Just here to orient you guys to the slides that we provided. This, for example, this graph here shows the number of orders, the total number of orders, both on the outpatient and inpatient side received since 2015. And you can see that as the average there is going to be that red line with the monthly counts as the dark columns. That average is pretty much stabilized at this point around 37, but has grown from around 20 over the last 10 years. Within that demand, we have inpatient and outpatients. These are stacked on top of each other. So if you were to, basically replacing that gray with the subparts there, the outpatient on the top, you can see most of the growth has been in the outpatient evaluations, which has been good news for us. By county, you can kind of see the trends here. So each county is a small little graph in there. The total number of evaluations in the month is a dot, and then the average is the red line. So you can see, for example, Laramie County, LaTorna County, no surprise, largest populations in the state, going to have the largest number of orders. There has been a downtrend in Laramie County recently, which has contributed to this slowing, I think, of the volume generally. And then we look at the wait times.
Senator Hicks.
So when I look at this data, the one that jumps out at me, obviously Laramie County's largest population, 20% of the state of Wyoming reside in that county. What is going on in Teton County?
Are you looking
that
at?
is Laramie
That's
County.
Laramie.
Oh, yeah,
Teton's
that's
the bottom
Laramie
one.
County. All right. Now,
Okay.
Mr. Chairman, ignore that last question.
All right.
Strike the designer.
Yeah. Strike that one from the record. Go ahead.
Thank you, sir. On the next slide, looks at the wait times. So what we try to do here is we try each of these dots is one case. And so you can see it's, obviously an eye chart. We try to basically show the distribution with the solid line in the middle is sort of your mean, sort of dashed line is your median. And then we have sort of, 60% probability within that first inner cone. And then I think it's 90% probability in the outer cone there. So obviously the wait time varies significantly by case, but the average, I think the good news the director is alluding to, we've seen a little bit of a stabilization and downtrend in the wait time on the inpatient side. So for around 2023, you can see the average peaking around 180. And now our estimates are down to around 150 or so. So that's positive news. But again, we prefer the outpatient. As you can see on the right side of that chart, the outpatient evaluations happen much more rapidly. That sort of correlates with our wait list. So the wait list has shrunk slightly. Again, not a huge improvement yet, but again, we're slightly positive news here. So what you have here is the census is that blue bar at the bottom, and then on top of that, we've stacked the wait list. So that's the total sort of volume of people sort of waiting in the system is around 55 to 60 folks at the moment. And then again, why is there a capacity problem? We're trying to break this down into math. At the end of the day, the total number and average number of people in the system is going to be a product of the arrival rate and the length of stay. So there's only a certain number of levers that you can pull to try to address this problem. We've tried to illustrate those levers here. What the jails are experiencing, the problem we're trying to solve, right, is that red, is the wait list. That's the overage of the number of people in the system that we cannot serve in the hospital. The other levers we can try to pull, court order volume, we don't really control that. Our ability to complete evaluations and restore, again, not something we can control too much, but we do try to discharge people when they're whenever possible. The more we have a fixed number of beds, but if we could turn those beds over faster, those beds can be more efficient. And again, as the director mentioned, these are just some stats on our staffing. Really, it comes down to nurses, direct service professionals, or CNAs. That's a DSP and CNA respectively. And you can see our current census is just below the 80 beds staffed. And with that, Mr. Chairman, happy to turn it back to the director to talk about some of the solutions.
So,
Data. One question: do we track recidivism here, and how much of a problem is that? Both outpatient and inpatient.
Mr. Chairman, Senator Hicks, we do, and we're happy to provide those numbers to the committee. Generally speaking, across all of the state hospitals operations on the inpatient side, civil and forensic, over time, we've seen around a 25 to 30% recidivism rate when we match, people and IDs that have come back over time. And I think with some of the items we'll talk about it, get feedback on, or queue up, additional work over the summer for those interested. A lot of these tools that we're talking about with treatment courts, with reforming our behavioral health centers in the communities, with our own internal reforms in the Department of Health, using our facilities smarter across the enterprise, and with our partnership with the courts, with judges, with law enforcement through sheriffs who have partnered with us to try to implement things like telepsychiatry services that we can provide in the jail, or connecting them to their community providers. I think that's the key, or potentially the keys to reducing that recidivism. It doesn't sound like a high number when you talk about 25%, but it absolutely is. We know, and our communities know, our judges know, our law enforcement partners know, oftentimes who these folks are. And as Chief Justice Fox has said often, we need to work smarter in this system because the judicial system and law enforcement system have become de facto mental health centers, and we're really trying to break that cycle.
Sorry, Representative Webb.
Thank you, Mr. Chairman. As you do your presentation here with solutions, could you please include in there why we don't compensate the jails? I think the counties are taking on a huge liability and responsibility, and they are not being compensated one dime, and I think that needs to be addressed.
Director.
Mr. Chairman, Representative Webb, it's an excellent point. And I'll answer directly, and then we'll certainly get to it in this discussion. The reason for why there's no compensation is there's no statutory mechanism to do it. On Title 25, on the other side of that coin, on the civil commitment process, the Department of Health is directed to reimburse providers, i.e. designated hospitals like WBI and Casper, or general providers, hospitals that might hold on to a Title 25 client while they're going through the process or committed to the state hospital. And after the first 72 hours of commitment, we are statutorily compelled to reimburse for those services. On the Title VII side, there's just no statutory mechanism to do it. The reason why, it's probably historical. It had not been a problem in decades previously, but there's not a really foundational reason or a policy reason why compensation isn't there. What you'll hear is my contention in this issue is that while we are completely agnostic, if not supportive of, if I were operating a jail, I'd want to be reimbursed for folks who are destined for the state hospital that I'm holding on to. It doesn't solve the problem. The volume is still there. And so being compensated for that doesn't fix the wait time or the wait list or the volume issue that we see with this population. And we're trying to combine that in sort of a menu of approaches or options, including reimbursement, that the legislature could consider or help us leverage more. But hopefully that answers your question. There's just not a statutory mechanism for us or any other state entity to reimburse jails under Title VII holds.
Thank you, Mr. Chairman.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Well, Director, I guess this Title 25 thing obviously continues to be a problem. You said you're lacking staff. How much staff? And if you had the staff, what would it do to the wait times? And I have a follow-up question. Thank you, Mr. Chair.
Director.
Mr. Chairman, Senator Kolb, right now we're approximately 35% vacant on nurses. So we could certainly provide the math. I'm not good at calculating that on the fly. But about 35% vacant on nurses. The good news is right now we're about 13% vacant on our CNA positions at the hospital, which is a big component of direct care there. That has come down dramatically through efforts we've made over the last year and a half. Some of that was the legislature's appropriation for state employee compensation. My department has about 1,400 authorized positions. 1,000 of those, so over 70%, of the Department of Health's workforce are out in our facilities, those 5 facilities I mentioned, or in our field offices like public health nursing. So that has certainly helped. To answer your question directly, we still struggle, and it's always evolving up and down with being competitive in the healthcare labor market. We have both within the state and outside of the state CNA wages that are far more attractive to staff. And the state hospital is not an easy place to work. It's a challenging environment. You really have to love it and love that type of care to stay. But I am proud that over the past year or so, we've brought some of those numbers down. At the Life Resource Center in Lander and at our nursing home in Basin, it's an incredible challenge right now to find and recruit those state staff that are there. We're over 70% contract labor at the nursing facility in Basin at the Wyoming Retirement Center. So we're paying a lot for that staff out of the 900 series. And I think the primary reason for that is there's probably a sweet spot with our wages for CNAs and nurses specifically that could increase that. Why do I mention the Lander facility and the Basin facility when we're talking about the state hospital? with the work we're trying to do to serve those populations in more appropriate environments, like long-term care, or in the Life Resource Center's case, folks with developmental disabilities and exceptional difficult behaviors or mental health diagnosis. That's what we and you all have invested in building the new Life Resource Center for. Staffing that up and being competitive would absolutely have an impact on the wait times and wait list at the state hospital, because we could more quickly and efficiently discharge folks out of the acute hospital institution and into more appropriate environments.
Senator Cole?
Yeah. Yeah, thank you. Just a follow-up. So I assume you have excess money within your budget because you're lacking the employees to pay for those positions. What, any thoughts? I mean, you talked about, you obviously realize it's a problem with the jails holding these folks. Why couldn't we propose some sort of a way to transfer money that you have, that you haven't expended it for whatever reason because you can't get employees? You know, I realize that's a problem, but to try to bridge this gap. And then when when things change, that could change. But what do you think about that idea? Thank you, Mr.
Director Johansson.
Mr. Chairman, Senator Cole, you hit the nail on the head. I think an important component there is when we have, those 100 series salary vacancy savings because those positions aren't filled. What do we do with those? We turn around and we contract for traveling nurses or agency labor at a premium. Just being blunt here, I can write for an entry-level nurse right now, I offer between $30 and $33 an hour. When I contract for a nurse, I'm paying anywhere from $75 to $100 an hour. That's where that money's going. It also goes per legislative direction from JAC in the budget to cover any overages we have in the Title 25 reimbursement budget to hospitals around the state. So you're absolutely right. Is there a way we could use that, what turns into contract expenses for outside firms to help staff our facilities to higher wages for these specific direct care positions? Yes, we've been discussing that within state government with A&I over the past year and a half. They're aware what an issue this is and what it's costing us on the back end. So I'm hoping to see some changes there. It's just difficult, Senator Cole, to be blunt, that the price tag gets high. You think of it as, well, if you're paying 75 or 80 bucks an hour for a nurse and you're offering 30 bucks an hour for that nurse, why not pay 35 or 40 and you save a bunch of money? That's true. But when you want to have an equity component to that with the nurses that have stayed with you, or across the enterprise of state government with corrections, with DFS, which I'm sensitive to as well, we're not a special snowflake in this challenge. That price tag becomes larger. But I do think there are natural sort of sweet spots or cut points where we save money on the contract labor side, on the 900 series side, by investing in slightly or marginally higher wages. The last thing I'll mention, Senator Cole, because I think it is something that money won't be the only thing that solves this problem. So I don't want you to hear your Department of Health director up here saying the only thing you need to do is give me more money for staff, because that won't solve the problem long term. I think the people that are the most prone to retention in my facilities, yes, we need competitive wages, but you also need upward mobility and career. And we've implemented some educational supports, educational leave, even some tuition reimbursement to grow our CNAs into LPNs and registered nurses to support that career trajectory. Also, flexible scheduling has been a big component of that. And quite frankly, being a part of a mission, this is going to sound a little touchy-feely, but this state and you all in the legislature, and I think the executive branch as well, has done a great deal over the last 10 years to reform and try to be better with our behavioral health system, that our safety net Department of Health facilities connect to our community providers, and we want to serve folks in those more community-based and integrated settings where I think we're thought leaders in using telehealth and telepsychiatry, and those initiatives. You all don't see it every day, but our staff at the facilities, they see that, and we want them to see that more and feel that they're part of something bigger. So I think those things with someone's career who might be starting out, working with the community colleges where they're often trying to promote this work, this safety net work, those are critical components as well.
Co-Chairman Washit.
Thank you, Mr. Chairman. I'll try to keep this brief. It seemed to me that these individuals present on a spectrum of severity. And from the sheriff's perspective, the individual who's running around naked, covered in his own feces gets at the top of the list. Does the severity of their condition get reflected in how fast they're granted access, or is it a first come, first serve system?
Mr. Chairman, Co-Chairman Wash, it's a really good question. Generally speaking, to try to be fair to every court, we are first come, first serve. We have a queue that just stacks those orders up. And when a bed opens up, that next one on the wait list comes in. However, there are special circumstances, and they're the exception to the rule, where in certain life safety conditions, I will move folks to the top of the list, but it's exceedingly rare. And you make a good point, but it's a difficult system to manage with fairness. And we try to do that by having a very strict wait list of when the order comes in, that case is added to the queue. And we do our best to, discharge folks appropriately so we can open up beds. But generally speaking, it's first come, first serve.
All right, please proceed.
Mr. Chairman, very quickly, and we'll get to the kind of the crux of the issue. There's kind of 4 domains I wanted to present to the committee today around what we think are some tools that can be either increased, leveraged, or considered by the legislature to help address this problem. The first bucket is really increasing our effective capacity at the state hospital. And I already mentioned many of these points within our Department of Health facility system, including the Life Resource Center and the Retirement Center, really using what I view as a regional health system that we have through those facilities that the department operates in a way that is not completely, but more targeted to this acute problem we have with these populations. In addition, I already mentioned the reforms that you all in the legislature have directed and that we have implemented around paying appropriately our community providers to target what is essentially 3 priority populations in behavioral health. One is acute psychiatric adults, and that's really subsumed within Title 25 populations. The second are criminal justice involved, both state corrections and local county law enforcement. Those are automatic priority populations for our community mental health centers, who generally offer outpatient mental health services and some regional residential mental health services. The third priority population really connects to ours and Director Schmidt's population of high needs adolescents and their families. Folks that might be adjacent to or in the DFS system are again automatic priority populations as of last July 1st for the community mental health funding that I have in my department. So I think increase these things that you don't see it directly, but there's an absolute indirect correlation to our Department of Health facilities operating more efficiently and effectively, and our community providers being paid for and incentivized for this type of population will have a direct impact on the efficiency and efficacy of the state hospital as it pertains to serving the courts and serving our law enforcement partners. And finally, within this category, just a blunt statement here, we've got to be better in the Department of Health at recruiting. It's a challenge. We've talked about it for a few minutes here. Salaries are a component of that, but there's other elements as well that we're really working on. Like I mentioned, educational leave, educational support to really try to show that working for the department and working for these types of facilities, our state hospital, for example, is a rewarding career and one that you can build on and you can be mobile in that career. So we think those are important components. Second, we want to reduce evaluation demand. And that's not because we want to abdicate our responsibilities and stop doing this. This is our critical mission work in the Department of Health and the state hospital. But these are some of the items that over the last year or two, you all have heard about in trying to use the system more efficiently, maybe not rely on the judicial system as much. And that involves our behavioral health redesign that I've already spoken at length. So I'll leave that there. But we're really trying to divert the higher risk people, stabilize and treat in the community as much as possible so that we're not relying on the courts, the jails, and the state hospital when we don't need to, and that it doesn't have to be the only provider in the system for folks that present with these conditions. And I'm optimistic about some of the progress there. In collaboration with Chief Justice Fox, the Administrative Office of the Courts, the Supreme Court, and several communities and county attorneys and judges and sheriffs, right now in Campbell County, Laramie County, and Natrona County, I know there's a lot of nuance here. I'm really optimistic about our Title VII diversion courts, treatment courts. Not because it's a be-all, end-all solution that anybody who says, well, I have a mental health condition suddenly doesn't have to be, go through the legal system and face charges for their crimes. But to Senator Hicks's point, you do see quite a bit of recidivism, especially at your lower risk misdemeanor level of disturbing the peace, shoplifting in a gas station or a retail environment. And that repeat pattern for someone with a diagnosable condition, and we're talking your real top 3 or 4: schizophrenia, schizoaffective disorder, major depression, things that are often very responsive to rapid treatment, often with medication. We see those folks occupying a large number of beds in our law enforcement system, and frankly, a large number of beds in our state hospital. Often we cite the number that around 30% of our inpatient beds at the state hospital for forensic populations are misdemeanors. And I think these treatment courts, as a way to connect more rapidly to treatment, give local control over whether charges should be levied or held in abeyance as treatment is completed, is a really promising program, both in Campbell County, recently launched in Laramie County, in Cheyenne, and in Natrona County, that we continue to monitor and try to support with the providers that Department of Health already pays for and contracts for. So I think that those two components are a huge element of reducing this overall demand.
Mr. Chairman.
Representative Chestick.
Thank you, Mr. Hanson. Director Johansson, is there a flip side risk that creating more treatment courts creates more demand on the services, more avenues into the system? Director.
Mr. Chairman, Representative Chestick, I think, yes, academically, that's absolutely possible. I think the key there is, what type of criteria does a local community use to determine who would qualify for that type of program? And that's what has been set up in the 3 pilot diversion courts that have been set up, is really for your lower level crime, so only misdemeanors, and the types of conditions that absolutely have to be evaluated, and a determination has to be made there. As we've talked about, in some of our smaller communities, we know who these folks are, and sometimes those folks have been to the state hospital and have a history of these conditions. But let's be honest, it's absolutely fair to think that this could be an avenue to not face what is appropriate punishment for a crime. But I think those criteria are the most important factor of mitigating that. And through the programs that have been set up, there's so many folks at the table that sign off on those agreements, even to set up the program, let alone to sign off on who could participate in it or be diverted through a program like that I think there's reasonable checks and balances in there. Mr. Chairman, third, reduce wait times and mitigate impacts on jails. There's a few tools that we've either started implementing, like our telepsychiatry program. This is something I'm very excited about. We have partnered and executed agreements with 3 sheriff's offices in Sheridan County, in Laramie County, and in Campbell County. Laramie County really came out of the gate wanting to help us build kind of a manual for how this could work. This is tough work. There's legal liability components around, sometimes forcible medication. These are tough scenarios to be in. But to Chairman Washett's point, at the highest end of the acuity pyramid here, what jails and sheriffs are dealing with, certainly what our state hospital staff deal with, you have folks that are really, really in crisis, and their behaviors are extreme, very self-harming, harming to staff, jail staff that are trying to serve them, often having to be in isolation, 1-to-1 or 2-to-1 staffing, really talking about that upper end of the pyramid. And what we implemented last fall in the agreements that I mentioned is to try to mitigate some of the legal liability risk on the side of the jail, with the Department of Health taking that on by contracting directly for MD level psychiatrists that can provide evaluation, diagnosis, and direct care through telehealth, and which I think is one of the keys in Wyoming, that psychiatrists are hard to come by. We need to stretch them as much as we can. And again, Laramie County Detention Center has really partnered with us to evolve and iterate how this could look. And if you talk to Sheriff Kozak or his team in the jail there, I think we've made a lot of progress where folks have received care directly through this program, and really through the good work of the jail staff. They're trying some things that are a little bit different. And what are they trying to see? It's not just get the person out of jail, because the staffing component in the jail, when someone's isolated on a one-on-one and with those behaviors, can be extreme. And the short-term outcome is, how can we serve this person in general population while the legal system, Title VII system, unfolds? And we've seen that happen in a handful of circumstances where that person is no longer experiencing those behaviors and can be served in the general population. Then through those other programs I mentioned, like our community providers, if the community were to want to divert a client and have a treatment program in lieu of charges, those things become more possible to stabilize quickly, provide rapid access to treatment within the jail, and mitigate those staffing impacts on the jail, and ultimately potentially remove folks off the wait list for the state hospital, because they have helped ameliorate the condition or begin treatment on the condition. So it's really promising. We don't have a line item budget for it. This is something that we would want to continue to discuss with this committee in the legislature. If we prove out results that more than a handful of clients are served in this way, and we can see those efficiencies or those wait list reductions, wait time reductions, which we're starting to detect in some of the data that you saw earlier. But something we would love to work with members of this committee or come back, should you have us, and see how could this be structured in a more formal way outside of a pilot project. But it's I think, cautious optimism here, that really proud of Laramie County Detention Center and our other partners that we've been in discussions with. How can we model that? Not every jail looks like Laramie County, and not every jail wants to provide services like Laramie County does. And so we're working with WASCOP and some of the sheriffs to create a playbook of what these tools could look like. And
Representative Webb.
Thank you, Mr. Chairman. My question this time would be, medications have been mentioned and forcible medicating has been mentioned. Jails are not medical facilities. Jailers are not medical personnel. Do we want our jails and our jailers to be administering medications? It seems to me, once again, that's a big liability that we're putting up on our counties.
Director.
And Mr. Chairman, just to respond to that comment, which I agree with, we don't want to turn our jails more so into mental health centers. However, I think the tension here is the people are there and the conditions are there. So in several discussions and presentations to the sheriffs over the past couple of years, we've recognized that reality, and liability was one of them. So through that telepsychiatry program, again, tele being the key word there, we're able, through Governmental Claims Act, because it's a Department of Health contractor, to at the very least remove or mitigate some of that medical malpractice liability, where my agency takes that on legally, because we believe that treatment needs to happen. But your point is very well taken, that there has been reticence to get into that type of business. And so again, through some of these options, I think there's ways with, for example, in Natrona County, we've got our community mental health center, who's very excited, really pinging my email and phone a lot, that wants to be that service provider, so they could partner with the jail, come in and do that where the jail wouldn't have to, if that makes sense. And I think by exploring some of these tools, we can look at where those where those points of leverage in individual jails or communities might be, because again, they're very different. Laramie County is much higher scale, has contracted healthcare providers, even mental health providers that they contract for. That's very different than some of your more rural or frontier communities who might not see as many clients, but when they do, really don't have that capacity. So don't have a silver bullet. It's not a perfect answer to your question, but worth knowing that we fully recognize those tensions. That there's liability on that side, but there's also liability, when folks are in jail on the physical health side, you got to take care of them. And so there's a certain amount of liability that if behavioral health conditions, especially those that result in self-harming or very violent aggression towards other inmates, other staff, there's liability on that side for the jails as well.
Thank you, Mr. Chairman.
And finally, again, I said I wouldn't bury the lead, but now we get to the reason you asked us to come present is directly compensating jails. And so this is not something the Department of Health really has a dog in the fight in. We're not unsupportive. It's a financial issue. And we were approached at the beginning of last session of by a few legislators, what would this look like if jails, and I think the opinions are mixed, but some jails say we should be compensated for this. While folks are waiting to admit to the Evanston facility, where's our reimbursement? And I totally understand where they're coming from. Based on our volume, we modeled some of that out for the legislators that were asking, and we estimated a cost of around $3 million general fund per biennium with the assumptions that you see there on the screen or in your presentation, just based on the demand that we've seen over the years. There's a lot of payment models that could be considered, and we're happy to help advise the committee should you take up this policy consideration. We're not to brag, but we're good at that payment policy theory and helping understand what the pros and cons are of fee for service versus paying on a bundle or having certain incentives within those payments like we do in many areas of the Department of Health. But certainly, I think part of the menu of services or of options here that you all have. And like I said, total sympathy with our sheriffs and jails who are saying, hey, at the very least, compensate us for this. It's taking a lot of staff time. It's not the most appropriate setting. And I think when combined with some of these other potential tools or options could be a huge component of making this system better. With that, Mr. Chairman, I know you're short on time. Certainly didn't want to dominate the presentation here and leave time for Waskoff to comment as well. Happy to answer any questions.
Senator Hicks.
Yeah, could you go back to your increased demand? And so, Mr. Chairman, just a little attitude here. This is like deja vu for I think the only one that's spent a lot of time when we were looking at probation, parole with corrections a number of years. And what we found out is the biggest escalator in cost was judges. And so if you could go back to that slide, it says increased demand, court ordered volume increase from 20 months to 37 months. And so that's a 46% increase based on the amount of time that the courts, the judges are saying you're going to spend time in some facility, whether it's county or state. So that's the biggest driver here. The question I have, and this gets back to when we looked at this for probation and parole, is there any clinical evidence? Have we mined the data that shows that the efficacy rate by going from 20 to 37 is having a benefit or not? And Mr. Chairman, the reason I bring this up is this committee actually worked with Pew Charitable Trust and NCL, and we went out and we took all of the state data from probation and parole. And we looked at that, and what we found out is what was driving the cost of probation and parole for corrections was 4 years, 5 years, 6 years probation. And all the data showed us if you get past 18 months and you had no recidivism, there was no need for probation and parole because it was single digit percentage of recidivism at that. So we were misallocating substantial financial resources. And I'm just wondering if we should take that data, do we know that 37 months, because this is the single biggest cost escalator amount of time that's driving this right now, it looks to me.
Mr. Chairman.
Where are we at with that?
Representative Washington.
Thank you, Commissioner. I think you're misreading the slide. I think what we're getting is 20 referrals per month versus 37 referrals per month from the judiciary, not dictating 20 months in the hospital or 37, but the
Just
number
the
of
increase in
cases, per month. And that's driven by the number of
Okay,
individuals.
that's a good clarification. I was reading that.
But
wrong.
Mr. Chairman and Senator Hicks, if I may, you hit on a good point, which is what's the evidence that, diverting or putting folks in treatment programs at certain levels of acuity, it's not all. And we were involved in sort of that criminal justice reform effort because, we pay for behavioral health providers. And part of that was over time looking at, well, for certain, low risk, medium risk, high risk folks of recidivism, where's the mental health and substance abuse need, and could we target that better? And one of your enrolled acts directed us with Department of Corrections to do that, and I think has borne fruit. Similarly, different issue, different population here. There is evidence both nationally and I think we're starting to see it in Wyoming that for certain folks that would be more prone to or responsive to treatment, depending on the condition, and again, on the logistics side, depending on the type of crime that's charged or alleged, then yes, I think you can break that recidivism cycle in those cases by some of these tools that we're talking about. And we don't have them perfectly flushed out. And I think a lot of it has to be tweaked for unique Wyoming needs. But to your point, Senator Hicks, I think that's exactly what we're getting at is no judgment here on the part of our wonderful judges around Wyoming. They get these cases, they get evaluators both from us and potentially from defense counsel saying, this is the need, this is the condition, and they make the order accordingly. But just by the numbers, that volume has grown. And so that's one of the elements I think that through some of these programs, even with static volume there, carving out some of those elements of the system that don't need, law enforcement holds or don't need state hospital admission, we could work a little bit smarter in the system.
Yes, Representative Breton.
Thank you, Mr. Chairman. I have a question about how long it takes to get the severe mental illness under control. So once that's diagnosed by the psychiatrist, how long, like on the average for those things, like, 2 weeks, a month, they're in the county jail. Tell me about that.
Mr. Chairman, Representative Bratton, it's a really good question. I'm going to give you an insufficient answer, but it depends. It really depends on the case, the condition. But, overseeing the state hospital, we see a variety. So some folks that get ordered to us, we stabilize in terms of their behaviors very quickly. A lot of those conditions require protracted treatment. So when we're looking at discharge and integration into the community, those treatment regimens are very different. I think not speaking for the jails or the sheriffs at all, that's not my world. But I think with that tippy top of the pyramid of some of the folks you see in really acute situations, extreme behaviors, violence, et cetera, that oftentimes, not all, and this does require strict medical oversight, medication intervention can ameliorate those behaviors in the short term while long-term treatment is planned. That's kind of what's necessary. But in that case, the response is generally pretty rapid in terms of stabilizing those behaviors. But I want to be very careful and clear here. I'm not a physician. I'm a numbers guy and a card-carrying bureaucrat. So happy to, in the weeks and months to come, as we work on these issues, involve my medical director and our medical staff to advise on some of those issues.
Representative Bratton.
Thank you, Mr. Chairman. And so also along those same lines, when you contact the telepsychiatrist from the jail, how fast is that turnaround? I know you talked about, the 60 days and the 90 days, but how quickly is that happened? So you're like, okay, this person, now they need to be on this. And then you have your time frame starts.
Director.
Mr. Chairman, Representative Bratton, with the program we launched as really a pilot, and Laramie County Detention Center has been the user so far. We're hoping that grows. It's a couple of days max when they request the intervention.
Thank you.
Great. Senator Kolb.
Yeah, thank you, Mr. Chairman. Director, and you had mentioned that you weren't here asking for money. So I would ask the question is, with the large budget you have, I mean, arguably, I think it's the largest budget in the state of Wyoming. There's $3 million you wouldn't have to potentially divert to the counties for the cost of what we're talking about. And if there's legislation, you need to be able to do that. I mean, I realize we're probably approaching an appropriations right now, but are you amenable to that thought? Thank you, Mr. Chairman.
Mr. Chairman, Senator Kolb. So over the last two biennia, the last 4 years up until we started this biennium, I'm going to sound braggadocious here, but I don't mean it that way. Department of Health offset or saved over $100 million general fund in each of those biennia. I think through being smart with our finances, but also in partnership with the Appropriations Committee, when certain cuts that we were going to have to make, the legislature didn't want us to make, you gave us authority to backfill those with projected reversions from those savings. And I'm absolutely open to that authority being here. I will say in this biennium, we are not in sort of the salad days of the previous two with our ability to offset general funds with some enhanced federal matches that we were able to get, and also just your Department of Health director locking down any projected unspent funds we had in the agency that our divisions and programs couldn't spend, but we put them into an account for these purposes. In the budget bill currently, we have that authority to spend projected reversions on Department of Health facility needs. So I see that as being already available within this current biennium, unanticipated Medicaid expenditures, and Title 25 overages. So there is precedent for what you're mentioning, and we're absolutely open to that, and happy to give this committee or you all individually projections on where we think we're coming in this biennium. It's much tighter. We do have a large budget, $2 billion budget. So I hear you. Seems like a drop in the bucket. But about half of that is federal funds that, are earmarked by the feds for specific purposes. On the general fund side, we'd be looking at offsetting other general fund areas that we would just want to be careful. My top 5 line items are Medicaid and our developmental disability and long-term care waiver programs, community mental health and substance abuse, developmental preschools, and then the state hospital and the Life Resource Center. That's where the vast majority of the Department of Health general fund is, and that's essentially the sources we would be taking from, but certainly open to it.
Mr. Thompson, do you have anything to briefly add? I'll give you about 30 seconds.
Or not.
Thank you, Mr. Chairman. Alan Thompson with Wascott. We've been having conversations about this starting from before the session this year. I think you've heard from some of our sheriffs and trying to talk about this cost impact on jails. And that cost it's not just in medications and things like that, but it's in overtime costs and impact on recruiting and retention with personnel in a jail. A severely mentally ill person in a jail setting, especially for a long-term wait for a bed, is severely impacting some of our jails, and especially some of our jails that just don't have the staff to handle. We're looking at 7-bed facilities up to 50-bed facilities that just don't see things like this, and then we have counties that have couple 100-bed facilities, and the difference between all of them is just very drastic. So trying to come to a consensus today to tell you what the sheriffs need from across the state is difficult, but I'll run through it real quick. So as the director had mentioned, there's mental health programs and diversion programs that are happening in various counties. There's various things going on at the local level that aren't even really touching on the state level, that are just trying to have a positive impact on the mental health problems within our communities. And then there is that concern about warehousing and waiting for hospital bed space that I think we've covered here. We're happy to discuss the option of starting treatment in jails, but not all jails are suited for that type of treatment. I think that that message was conveyed to the director when our sheriffs did meet with him last month. And we are excited about having this discussion going forward with the Department of Health. But the sentiment from the offices indicates concern with the Department of Health paying incarceration rates at I think it was mentioned $100 a day. So anywhere from that $60 to $120 a bed day similar to what the Department of Correction pays. And the Department of Correction does pay our jails after 10 days after they're sentenced and the paperwork's all at the Department of Correction. If they don't come pick up, there's a mechanism in state statute that allows for the sheriffs to be billing the Department of Corrections for those days. But that it also doesn't consider the increased medical costs and what those might be. So these discussions about, having ongoing medical treatment starting in the jail might positively impact. But anyway, that $100 a day, that's extremely cheap for mental health space. And many sheriffs are concerned that might become the norm. Some jails have that smaller number of beds and a lower number of mental health inmates. So $100 a day to them means real money in their budget. But when you're looking at a 200 bed facility and 5 of these inmates and $500 a day, that's not making a big impact on them. And they're more concerned about that being cheaper than bed space at the hospital. I think we all know that that's real cheap bed space. But they're more interested in offsetting the costs that are, not anticipated and not part of their budget. So the consensus is that if funds are appropriated, as many sheriffs have asked last session, that it be contingent upon an agreement entered in by that sheriff. For example, if a sheriff seeks and enters into a contract with the Department of Health, they can reimburse them at a certain rate for a certain number of days. And if a sheriff does not seek an agreement, they will maintain the status quo and be able to start treatment if working with the Department of Health, as we mentioned before. And most importantly, will not lose their place in line for physical bed space at the state hospital. In summary, the sheriffs would very much like to see the wait times diminished across the board for all persons in need of mental health treatment that are placed, and making sure that they're placed in the appropriate facilities. But secondarily, they would like a mechanism for reimbursement for those affected by these long-term and very time-consuming inmates. And I'd be happy to answer any questions if you have any, sir.
Representative Brett.
Thank you, Mr. Chairman. Who pays for the medications for the treatment when they're in the county jail?
Mr. Thompson.
Mr. Chairman, I wonder if somebody at this table might have an answer to that.
Okay. Director Johansson.
Mr. Chairman, Representative Braden, I'm going to make a habit of frustrating you. It depends. So some of this is relatively new in the jail space. We have the ability in some of those diversion courts that we talked about, our new programs that we've started, and through our behavioral health redesign to finance those medications, but it's not across the board at this point. With Laramie County Detention Center, for example, they fund a lot of their own healthcare operations with their own budget from the county and through their contracted healthcare providers. But again, some of the options we're queuing up here to dive deeper into is whose role should it be? If we're going to scale a program like jail-based telepsychiatry or, diversion programs in the communities, then my macro point in this presentation is we do have existing resources that could be tweaked to finance those things more comprehensively. But it's kind of like pushing on a balloon. We push here, it's got to come out somewhere else without your health director coming here and saying, I just need a ton of money to solve this problem. That's one option, but it's, to answer your question directly, it's kind of a mixed bag with who pays for the medication right now.
Okay. Co-Chairman Washut.
Thank you, Mr. Chairman. I'd like the comment that the director said about forming a working group to talk about this further, but I think perhaps the better approach would be you all are already well down the road. You're the experts. If you were to come back to us at our meeting in August and say, here's what we propose. Because I think we're always going to have 1,000 questions and 1,000 new ideas. And I don't know that members of the Joint Committee are going to add a whole lot to the value of your discussions internally between the sheriffs and the mental health. But the director said at our last meeting last year that, or maybe it was during the session, that he understood he was about ready to run out of runway, right? And we know that it's just a matter of time before we're going to face some liability issues here big time about people who are spending 4 times as much time incarcerated in the county jail waiting for their opportunity to go get mental health treatment. than they ever would had they been convicted and sentenced by the municipal court, right? And so I guess my recommendation is that we not form a task force or a working group from within the committee and let these folks continue their work, come up with a plan and come back to us in August and say, this is what we want incorporated in a bill draft. It'd still give us time to get a bill draft done and move forward before the end of our interim.
Yeah, I agree with Co-Chairman Washut. I think you've given us some potential solutions, one of which is the $3 million solution. But it seems like if the two of you put your heads together, you should be able to come back with a pretty good solution for us, at least to give us something to work from. And we could put some senators and representatives in a working group with you, but I don't know that will change what you already know.
And Mr. Chairman, happy to take that direction. Mr. Parks and I were talking before this meeting and over the past month or so of, we're going to do this work anyways. I'm thrilled that we have a committee interested in this topic because I think there's really good value that we can inject into this system. My offer is still, even informally, for those who will make time, even if it's not an official work group or a task force, that I think that feedback is important. We don't have all the answers to this. We think we have some good concepts and ideas, but would love to invite anybody from the committee, should you want to dedicate that time over the summer to join us in fleshing some of these out. But we'll absolutely, won't speak for Alan, but I think we'll continue that work, engaging the sheriffs and trying to come to some higher level consensus on what some of the options would be, both statutorily and financially.
Right. Senator Cole.
Yeah, thank you, Mr. Chairman. This is probably a last cop question, or I'd just like to say that within our state, there are counties that I will say have turned into repositories for other counties, folks with mental illnesses. And I can say it's Sweetwater. And it's many others, the larger counties usually have more facilities and so on. I guess when you're working this in your group, I would like consideration, thought about that we are not going to make that problem worse, or maybe we'll deal with compensation, because the reality is the smaller counties they don't have the people or the facilities to handle it. So I think we need to always keep that in mind, that the nature of our state is such we're going to have, places where a lot of folks go to, more than, say, a small county, say here. And I just like that to be, I guess, say that for the record. Thank you, Mr. Chairman.
Okay. Appreciate that, Senator Cole. All right, committee. So you've heard the ask from the director that if you want to informally get with them, I don't see an issue with that, but sounds like from here, we'll hopefully come back with some concrete ideas that we can put into bill drafts at our next meeting. All right. Thank you, Director. Thank you, Mr. Thompson. All right. Are there any directives from
Mr. Chairman? Sorry to interrupt. There is someone online for public comment.
There is someone online for public comment. Okay, let's do that. Anyone in the room wishing to give public comment? No. Okay. Miss Somerville, welcome.
Thank you, Mr. Chairman. Andy Somerville, Executive Director for WAMSAC. And Mr. Chairman, I don't have any particular comment to provide today. I just wanted to be here in case there were questions from that third leg of the stool, the jail-based services from the behavioral health providers. But I'm happy to work over the summer with the Director's Office and WASCOP on any of those questions as they come back to you.
Great. Any questions for Miss Somerville? No? All right. We look forward to seeing what kind of work product comes out of this. Are there any directives? Yes, Representative Lean.
Thank you, Mr. Chairman. I would like to move that LSO draft a joint resolution to repeal the Judicial Nominating Commission and add Senate confirmations for Supreme Court justices only.
A joint resolution. Okay, is there a second?
Mr. Chairman.
Sir, Senator.
Discussion.
I was just waiting for a second first.
Oh.
Second.
Okay, I will. Who was the second? Cole, Senator Cole. Okay. Discussion?
I didn't hear all of the motion, if that could be restated.
Yeah.
I move that, excuse me. LSO draft a joint resolution to repeal the Judicial Nominating Commission and add Senate confirmations for Supreme Court justices only.
So, Mr. Chairman,
Senator Hicks.
the question I have is why a joint resolution versus a bill draft? And I see staff's got their hands.
Well, we already had the proposal for the bill draft earlier.
There's a new proposal.
This is a little bit different.
This is.
Oh,
only
because
for
it's
the
limited
Supreme-
to Supreme Court.
Yes, Mr. Chairman.
Mr. Fuller.
And Mr. Chairman, my question would be just to clarify that, again, this would just be adding Senate confirmation and not fully repealing the Judicial Nominating Commission outright? Or is the intent something different from earlier? Thank you, Mr. Chairman.
Representative Lean.
Your understanding of my motion the first time was correct, to repeal the Judicial Nominating Commission and add Senate confirmations.
Okay. So there's the missing piece to that. I think if you repeal the commission, then you've got a process gap.
Mr. Fuller, may we move it to Supreme Court justices will have Senate confirmation hearings?
Okay, Mr. Fuller, does that make sense now?
Yeah, Mr. Chairman, so all we're doing is, I mean, I just want to be clear because there's a couple different ways. One way to interpret that is we're just adding Senate confirmation after, the current process for the Supreme Court justices. The other would be if we remove the Judicial Nominating Commission's role for Supreme Court justices, who selects that those justices in the first instance before confirmation.
Representative Lean.
I would like to amend my motion to say that Supreme Court justices have Senate confirmation and remove the removal of the judicial nomination.
Remove the removal.
Yeah.
All right, I think
Strike.
everyone, Senator Craigo.
Mr. Chairman, procedural question, I guess, point of clarification. So we've already debated that particular issue today. So it seems to me like we, might be more proper for a motion for reconsideration. I understand the end result is a little bit different, but we actually debated that on an amendment. So I don't know how the rules read or what Mr. Chairman, I don't know what the process is for that, for revoting on something we already voted on once today.
Mr. Fuller, what's our rule on motions for reconsideration? I think there's a time period
With the bill.
with notice.
Yeah, that's what I'm saying. So I think we can vote on this bill.
So Mr. Chairman, the way the rule reads is the motion to reconsider or to rescind actions of the committee. I think by virtue of that first motion failing, I'm not sure there was a committee action. So I'm not sure there wouldn't be anything necessarily to reconsider.
All right. LSO's interpretation is that we're not reconsidering, is a new motion. Any other discussion on this? Senator or Representative Washington?
Thank you, Mr. Co-Chairman. I guess we do away with the Judicial Nominating Commission process. The question is, how do we select who the person is who goes before the Senate for a confirmation hearing? Somehow you have to end up with a nominee who goes before the Senate, and whether that individual is selected through a Judicial Nominating Commission process, and then they go through a confirmation hearing, or whether they're simply appointed by the governor and then go through the appointment or the confirmation process. I think there's a piece of this motion, right?
Well,
Is it
Co-Chairman
clear?
Washington, I think she withdrew that portion of it. So all this motion does is create a resolution to say that Supreme Court justices should have a Senate confirmation. The rest of the process remains the same.
Excuse me, Mr.
Senator Cole?
Yeah. Oh, so it's Is this going to be a resolution,
It's a resolution.
not a bill draft?
It's a joint, her motion was for a resolution.
It would have to be a joint resolution because it's to amend the Constitution.
Oh, yeah, good point. I see what you're doing. Senator Craigo?
So just from, I guess if we are gonna actually talk about it, I guess we better take some time and talk about the consequences of, Senate confirmation and what that looks like. Does that make us a full-time Senate? Confirmation comes in, we get judge, or the governor says, here's the person I want to be Supreme Court Justice. That comes in April 1st. So does that person sit there for 11 months? 10 months before we have time to confirm them? Do we have special sessions? What are the ramifications of requiring Senate approval of all nominations? Just a question, I guess I'd like to ask the bringer of the motion. What's the solution for that?
Yeah, because the example, we're living through it right now with Attorney General Hill being appointed during the interim process.
Thank you.
Representative Lean?
So the purpose of getting the bill draft started is that we can have these conversations as we move through the interim course. That if we do nothing with it, then potentially this topic just sits to the side and does nothing. So the intent of the bill draft is that we are able to come together as a committee and work through the problems through the interim and potentially have a bill to bring forward.
Okay, any other discussion? This is just a bill draft. Well, it's a joint resolution, but all we're doing at this point is drafting. All right, I think that's it for discussion. All those in favor signify by saying aye. All those opposed?
No.
Okay, all those in favor, go ahead and raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. All those opposed? 1, 2, 3, 4, 5. All right, that motion has passed. Are there any other directives related to the topic we're on? Or any other topic apparently in the universe? Co-Chairman Washit.
It's 2:45. My concern, I think it's about a 20-minute drive out to the facility, time you clear security. I don't know that we're going to get much of a tour in before their hard break at the Department of Corrections.
What time was there? Do you know?
I think the hard break was 5.
Probably 5.
4:30. What's that? Yeah, you said they had a shift change and so forth. That was a hard break at the end of whatever time we were expected to be done. So I'm just wondering whether it's prudent for us to even drive out there.
Mr. Chairman, what was the intent? Just to tour the facility, just to get an idea?
Yeah.
Never seen one.
Yeah.
Yeah, Senator Hicks, just a tour. What do you think, committee? I don't know. I don't know because I don't know the hard stop time. I just know that there is one, but I don't know what it is. Who has Director Shannon's cell phone number?
Yep.
Oh, wow.
Volunteer in the back.
If he's allowed
We'll
to
go
take
ahead.
his cell phone inside the institution.
Sure, the director.
As a committee, we'll go ahead and recess now because either way, we're going on the tour or we're going home. So we'll go into recess.
Yeah, Mr. Chairman, I just